with this case. I do not dispute any of the facts in the charging instruments, and for the record, I do not consent to being called that name.
The record should reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is in street clothes, wearing a suit and tie and a mask.
I don't consent to being called that name, Your Honor.
I understand,
For the record.
And I have advised you previously that I will continue to refer to you at times by that name, as I believe it's appropriate given the charging instruments in this case. And other evidence now that's been received during the course of this trial where I believe we are using the accurate name. With that, I don't agree to that, Your Honor, or consent to that. Your lack of consent is noted. So before we go forward, I need to put a couple of things on the record. I know Mr. Brooks has filed some things, but before I get to that, as I told the parties on Monday, I had excused one of the jurors for a health reason, and it has come to my attention that I now have a second juror with the same health concern. Out of an abundance of caution, I am going to bring the jurors out to question them about their, whether any of them have any concern about continuing to serve on this jury, given the health concern. I am referring to a COVID concern. I'm not going to ask any particular juror whether they've tested positive or not, or whether they've had an exposure. But I am going to ask them questions about their willingness to continue serving, whether it's interfering at all with their ability to pay attention. Out of an abundance of caution, we have brought in 2 air purifiers, although I am told that because of the new building and the HVAC that's in this building, and I received this from our facilities manager, the new HVAC system in the court's tower has a UV light system that disinfects the air at a higher air exchange rate than the purifiers, and that the system was specifically designed so that no special standalone systems are needed. But again, out of an abundance of caution, we've had 2 air purifiers put in this courtroom. I'm putting a 3rd one in the jury room. We have also provided jurors, should they wish, with masks. We've increased the hand sanitizers and the disinfecting wipes. We've always had the hand sanitizers around. There's one on the jury box at the moment, and they've been in the jury room. I'd also like to put on the record that I did advise the jurors on Monday that one of the jurors was not going to be with us any longer due to a health concern. I asked them at that point if anyone had any concern. I did indicate at that point it was a possible exposure, and they all indicated no, they didn't have any concerns. But again, out of an abundance of caution, I feel it's important to now question them while they're in the jury box to ensure that there aren't any issues related to that. So with that, I am going to instruct the jurors to be brought out for that purpose. And then they'll be excused after that so we can continue the discussion regarding that, and then deal with, if need be, the other issues and filings that have been brought to my attention today.
Your Honor, will we be addressing subject matter jurisdiction?
No, not at this time.
Still has yet to be proven for the record. I don't know if the audio is on, but.
All right, for the jury.
Could you have a microphone available, please, if need be? They're behind you. I don't know if you can see it. Oh, wait, if you could bring me that. We're not gonna take testimony at the moment, and it is a preliminary issue. Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, I brought you out here. We are not taking testimony at the moment. I have made a record previously regarding COVID-related concerns with the jurors. I know you are all aware that one juror was excused due to a health concern. I also put on the record that on Monday, when I advised the jurors of that, I asked you all if anyone had a concern regarding that, and that no one indicated they had a concern. I have been made aware of a second issue and potential exposure, and so I wanted to make a record in open court and to ask each one of you if any of you have any concerns about continuing your service in this case due to exposure to COVID. And so I'm just going to go through each one. Hopefully I can see all of your numbers from here. I'll just start from the back row and move from my left to right, front row, my left to right. And I also want to let you all know we have a very, very good HVAC system. I made a record of this while you were not here. But this is a new building. It has brand new technology. I've been told that the HVAC system in the courts tower, and this was told to me by our facilities manager, has a UV light system that disinfects the air at a higher air exchange rate than purifiers, but out of an abundance of caution, and I've had 2 air purifiers also put in this courtroom, and I've had 1 put in the jury room. I believe you would be able to confirm for us as well that when you got into the jury room this morning, there were extra sanitation supplies along with masks. And so with that, I am just going to identify you by number. First of all, juror number 11. Do you have any concerns about continuing your service in this case, specifically related to COVID?
No concerns.
All right, thank you. Let me actually go back to, would the fact that you may have been exposed in any way interfere with your ability to pay attention and ultimately render a verdict in this case?
No.
All right, thank you. And then, let's see, I know our bars, like juror number 48, if you could also answer those 2 questions.
No concerns, both ways.
All right, thank you. And then juror number 46.
No concerns.
Thank you. Juror number 34.
No to both.
Thank you. Juror number 27.
No, also to both.
Thank you. Juror number 30.
No concerns to both.
Thank you. Juror number 1.
No concerns to both.
Thank you. And then what's your number?
6.
6. Juror number 6.
No concerns for both.
Thank you. And then juror number 14. I'll just start there.
No concerns to both.
Thank you. Juror number 10.
No concerns to both.
Thank you. Juror number 51.
No concerns to both.
Thank you. Juror number 45.
No concerns to both.
Thank you. Juror number 19.
No concerns to both.
Thank you. Juror number 41.
No concerns to both.
Thank you. And juror number 3.
No concerns to both.
All right, is there anything I haven't asked of the jurors or any other concerns related to that that you would want to bring to my attention? If so, just raise your hand. There are no hands raised. I can also tell you from our initial days of COVID when we started up jury trials, we do have plexiglass panels that I could put in between anyone who would want one. Is there anyone here who would want that? If so, raise your hand. No hands are raised. That's really all I have. I don't know if there's anything either of the parties would want me to ask the jurors from the state on this topic. All right, Mr. Brooks? No. All right, thank you. I'm going to excuse the jurors then, and then when we're ready, we'll have you brought back out. And thank you so much. Thank you. Be seated.
Judge, can we ask you a question?
Go ahead.
We counted 15 jurors in the courtroom.
I excused one.
You excused one earlier in the week too, though.
No. I'm only talking about the one. The other one I didn't excuse.
I see.
And,
Okay.
and thank you, I'll make a record of that. I did not excuse given when that person reported their symptoms and where we're at today. So it would be,
So that person is here
yes,
and willing to continue serving?
yes.
Okay, thank you.
Sure. And I will make a further record that none of the jurors are wearing masks. And I'm not going to mandate. I believe it's a personal choice. And that would also be consistent with, I believe, our county policies as well. So, unless there are anything related to that, I have a couple of other issues I need to address this morning. Go ahead.
The person that's, or the two people rather, that are having the COVID concerns, I know you said you wasn't gonna ask them, had they test positive or the results of any testing. Do you know if there has been exposure on their end to COVID exactly, or is that just a caution thing?
My understanding is that I've had 2 jurors test positive throughout the course of this trial.
And
I'd make a further record that they're the only ones within 6 feet of each other, right? They, and perhaps our civilian bailiffs, and they've not been in, obviously, contact with anyone in the gallery. I don't know if maybe Attorney Opper might be within 6 feet. I don't think so, but I haven't measured it. Obviously, you're not within 6 feet of any of them. But that's a good question to ask, and I'm glad you asked that, and I wanted to make a record of that as well.
yeah, that would be my question to it. I guess in reference to me myself just having the same concern a few weeks ago. So that would be the reason why I would want to know exactly any details that could be provided.
I'm providing all the details that I will. Again, for the record, you have not been exposed, from my opinion, because of the distance that you are away from them, and my understanding based upon my review of county policy.
Yeah, I'm not saying me myself have been
Understood.
exposed.
Well, that's why I asked them though too, right? I wanted to make sure they had no concerns, or if they had a concern, to see if I could accommodate it in any way. I'm satisfied that if they don't have a concern, that we can continue forward.
Have they ever, the entirety of the jury though, have they been exposed in any way?
I don't know the specifics because of the 6 foot, right, rule, and no one has asked me to investigate that further.
Wouldn't it be smart though to see?
I don't believe that's necessary under the circumstances.
Well, if anything, just for future reference, like, what if it plays a part later on?
Well, I'll certainly take your concerns under advisement, and if I believe any further questioning needs to be done, I'll do that. At this point, I don't believe it needs to be done, but I'll think about that, and I'll take it under advisement, and if I change my mind, I'll let you know.
Yeah, I'm just saying, because if anything, it probably would be smart for the long run to make sure no one else was compromised, considering that.
Let me make
Yeah.
a record there. No one has indicated they are compromised. I don't think we can make assumptions about how anyone who's been exposed or tested is feeling. You can be asymptomatic and test positive. You can have mild symptoms. I trust my jurors that they would report if they're not able to sit through the proceedings. And I will further advise them through the bailiffs that they are to report if they ever get to a point where they feel they're not able to sit through here, and and so that we're advised and I can tell the parties.
Yeah, that's what I was referring to, because it went from Monday, which at that time it wasn't known. Could have been flu, could have been just not feeling well, could have been anything, and then today is, then you kind of worry about tomorrow, Friday, over the weekend.
Mr. Brooks, I share all of those concerns, but my other concern is that we are in the third week of trial and that we should keep going until the conclusion of this matter, understanding what has happened.
All right, I just wanted to put that on the record because
I appreciate
it
that.
seemed like the circumstances were different when it was me. Just saying.
Are you making any specific requests given this information?
Well, I believe that the jury clearly all congregate together. I think it would be smart to make sure everybody is tested. I mean, that's it would be smart to do that.
I'm not going to mandate testing for the jurors. That much I can tell you. So that request is denied.
And the grounds for the denial?
I'm not going to mandate that the jurors be subjected to testing. They're the ones who indicated they are comfortable being here. They don't have concerns. And again, I would trust them to report to me if anything changes.
I would trust that too, but it still would refer back to Monday when the first knowledge of someone having an illness or a potential illness was those same questions that were asked today, asked Monday. And
I did
I'm
not.
quite sure.
I certainly questioned them much more for, it was a very brief, I put what I said to them on the record earlier. It was certainly not what we did here today, and the record reflects that.
Right. I'm quite sure though that all the jurors Monday said they didn't have any concerns as well. And then now today, someone else, same thing being said. So
I understand what you're
if it
saying.
happens again, same thing being said,
But are you making any specific requests as it relates to this topic and this issue?
well, you denied the request that
Any other requests?
I just feel like it's smart for them to be tested. So it doesn't come up again in the future, or potentially come up again in the future, because then we'll all be looking back and saying, well, we could have prevented something like this from happening if we had just nipped it in the bud from the get-go. It's just smart to, like you say, err on the side of caution.
I appreciate that. I'm going to continue. I understand what you're saying, but given the responses of the jurors today, I'm going to continue. I'm going to base this off of their desire to continue, at least what I would interpret as their desire to continue with their service on this case. All right, then I want to talk briefly about the jury view. I did provide the parties with a proposed instruction. Before I get to that, though, Mr. Brooks, I have been thinking about your request yesterday. And I know I indicated to you that I would require you to be there. I've rethought that. I've had the overnight to really think about it. And if that is your decision to not be present for that, what I would say is this. I want you to be advised that you have a right to be at that jury view. Did you hear me say that?
Yeah, I mean, you pretty much told me yesterday about, everything that was going on. I didn't agree to or consent to it being, well, I was still confused about why did there even need to be a jury view. That was my whole thing. I don't see the relevancy of it. And I also didn't agree with or consent to having to be part of something that I don't see as relevant.
I appreciate you making a record of that, but did you hear what I said, that you have a right to be present for it? I've ruled that let me back up. There's been a request from the state to have the jury look at the vehicle that was recovered by the police and, of course, is alleged to be the vehicle that was driven through the parade. Did you hear me advise you of that?
Yes, I heard.
All right, so that motion was addressed previously, and I granted the request for that jury view. Did you hear me say that?
I'm informed.
All right, thank you. So with that, you have a right to be present at that jury view. Did you hear me say that?
I'm informed.
And I would like you to be there. I believe it is a piece of evidence. That's why I've drafted jury instruction 152 the way that I did. Did you hear me say that?
I'm informed.
So my question to you then this morning is, do you want to be present at the jury view of the vehicle?
I don't see the reason why I would need to be present.
Well, that's my question to you though, is do you want to be present for it? You are the accused in this case. You're the person who the state has alleged committed these acts. The jury view will be to view a piece of evidence that frankly can't come into the courtroom due to its size, and the jury's going to be shown that. So do you want to be present at that?
For the record, I'm not a person, I'm a human being. And no, I do not consent to or agree to being present at a jury view.
All right, then I'm going to honor his request, but what I am going to do though is, as part of that process in any event, because it's being done in a secure location, is I have ordered that I want to make a record of what's being done, and I want a visual record of what is being done. And so this jury view is going to take place in the sally port of the jail. And precautions are being taken so that the jurors do not know where it's at. It'll look like a garage, right? Anything that says jail within the sally port is being covered up. That will be verified before anyone is taken in there. They will be transported to there. I'm not sure if they'll walk or drive because it's very close. But then the sheriff's department, because as the court official, I'm in charge of keeping the record, not keeping the record, I'm in charge of making the record. It's the better way to say it. And I want to make sure that there's a record of what is done for this trial and certainly for any appellate purposes if need be. The sheriff's department, the sheriff's department is obviously charged with the security and safety of a courtroom, including the jurors. And so I have asked the sheriff's department to record. And so there is a camera that will be on a tripod that will record what's there before anyone gets there. I've instructed them to take that camera to walk around the vehicle and while it's recording, to put it back on the tripod. And before the jurors and the court are brought in, once we are brought in, it will also be recorded, and that contemporaneous recording, so that will be as we will walk around the vehicle one time. That will be recorded, and then both of those recordings are going to be made part of the record. Because the second recording is for the record and has the jurors, at this point I'm going to seal it so that at least until the conclusion of the case, given the order that I have regarding the what's referenced as an anonymous or numbered jury, so that will be sealed. But what will be released to the public or be made part of the public record, and so therefore any media request, would be that recording that just shows the vehicle without the jurors in it and without the court. So, and then I plan on also bringing that back to the courtroom while the sheriff's department's going to bring it back, and then we'll show it to you at that time.
I have a question though.
Go ahead.
If I have a right to be present, then I have a right to not be present. How can this take place if I don't agree or consent to being present? How can it even still take place without me?
It will take place, sir. I'm just going to honor your request not to be there.
I'm asking a question though. How can it take place without my consent or agreement?
If you don't, it's going to take place. That's how I'm going to answer that, sir. So you not going there is not going to prevent it from happening.
My Lord,
But you can forfeit your right to
I
be
didn't-
there
I
by your
didn't-
conduct. And by
I
your
didn't-
conduct, by not answering my question, by saying I don't want to be there and I don't consent to it, you will be forfeiting your right to be present and essentially waiving that.
Doesn't I have to sign something for it to be waived?
I don't think so in this case.
Well, yesterday you said something about
I know I said that, and I've
Yeah.
had some time to think about that further, I don't believe I need to take a full waiver with you signing anything or even agreeing to the waiver.
so why did I have to do that for when my
I'm not going to answer those questions because that
Well,
would
we-
be for me to give you an explanation of the law.
no?
I'm
it
just
would
going to
be-
tell you that I'm not going to require a written waiver from you in order to honor your request to not be at or even if I phrase it, your lack of consent to the jury view.
And is that lawful law? Because
Sir, I'm not
The
going to
way-
go through all the law that applies to that.
way
This is
I-
my ruling. If you disagree with it and ultimately there is a conviction, you can raise that on appeal. But
No,
your lack
Your
of
Honor.
consent is not going to stop the jury view. It's going to happen. It's a piece of evidence that I cannot physically fit in this courtroom. It's too big. There's no way to get it in.
okay, I'm informed of that, but at the same time, if I haven't signed any waiver, how could it be lawful? I haven't given consent or agreement to a jury view. I haven't waived any right. When the whole issue was brought up, on the record yesterday, my first thing that I said was, I don't see the relevancy of why there should even be a jury view. And that was the whole issue. And yesterday I was told about I don't know how you say it, the colloquy or however you say it. I don't know how to pronounce it.
I know
Which
what
was-
I said, and
Yeah.
I'm telling you, I had time to reflect. That was my initial reaction to your statement yesterday, but I've thought about it some more, and I'm changing my mind. I don't believe I need to take a full waiver with a colloquy with you and anything in writing. I'm advising you, you have the absolute right to be there. But I'm also advising you that if you choose not to be there, I will honor that request. And I'm not
Your
going to
Honor, the way-
force you. I'm not going to direct the sheriff's department to, use any type of force, if you will, or require you or get you there without your consent. You either cooperate with that process or you don't.
The way I interpret the law, though, Your Honor, which the law is designed to be interpreted by the people. The way I interpret that is I have the right or essentially to be there or not to be there, and it still has to be an agreement or consent. That's how I interpret the law.
My ruling on that, sir, is I disagree with you. You do not need to provide consent for the jury view to happen. Your objection is noted for the record. I'll make a specific finding today that it is relevant to these proceedings, to this trial. There is an allegation that you drove through the Waukesha Christmas Parade on November 21 of 2021, driving a red Ford Escape, killing 6 and injuring dozens more. The relevance is that there is, in addition to the charges, there's an enhancer that has been charged as it relates to the intentional homicide charges and the first-degree recklessly endangering safety, that you committed those acts while using a dangerous weapon. I would direct your attention to the meaning of a dangerous weapon, that the legal definition that was provided to the jurors in the preliminary jury instructions, and that the jury view is related to the evidence that the state is presenting regarding the charges, and specifically the instrumentality that they allege is the dangerous weapon. So there's clear relevance of this vehicle and has evidentiary value. Again, your objection is noted for the record, but I will and am permitting the jury view of the vehicle. With that, I'm going to move on to the jury instruction.
I don't agree or consent to that, Your Honor.
I understand your
If I'm not-
objection is well noted for the record. I need to keep going though on the pattern and
I'm
jury.
informed that you need to
pattern-
keep going. I'm not trying to stop you from continuing to go. I'm merely stating for the record that there are things I do not understand how they're being permitted versus the Constitution. I mean, I'm sure you're aware under Article 6, Chapter 2 about the Supremacy Clause, that the Constitution is the supreme law of the land. So how can we disregard?
Mr. Brooks, I'm not disregarding the Constitution. Here's the thing, I've made my ruling, okay? Once I've made a ruling, I do expect that even if you disagree with it, you will not continue to argue it.
It's not
That
arguing.
we will continue on with the next
I'm seeking to
topic.
understand, Your Honor. It's not an argument.
Mr. Brooks, I'm not going to explain further other than what I have done, my ruling. My ruling stands. Now, I'm gonna move on to the jury instruction. I gave the parties
May I
2
respectfully
documents.
reject that ruling and take exception to that ruling?
Your objection is noted. I'm
For the
moving on
record, may I
to jury.
request a legal
to-
and factual basis for your
Mr.
ruling,
Brooks,
Your
please
Honor?
don't interrupt me, okay? I give you an opportunity to raise your objections and to make your legal arguments.
raising
And then I make a
objection now.
ruling, and then you start in on something else. You need to give me your argument all at once. For you to interrupt me afterward is disruptive to me.
It's not
And
disruptive.
it's interrupting and it's disruptive.
It is definitely not
Well,
disruptive.
if that's my view of things, sir, and what I'm putting on the record is that it does disrupt what I'm doing and the flow of what I'm doing and needing to move on, having to interrupt what I'm doing so that I can address that once again. Please, please. I know you may not always agree with my rulings, but I'd ask that you show the courtesy and decorum that is expected of everyone. And once I make a ruling, we're going to move on. You don't need to keep objecting because your objection's already been noted for the record. I'm going to continue. We're going to look at jury instruction 152.
Well,
I gave the parties 2 documents yesterday. One was the pattern instruction, which I've modified, and then one is the draft of, and Mr. Brooks, please stop. You're continuing to talk over me.
Because
You're interrupting.
You said I have the right to object, and you didn't let me even get to the objection.
I did, sir.
No, you
okay?
didn't. I was right in
Your
the middle of
objection
it.
comes before the ruling, not after. Once I make a ruling, we're moving on.
You made a ruling before we even finished the conversation, Your Honor. With all due respect,
Brooks,
before
please
we
stop.
even finished,
That's not true. Okay?
you
It's
said
not
I'm going to
true.
make a ruling. As soon as you even started in about
Mr. Brooks, I'm not
having
going
the
to
time
spend
think.
hours on end making a ruling about a jury view on something I've already decided. All right, so please, I'm asking
Well-
you to stop. Stop
No, this-
interrupting me.
You can't,
And please
just
listen.
disregard the United States Constitution, which has a
I
supremacy
absolutely am
clause.
not disregarding the
You are.
United States
You're
Constitution
not
or the
honoring your oath
Constitution of
office.
the state
Your
of
Honor,
Wisconsin.
are you not a public servant?
Okay, Mr. Brooks, you're starting to cross the line. You've already crossed it, but I want to keep going. I want
didn't
you in
cross
this
any line.
courtroom. But if you keep interrupting me and putting you on notice that you run the risk of being forfeiting your right to be present in this courtroom and continuing in the next courtroom so that I can effectively and without interruption continue with the proceedings this
So
morning.
again, you're holding me in contempt.
All right, jury instruction 152, has the state had an opportunity to review it?
Is that a judicial determination that I'm being held in contempt?
And I agree generally with the court's proposed instruction. I did submit kind of a counter-proposed instruction following much of the language that you had in your version, Your Honor. I just think it's maybe better to refer to this area as a garage instead of a sally port. I don't know that anybody knows what a sally port is unless they work in this industry. And instead of referring it as being in the Waukesha County Jail, I just suggested a garage attached to the Waukesha County Courthouse. I think that is factually accurate and would dispel any concerns about anybody being in custody or reference to a jail setting. I did email my proposed instruction to your clerk and I e-filed it, but I admittedly just did that a few minutes ago. So that's why I emailed it to the clerk, because it's probably not in your queue yet.
All right, why don't we print that off so that Mr. Brooks can review that as well?
Seem to being called that name. What do I need to be reviewing?
The state has submitted an alternate proposal for instruction 152.
And that's referring to this quote-unquote jury view?
Yes. Thank you.
I accept for value in return for value this document. And I would like the record to reflect I still haven't received my original copies of my filings here this morning with the timestamp.
Let me know when you've had an opportunity to review it if you so choose.
I just stated for the record, I accept for value in return for value the document.
Do you have any position on this state's proposal?
I'm still trying to understand the whole process.
Mr. Brooks, my question to you is, do you have any position on the state's proposed jury instruction? Otherwise, I'm going to rule on their request.
You're gonna rule on the request anyway. I got a lot of questions that don't get answered.
I have to rule on the request, sir. It's been a proposal filed with the court.
You haven't ruled on subject matter jurisdiction yet.
Yes, I have.
No, you
In
haven't.
any event, do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction?
One last time, Mr. Brooks, do you have a position on
Can
the
I
state's
go over the
proposed?
document, please? Can I do that, Your Honor? Respectfully
sorry?
for the record, may I do that? You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes?
Reference
It's
to
the same.
the-
It's the same document. That was
Reference
was
to
accepted for value,
the-
return for value yesterday. The same document.
It's not the same. The changes were put on the record verbally by the state. It's taking out reference to Sallyport of the Waukesha County Jail, referring to it simply as a garage attached to the Waukesha County Courthouse. Those would be in the first two paragraphs. I believe the rest is the same.
So it was a couple words changed.
That's my understanding.
So it's the same document.
Let me know when you're finished reviewing it and
I
I'll
don't
question.
have to review the same document that was reviewed yesterday, accepted for value and return for value yesterday.
All right, then let me ask you this, sir. Do you have a position on the proposed instruction from the state?
It's essentially the same document. What was the significance of the change? What's the significance? Garage, Sallyport. What is the relevancy of what it's called?
State want to put on the record again the basis for the changes you made.
Your Honor, to my way of thinking, it is beneficial to the defendant. It removes any reference to Sallyport, which some may recognize as being part of the Waukesha County Jail. It removes reference to the jail itself. And then in the second sentence, the pattern instruction was worded, and the court followed it. You will be taken to the Sallyport in the custody of the jury bailiffs. I just thought it was better to change that. You will be taken to the garage by the jury bailiffs. Again, removing the use of the word custody it's factually true, but it's really irrelevant. Just to be cautious, Your Honor.
With that, sir, do you have any?
I don't
Position.
fundamentally understand that. I think everyone's well aware that I'm in custody, so how does the wording change what's already known? Everybody knows that I'm housed in the Waukesha County Jail. How does the wording change what's already known? It's reported on every single day, as it has been since the beginning of trial and even before that. So I don't think anyone's not privy to the knowledge of where I'm housed and that I'm in custody. How does changing the wording change what's already known?
Thank you. From my perspective, of course, when I drafted this yesterday, factually, what I put in there would be accurate because that's where the jury view is going to take place. I think changing the verbiage so that it says a garage attached to the Waukesha County Courthouse takes away any possibility that other law enforcement is condoning what is happening or somehow related to the case. It is true the location was selected due to your custodial status and being able to secure the area for the court, for you, for the jurors, etc. But it's also a controlled environment, I think, a good thing for purposes of the jury view. And so I am going to adopt the draft that was submitted by the state. It still is factually accurate. And from my perspective, again, the importance of this instruction is to tell them what is and what is not evidence, and to instruct them and to not talk during this time. They can't discuss what they see during this time. This instruction will be read while we are still in the courtroom prior to the parties in the court going to the Sally Port for that viewing, and I've already discussed how it will be contemporaneously recorded so that it's part of the record as well.
So if I was there, where will I be at?
My understanding, if you choose to be there, is you will be escorted like you are in court here now. The bailiffs would be with you. You'd be in your suit.
No, where will I be at?
You would. I don't know exactly. That's up to the sheriff's department as to where all the parties are going to stand. Obviously, you would. We're not going to commingle you with the state or the state with jurors or you with the jurors or the court or anything like that. My understanding is we'll have sort of assigned places and that it's only myself who will walk around. And I may not even do that. I have to think about that. But the jurors are the ones who are going to walk around the vehicle one time.
So I don't get to walk around the vehicle?
I can have you do that before the jurors come in. I certainly can have you do that if you would like. I can give the parties that opportunity.
And may I add something else, Your Honor? I agree with everything the court said. I also think Mr. Brooks should understand that it will be a fair process. He's not going to be led into the room in shackles in front of the jury. It's my understanding from Captain Dussault, the attorneys for the state, the prosecution team will be in the room. Mr. Brooks will be in the room. We will be in our assigned location. It will be fair. It will match. There will be basically no distinction between how Mr. Brooks appears to the jury versus how we appear to the jury. We will be in there first. If the court's willing to allow him to walk around the car one time to look at it, we have no objection to that. And then the jurors will come in. No one will speak. They will do one lap around the car. They will leave the room, and then the parties will leave the room. That's my understanding, Your Honor.
And I will add to that, because it's been a while since I had some preliminary discussions with the Sheriff's Department on this, that if however many bailiffs, sheriff's deputies are with you, I want the same number with the state, right? And that's what we mean by it will look no different. So each party will be accompanied by deputies.
I have a question to that.
Okay.
How come none of that knowledge of how it would be conducted was discussed with me? I didn't know anything about how the bailiffs would actually do things, how certain things would go. This is my first time hearing this.
Well, we have
So
preliminary.
I don't understand it.
We had preliminary discussions at the time of the request back in August, when you still were represented by counsel. And then I had some additional preliminary discussions, if you will, internally with court staff, which included Captain Dussault and someone from the jail to talk about it and the logistics of it. And then, of course, we're having the discussion now, which is, again, why there's no jury here now. I wanted to wait until the appropriate time and then make a record of everything.
But don't you
At no
think-
time did I have conversations independently with the state.
Don't
They
you-
had filed a letter at one point because they themselves had, again, my understanding, and Attorney Opera can correct me if I'm wrong, had some discussions with, to see if it was feasible. They had some discussions with Captain Dussault. And Captain Dussault is with the Waukesha County Sheriff's Department. Of course, the Waukesha County Sheriff's Department and the sheriff is statutorily responsible for the security of the campus, security of the courtroom. And so that would be the proper person for any party to have discussions about a piece of evidence such as this. But I did not have any discussions with the state myself. That only happened in the setting of a courtroom or when a letter was received and I reviewed it.
I haven't reviewed that letter or seen it. Don't you think that?
It was specifically addressed at the jury status hearing, at which time he was represented by Attorney Perry and Attorney Keys. It is on file, and it was addressed by this court, many of these details, Your Honor.
All right.
Many of the same
So-
details that's being discussed right now at this moment?
All right, Mr. Brooks, do you have a request as it relates to any of that?
Well, yeah, I'm still trying to understand the whole, how this is all working. And then it was a reference to how the shackles would look, or how being shackled or not being shackled. I'm guessing that I can't just walk around freely with bailiffs. I'm sure there would be some type of shackles.
I will tell them you are not to be shackled visibly for the jury to see.
And what do you mean by visibly,
And-
Your Honor?
So, obviously, when you sit in court, you're shackled to a table. They can't see that. I'm not going to have you in belly chains or in leg shackles. You're just going to be escorted. And it will be up to them how they determine.
Well, he may be in leg shackles, Your Honor, if there's a table or some way that they can keep that out of the view of the jury. Just like he is in court. He's shackled in court. He has been for 3 weeks.
Actually, these are
The security has to be left at the discretion of the sheriff's department.
Actually,
Yeah,
these
exactly.
are leg shock devices, not shackles.
Sir, the security is up to the sheriff's department. I should be careful not to overstep my bounds on that. And, you know, whatever is done, it should not be viewable or visible to the jury.
And why is that, Your Honor? I don't understand that part. Why is the jury not privileged to see
That is to your benefit.
shock?
I'm not going to explain that any further.
I don't understand. I'm just seeking to understand. I don't know.
All right, I need to move on. So unless there's a specific request, other than a statement that
Yeah.
you're making about your lack of understanding, I need to move on with the other
There
topics
is
I
a
need to
specific
cover.
request. Why do I have to have ankle shocks on my ankles to appear at this jury view thing?
I guess I'm not aware of what you're talking about. So were you advised by the sheriff's department that that would be the case?
Well, the DA just said that I would have the ankle shocks on.
No, shackles, she said.
No, these are not shackles. They're a shock device.
Judge, I think perhaps we can move on. I think maybe because this is going to have to occur on a break, the bailiffs can take him down there if Captain Dussault is willing, show him what it's going to be like, show him how he's going to get there, and he can decide at that point if he wants to be there or not when the jury comes in the room. We're spending a lot of time talking about security and things that are frankly beyond your knowledge and my knowledge.
I object to that. I'm simply trying to understand, why do I need ankle shocks?
I'm going to leave the security. I'm not going to make any specific orders. I'm going to backtrack a little bit. I will leave the security of the jury view to the Waukesha County Sheriff's Department. That is their responsibility. And I trust that they will do what needs to be done to maintain the security, no different than what they do here. And in their discretion will determine how best that takes place. And if I need to address anything after that or at that point in time, then it should be brought to my attention, but we are gonna move on this morning.
So I should discuss that with the sheriff?
Yes. So I know, Mr. Brooks, you filed with the court 2 documents. I'm gonna take them under advisement.
No,
I'm
it's
not
one
going
document.
to-
It's one. It was 2 papers, but it's one document.
Oh, all right, thank you for that clarification. It's 1 filing, 2 papers, just front side, entitled Alleged Defendant Jurisdictional Challenge and Mandatory Judicial Notice by Affidavit. It references the case caption, the case number. I will simply take it under advisement, and I'll review it later, and if I believe it needs to further be addressed, I will do that. But it's my understanding, sir, that you are requesting the original back. Is that true?
Yes.
So normally, just so you know, when documents are filed with the court, we maintain the original until it's scanned in and it's audited, and then, because under the statute, once it's e-filed or into the electronic filing system and the electronic case, I believe we just destroy the documents at that point. So I don't have an issue giving you back the original, but it needs to run the normal course. My clerk needs to scan it in. I've advised you of this previously, but in the courtroom, we don't have the time stamp. We just have the date stamp. I will state for the record that you provided this. It was right away at the beginning of the morning, so at 8:30 a.m. is when it was filed with the court, so that will be on the record. And then at some point today, when we're on a break, my clerk can scan it in and then provide the original back to you, and then I'll have the electronic copy to review and address as I deem appropriate. Here you go, Madam Clerk.
I want to say to that too, in reference to that, I actually said on record numerous times that I wanted the original copies of all my filings. I've actually said that 3 times on the record. This would be the 4th time. Every
As a
filing
courtesy,
that
I'm going to give it back to you, sir, but I'm not required to by law.
Well, I'm just saying on record that I've asked for that numerous times.
Your statement's noted for the record. All right.
So would I be
believe I've
able to
covered-
get all the original copies of all my filings?
I'm not going to address that any further, sir, because I am not the official keeper of the record. As to what was filed this morning, as a courtesy, we will provide you back with the original once it's scanned and it's in my electronic file.
I was told that you make the decision if I can get the original copy.
And I just made a determination you could have the original back of this
Can
one.
I have the originals for all my filings?
I'm not going to address that right now, sir. I don't have time, frankly, to look through everything that you filed to determine whether we've given you originals or not. In the future,
I
you may-
have the copies. I don't have the originals.
All right, I'm going to move on,
I have
sir.
them here.
This is taking up valuable time with the jury. We need to keep going.
Is that a judicial determination, Your Honor, that I can't get an answer to
I don't
something?
believe there's any other preliminary issues we need to address unless the parties have anything from the state.
Just very briefly, Your Honor, to advise the court, I have 4 witnesses here that I believe are very brief records custodian type witnesses on some video evidence. I'm hoping my direct should take 5 to 10 minutes for each of them. And then I have 2 police officers who will be testifying. There will be some physical evidence involved when those officers testify. And Detective Casey went to retrieve it and he will bring it to the courtroom. When that moment comes, do you want me to have Detective Reglan take the exhibits to the witness stand, or what is the court's direction on that?
I would like you to provide it to the Sheriff's Department bailiff who's in the courtroom, my bailiff, who will then take it to the witness stand.
Okay, Deputy Bordeaux and, yes, okay, I understand. Thank you.
All right, thank you for the roadmap for today, if you will. Anything preliminary other than the filing, sir, and other than the topics we've discussed this morning?
Yeah, I'm still wondering when I'll get the copies back for the ICFs that I filed.
I can't answer that, I don't have those, sir. You'll have to reach out to Clerk of Court Monica Paz.
Well, what happened to them?
I don't know. They're not part of the record. So you'll
They
have to
should
take
be.
that up with her by an inmate communication form and ask her for those, but I'm not gonna address that any further on the record. All right, let's
should
bring the
be.
jury up.
It's kind of funny that they disappeared. No,
That
ICF
assumes a
disappeared
fact,
before.
Not an evidence, sir, so.
They haven't disappeared before. I've always got copies. What's the difference now?
All rise for the jury.
We need to make a record.
So I have to readdress her the same thing in order to get copies that I've always been getting since the beginning of you telling me to file ICF.
Sir, as a courtesy, if you want to make a list of whatever documents you believe you have not been provided copies with, I will, as a courtesy, instruct my clerk, Teresa. They're not going to be dates or timestamps other than what's in the file. They'll be from the electronic file, but you need to provide her with a list, and then I will do that as a courtesy to you. But I'm not required to do that. But as a courtesy, I will do that. And as far as any ICFs, if they weren't directed to me, then you will have to follow up with Clerk of Court Monica Paz. I don't have them. They're not part of the file.
Then why were you getting them before?
You'll have to ask her that.
I have to ask her why you were getting them before?
My understanding is they were forwarded to me, sir, but
So what happened to this one being forwarded to you?
sir, I can't answer that. I can't answer what I don't know. So
It
the
seems
jury's
like you're
coming
trying
in.
to
We're
avoid
gonna
it. That's
we're
what it
gonna
seems
continue
like.
with the trial. So thank
Just
you.
like you've avoided subject matter jurisdiction. You haven't proven that on the record.
Thank you, everyone. Please be seated. And thank you for your patience this morning as the court addressed some legal issues with the parties. All right, if the state would, please call their next witness.
Thank you, Judge. The state calls Steve Schloman.
Good morning, Mr. Schulman. If you would please make your way to the witness stand, which is up one riser to my right. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. Just give me 1 second. All right, go ahead. If you would please state your first and last names for the record and then spell each.
Stephen Schloman, Steven Schlomann.
Thank you. Go ahead, your witness.
Thank you. Good morning, Mr. Schloman.
Morning.
Sir, what is your job title?
I'm the IT director at Waukesha School District.
And are you aware as to whether or not the school district maintains security cameras at the buildings on the school district property?
Yes, we do.
Overruled. It's foundational. The witness may answer.
I'm sorry.
Yes, we do.
Okay. And specifically, is there school district property located at the address of 222 Maple Street or Avenue in the city of Waukesha?
Yes.
What?
Overruled. It's foundational. The state or the witness may answer. I believe you did, and your answer will stand. If there is an objection, sir, wait until I rule on it before you answer it. Thank you. Go ahead.
What building is that location, sir?
That is our district office.
And is there more than one security camera on that building?
Overruled. The witness may answer.
Yes.
How many are there, sir?
Overruled. The witness may answer.
I'm not exactly sure, but I believe there's about 8.
Okay. Directing your attention to the days following November 21 of 2021, were you contacted by the Waukesha Police Department for any reason?
Yes, I was.
For what reason?
They asked me to look at my external security camera footage to see if I saw anything unusual on it.
And that would be specific to the building at 222 Maple Avenue?
That's correct.
Overruled, the answer may stand.
I'm going to show you an item that's been marked as, well, let me ask you one other foundational question. Do your security cameras record the activity?
Yes, they are recorded on a digital video recording system.
And can be viewed later?
That's correct.
Okay. So when the police came to you in the days following November 21 of 21, did they ask you to check a certain day and time on the video recording for the building at 222 Maple?
Objection, second to.
Overruled, the witness may answer.
Yes, they asked me to look at Sunday. Well, this was Monday when they contacted me, and they asked me to look at Sunday at approximately 4:30 p.m. in that range.
Okay. And did you do that, sir?
Yes, I did.
And did you view any video that you thought may be helpful to the police?
Yes.
Did you turn those recordings over to the police?
Yes, I did.
Had you changed or altered the content of the recording in any way?
Objection, leading.
Overruled, the witness may answer.
No, I have not edited it or changed it in any way.
Okay. Now I'm going to show you first an item that's been marked as Exhibit 157. And for the record, Your Honor, I'm just laying the foundation with these videos with this witness. I do not intend to display them at this time.
Will there be more than one?
With this witness has two,
And that would be Exhibit 157 and,
158.
all right, thank you, go ahead.
So is there an image on the screen in front of you, sir?
Yes.
Okay. Do you recognize what we're seeing there, sir?
Yes.
Could you please tell us what is shown on the front screen of Exhibit 157?
Objection, leading.
Overruled, the witness may answer.
This is the side of our Lindholm Administration Building at 222 Maple.
Okay. Do you need to see the, like 5 or 10 seconds played, or are you confident that's what we're looking at here?
I'm confident that's what we're looking at.
All right. Do you believe the video contained in Exhibit 157 will be a true and accurate depiction of the events from this location on November 21 of 21?
Objection, speculative.
Do you want him to see the video first? Why don't you show him the video first?
Well, the video's 20 minutes long, Your Honor.
Oh, all right.
Or I'm sorry, 11 minutes long. But I think he's made the adequate foundation, Your Honor, that he's confident where this camera is and what it shows.
All right, with that, the objection's overruled, and I'll receive Exhibit 157.
Thank you. Now I'm going to display for the witness only Exhibit 158. Do you recognize what is shown in Exhibit 158?
Yes.
Please describe it.
Objection, leading.
Overruled, the witness may answer.
This is our rear parking lot at the Lindholm Administration Building.
At that same address?
222 Maple, yes, that's
Okay.
correct.
Is this a second camera?
Objection, leading.
Correct.
Overruled, the witness may answer.
Correct, this is a second camera.
And does this appear to be one of the video clips that you also provided to the Waukesha Police upon their request?
Yes.
And for the record, again, Your Honor, this entire video is 11 minutes in duration. Based on the testimony of the witness, I do not intend to play any of it at this time, but I would move to admit 158.
Objection. It's not intended to play. What's the relevancy?
The objection is noted, it's overruled, and Exhibit 158 is received.
Thank you. I don't have any other questions, sir.
All right, thank you. Go ahead, sir. Do you have any questions for this witness?
Brief. Before today, sir, well, first of all, good morning.
Good morning.
Before today, had you seen these exhibits or videos, rather, 157 and 158?
I've seen this video when I collected it off our system.
And do you recall seeing the first one?
Yes, I do.
Do you recall when you saw those videos?
I saw those Monday morning when detectives came and asked me to review video footage.
And do you recall the name of the detective that you reviewed the footage with?
I do not recall the name of the detective, no.
And after that, after initially viewing these videos, did you follow up with law enforcement after that?
Yes, I did.
And it would be fair to assume that that was strictly about the videos.
Correct.
And had you obtained any knowledge outside of what was shown in the videos?
I'm not sure I understand the question.
Had you obtained any knowledge to why you were asked to provide those videos at that time?
No, I was just asked to look at my videos and see if I saw anything unusual, any unusual activity in the parking lot.
And do you recall being informed that it was a possibility that you would be testifying in this matter?
No, I did not know that.
Were you subpoenaed at any time?
Yes, I was.
And do you recall about how long ago you received that subpoena?
Several weeks ago.
So pretty recent, would be fair to say.
Yes, I would, well, several weeks ago. I'm not sure if that's your definition of recent or not, but
Do you recall who served you the subpoena?
Objection relevant.
Grounds.
Overruled, the witness may answer.
the district attorney's office from Waukesha.
Do you recall if it was a specific district attorney?
I do not recall.
Do you recall if you were contacted by the plaintiff in this matter?
Objection.
Grounds.
Vague.
Sustained as to the form of the question.
Do you recall having a conversation with the plaintiff?
Objection.
Grounds.
Misleading, legally inaccurate statement here.
Grounds.
Sustained as to the form of the question.
Do you recall having a phone conversation with the plaintiff in these?
Same objection.
Grounds.
Sustained as to the form of the question.
Do you yourself recall reaching out to the plaintiff in this matter?
I'm not sure who the plaintiff is. Can you define that for me?
The plaintiff would be who's bringing the claim.
Your Honor, I object. Well, I realize there's no question at this point, but if he's going to ask the witness to answer his prior question, now that he's clarified, this is irrelevant questioning.
I'll see what his question is first.
I asked it.
Please ask your question again, so that I'm clear.
Have you yourself ever reached out to the plaintiff in this matter?
And my objection is it's vague, and it's legally inaccurate.
Sustained as to the form of the question.
Do you even know if there's a plaintiff in this matter?
Objection
Grounds.
argumentative.
Sustained as to the form of the question.
Have you yourself filed any complaint in this matter?
Objection
Grounds.
irrelevant.
Overruled, the witness may answer, sorry.
I have not, no.
Do you know of anyone who filed a claim in this matter?
Objection
Grounds.
irrelevant.
Overruled, the witness may answer.
I do not.
And do you recall when you submitted the videos to law enforcement?
I submitted them on Monday afternoon.
And do you recall what method you submitted it in?
The detectives came to my office and they viewed the video on my system directly, and then they asked me to put it on a flash drive, so I downloaded it on a flash drive, exported it to a flash drive, and then they took it.
No further questions?
Thank you, Mr. Brooks. Any redirect?
No, Your Honor, I'd ask Mr. Schloman be excused.
All right, thank you, sir. You may step down. And he is excused.
State will call Robert Stone.
All right, good morning, Mr. Stone. If you would please make your way to the witness stand, which is up by me, to my right, up one riser. When you get there, please remain standing, raise your right hand. My clerk, Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. The first thing I will have you do is to state your first and last names for the record and spell each.
First name is Robert, R-O-B-E-R-T. Last name Stone, S-T-O-N-E. 2 capital I's on this end because I'm the second.
Very good. Thank you. Go ahead, your witness.
Good morning, Mr. Stone.
Good morning.
Sir, on the date of November 21, 2021, where did you live?
I reside at 424 Dunbar Avenue in Waukesha.
Do you have any security cameras at your home, sir?
I do.
And do the security cameras have a way to record or save events that are captured on the camera?
They do.
Objection leading.
Overruled foundational, the witness may answer, and just so you know, sir, if there is an objection, wait to answer the question until I rule on the objection. Thank you. Go ahead.
To your knowledge, sir, was your security camera system operational on November 21 of 2021?
Objection
Yes.
speculative.
Overruled, the witness may answer, and he did his answer.
Was there a time where you turned over video from that security system to Waukesha Police sometime around November 21 of 2021?
Objection leading.
Overruled, the witness may answer.
Yes.
What kind of security camera do you have, sir?
Objection leading.
Overruled, you may answer, sir.
It's just a generic NVR system.
Okay. And police came to your house? Is that right?
They did.
Okay. What did you give them?
They came to my house, and my mother-in-law had answered, and they had asked about the security cameras, and she told them that it was her son-in-law's. And then I retrieved the footage and turned it into the police department.
Before you turned it into the officers, did you alter the content of the video in any way, sir?
Objection
Absolutely not.
speculative.
Overruled, please wait, sir. Overruled, the witness may answer.
Absolutely not.
I'm going to have Exhibit 155 displayed on the screen in front of you, sir. And this clip is 40 seconds long, so I'm going to play it for the witness only, in full, at regular speed.
Go ahead.
That's not regular speed, Your Honor.
Please wait for cross. We'll have the state question the witness about that, though.
All right, if you could start it at the 00 again, just put up that. Sir, did you see that 40-second clip that was just displayed?
I did.
Do you believe that's a true and accurate capture of the events at your residence on November 21 of 21?
Objection speculative.
Overruled, you may answer.
It is.
I notice in the upper right-hand corner of the video, there appears to be a date and time stamp. Do you see that?
Yes.
Objection relevancy.
Do you believe,
Well, hold on. Overruled, the witness may answer.
Yes.
do you believe that date and time stamp was accurate?
It is, but it's off by the daylight savings time.
Okay.
So
So it reads, what does it read
it's currently reading 4:59.
for the time of day?
Correct.
AM or PM?
PM.
Okay. What do you recall the real day and time to be?
Objection leading.
Overruled, the witness may answer.
Would have been an hour earlier.
Okay. And do you recognize the scene that's shown here, sir?
Yes.
What are we seeing here?
My garage and my vehicles and my backyard.
All right. Move to admit 155, Your Honor.
Objection relevancy.
Overruled, the objection is noted, but Exhibit 155 is received. And I'm
No.
sorry, did you ask to publish?
No.
Okay, thank
No
you.
further questions at this time, Your Honor.
All right, very well. Sir, do you have any questions for this witness?
Yes.
Go ahead.
Good morning, Mr. Stone. Before today, had you viewed that footage before today?
Yes.
And do you recall seeing anything unusual?
Not sure I understand the question.
Do you recall seeing anything unusual
Do you mean in the footage or?
in the
at his-
footage?
Go ahead and answer with that understanding.
I guess not, no.
So if you don't recall seeing anything unusual in the footage, what would be the purpose to turn it into law enforcement?
Objection.
Grounds?
It's argumentative and a misstatement, Your
Grounds.
Honor.
The way it's phrased, I believe it calls for speculation on the part of the witness, as well as the other reasons indicated by the state, so I'll sustain it as to the form of the question.
Why did you turn the video footage into law enforcement?
I was asked to go through my camera footage.
Even though you hadn't saw anything unusual?
Sure, correct.
And you stated that the time was off because of daylight savings time?
Correct.
And so it would have been an hour earlier than what was being shown?
I believe so, yes, correct.
Can you state where that particular camera is positioned on your residence?
It's on the back of my home, facing my garage.
Do you recall what law enforcement agency you turned that footage in to?
Was the Waukesha Police Department.
Do you recall what officer you spoke with when you turned in the video footage?
I do not.
You stated that you saw the footage before today. Any idea exactly what we were looking at?
Recorded footage of my backyard.
Pretty standard to any other footage from any other day?
I guess I don't understand that question.
Is it pretty much the same thing you would see any day if you viewed that footage?
It's recorded footage of my backyard.
Is it pretty much the same footage you would have saw if you viewed it every day?
Sure.
And do you recall if you were subpoenaed to testify in this matter?
Yes. Yeah, I received a letter.
Do you recall by whom?
Waukesha County was on the envelope. I don't remember the names on it.
Do you recall how long ago that was?
I do not.
Did you yourself at any time file a claim in this matter?
No.
Do you know of anyone who has filed a claim in this matter?
No.
Have you ever talked to the plaintiff in this matter?
Objection.
Grounds.
Bank.
Sustained as to the form of the question.
Have you yourself ever reached out to the plaintiff in this matter?
Objection.
Grounds.
Bank.
Sustained as to the form of the question.
Have you ever had any personal interaction with the plaintiff in this matter?
Objection.
Grounds?
Vague, argumentative, irrelevant.
Sustained.
Sustained for those reasons stated by.
Sustained as to the form of the question as well.
Are you sure if there's a plaintiff in this matter?
Objection.
Grounds.
Argumentative, irrelevant.
Sustained for those reasons.
Were you at any time informed that there's a plaintiff in this matter?
Objection.
Grounds.
Irrelevant.
Sustained.
For the reasons stated by the,
Sustained.
for the reasons stated
Yes.
by the state.
Also as to the form of the question.
Have you at any time seen anywhere or read anywhere that there's a plaintiff in this matter?
Objection, Your
Grounds.
Honor. Irrelevant.
Grounds?
Sustained, also as to the form of the question.
No further questions.
Thank you. Any redirect?
No, Your Honor, I'd ask Mr. Stone be excused.
Thank you, sir. You may step down. And yes, he's excused.
Thank you.
Thank you.
You may call your next witness.
State calls Andrew Amerson.
What was the name again?
Andrew Amerson.
All right, thank you. Good morning, Mr. Amerson. If you would please make your way to my witness stand, which is to my right. Up one riser. When you get there, please remain standing, raise your right hand, and my clerk Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat. The first thing I will ask you to do is to state your first and last names for the record, and then spell each.
Andrew Amerson, capital A-N-D-R-E-W, capital A-M-E-R-S-O-N.
Thank you. Go ahead, your witness.
Thank you. Good morning, Mr. Amerson.
Morning.
Sir, on November 21 of 2021, where did you live?
435 Dunbar?
Is that here in the city of Waukesha?
Yes.
And is that your home?
Yes.
Overruled is foundational. The witness may answer. If there is an objection, sir, I will need to rule on it first before you answer, so just wait until I do that. Thank you.
Okay.
Do you have any security cameras at your home, sir?
Yes, I do.
And did you back then in November of 21?
Objection leading.
Overruled. The witness may answer. It's foundational.
Yes.
To your knowledge, were they in working order on November 21 of 21?
Objection speculation.
Overruled. The witness may answer.
Yes.
Does your security camera have recording capability?
Objection leading.
Overruled. The witness may answer.
Yes.
And can the recordings be viewed at a later time?
Yes.
At some point close to November 21 of 2021, maybe a day or two later, were you contacted by the Waukesha Police Department?
Objection leading.
Overruled.
I was contacted on Monday and on Wednesday.
Okay. Why were the officers at your house, sir?
My cameras are evident from the street, so they were curious if they were in working order and if they could look at them.
Did you agree to that?
Absolutely.
And did they specifically obtain recordings related to the date of November 21 of 21?
Objection leading.
Overruled, the witness may answer, it's foundational.
Yes.
Did you ultimately provide a copy of those recordings to the officers?
Yes, on Wednesday.
How did you do that, sir?
I gave them the operating system after acquainting them with the monitor and how it all worked.
Okay.
And they were focused on a certain area to the west,
Okay,
and I showed them how to get a good view on that and welcome them to have it if they needed it.
did they take it?
Yes.
Before you turned it over to them, sir, did you change the content of the recording in any way?
Objection
No.
leading.
Sorry.
And speculative.
Overruled as to both objections, the witness may answer.
Nothing was changed.
Okay. I'm going to ask you to look at the screen next to you. I'm going to put up Exhibit 156. This is a 9-second clip. Can you see that, sir?
I can.
All right, I'm going to play that clip for you at regular speed in its entirety.
Sorry, how many seconds is the clip?
9 seconds, Your Honor.
Can we make sure it's playing at regular speed?
Did you see that clip, sir?
Yes, I did.
Is that a portion of the recording that you turned over to the Waukesha Police Department?
Yeah, that's the camera that faces west.
Okay. Do you believe that exhibit, what we just showed you, that video is a true and accurate representation of the events that evening near your home?
Yes.
And if you look on the screen, sir, do you see a date and time stamp for the video?
Yes.
Objection leading.
Overruled, the witness may answer.
What was the date and time stamp that the video was recorded, please?
November 21, 2021 at 4:46:41 p.m.
Thank you, sir. I move for admission of 156, Your Honor.
Objection relevancy.
Overruled, the exhibit 156 is received.
No further questions.
Thank you. You may be questioned by Mr. Brooks now. Go ahead, sir, if you have any questions.
Yes, I do. Good morning, Mr. Emerson. Would it be fair to say that you saw the video footage before today?
I saw it on the day of and the days following.
And what, if at anything, do you see on the video?
I see a man crossing the street, coming down from the properties across the street.
And you said a man. Would you say it's fair to say that from the video, this is a pretty good distance from where your camera was positioned?
That video image is a good distance. It's about 50 yards.
And you can tell from the video that you just watched today, you can tell the gender of the individual that you saw crossing the street, as you say?
Well, when I saw it originally, I had zoom. Okay, the feature of the camera zooms, so your image was real clear.
So the image was real clear when you had zoom. Any reason why this particular image doesn't have that feature?
They can do whatever they want.
Ground.
Objection.
Hold on, there's an objection.
Sorry.
Let me rule on it.
Beyond the scope of the witness's knowledge, Your Honor.
I'll overrule if you know the answer.
I don't know what decisions they made in choosing the display.
And was that all you saw in the video, or did you see anything else unusual, or something that may have caught your eye, or?
That's the only thing that I was focused on.
And do you recall what agency you was contacted by about the video footage?
The detectives that came to my home on Monday identified themselves and then told me that other detectives might show up on Wednesday, and other detectives did show up on Wednesday. I didn't write down their names.
Do you recall what agency they were from?
Police department.
Do you recall if they were Waukesha Police Department or some other jurisdiction?
I'm pretty sure they were Waukesha, but I, didn't ask.
Did those detectives ever follow up with you after those initial dates from that Monday, I think you said, into Wednesday?
Never saw her again after Wednesday.
Did you yourself follow up with law enforcement after those 2 visits?
No.
And do you recall when you were subpoenaed to testify in this matter?
Late July, early August.
Do you recall by whom?
Waukesha County District Attorney's Office.
Do you recall whose name was on that subpoena?
I would have to take a look at it to recall it.
And once you received the subpoena, did you call the Waukesha District Attorney's Office to gather any information about the subpoena?
On a few days, getting close to October 3rd, I made a phone call to ask if I was going to be somebody that they needed on October 3rd, because I hadn't heard anything from them.
Do you recall who you spoke with at that time?
I believe the person that gave me the information that was helpful to me was Carrie Peterson.
It would be fair to say at that time you were notified that you possibly were needed to testify.
It was an unknown still at that point. Later, I received a text saying that I was on call as a witness.
Did you receive that text the same day that you called the district attorney's office or sometime after?
It might have been the same day, it might have been the next day.
Did you yourself at any time file any claims in relation to this matter?
No,
Do you know of anyone who filed any claims in relation to this matter?
that's a privacy issue.
You may answer the question.
I know that my grandchildren receive counseling, and I think that a Waukesha Community Fund might have helped cover some of that.
Do you recall the name of the fund?
No.
And to your knowledge, the fund that you speak of was strictly geared towards counseling?
I'm not privy to what it was geared toward.
So would it be fair to say that there was a financial interest attached to this incident?
Absolutely not.
And how
There's a
did you
mental health interest.
And how's everybody doing now? Are they okay?
Objection irrelevant.
Grounds
Sustained.
for relevance?
Yes.
Have at any time you yourself had any personal interactions with the plaintiff in this matter?
Objection.
Grounds.
Sustained is to the form of the question.
Do you know if there's a plaintiff in this matter?
Objection
Grounds.
irrelevant.
Sustained.
Grounds for the sustain, Your Honor.
Not relevant.
Do you recall if the plaintiff in this matter reached out to you in any way?
Objection.
Grounds.
Irrelevant, asked and answered.
Grounds.
Sustained for those reasons. Also as to the form of the question.
Just for the record, it wasn't asked and answered, just for the record.
Next question, please.
Do you yourself know if there even is a plaintiff in this matter?
Objection argumentative.
Sustained as to the form of the question.
No further questions.
Thank you, sir. Any redirect?
No, I'd ask that Mr. Amerson be excused, Your Honor.
Thank you, sir. You may step down, and you are excused. Go ahead.
State call Leonard Miller.
Good morning, Mr. Miller. If you would please make your way to the witness stand, which is to my right. It is up one riser. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat.
Thank you.
First thing I will ask you to do is to state your first and last names for the record and then spell each.
Leonard Miller, Leonard, Miller, Miller.
Thank you. Go ahead.
Good morning, sir.
Good morning.
Mr. Miller, on November 21 of 2021, where did you reside?
Uh,
Overruled, the witness may answer.
126 Central Avenue,
That's here in the city of Waukesha?
Waukesha, yes.
Okay. Do you have any home security systems in place at your residence, sir?
Objection, speculative.
Overruled. The witness may answer.
Yes, I have 2 doorbell cameras and a floodlight cam.
Are you able to record the events that are captured on the security camera?
Yes,
And can those recordings be shared with others?
yes,
At some point, shortly after November 21 of 2021, were you contacted by the Waukesha Police Department?
it was actually that evening.
Okay. Tell us about it, please.
Well, actually, after everything transpired, I just got done setting up my Christmas lights, and I was in the house, and my wife came down from taking a shower, and I said, let's go look at the lights. We stepped outside, well, we started to step out the front door, and there was actually a SWAT team in our front yard.
Okay.
So I said, we're not gonna look at the lights now. So then, after a little bit, I started looking through my cameras, and I noticed somebody running up my driveway on the one camera.
Did
And
you
so
recognize the person?
I did not,
Okay.
sorry.
Hold on, there's been an objection. It's overruled. His answer may stand. If there are further objections, please wait until I rule on them before you
sorry.
answer. That's okay. Thank you.
Okay, so you saw somebody on the recording that you did not recognize.
Correct.
Objection, leading.
What,
Hold on. Overruled.
Action, answer.
It's foundational. I'll allow it, but please move on.
Just asked and answered already.
what did
Go
you,
ahead.
what did you do when you saw that, sir?
I called the Waukesha Police Department, and a short while later, a couple officers came over and walked through my property and through the garage and made sure nobody was there. Then about an hour or so later, I believe it was a detective called me and asked if I could send them the copy of the video.
Did you do that?
I did.
Prior to doing that, did you alter the content of the video in any fashion, sir?
No, my,
Speculative.
Overruled. The witness may answer. Go ahead.
I did not. I have no way of, I wouldn't know how to.
Okay. How did you send it to the police officers?
Via email?
Okay. I'm gonna put up, on your screen next to you, Exhibit 159, please. This is a 20-second clip, and I'm going to play it for you at regular speed, and then I'll ask you a question, okay?
Sure.
Said 159.
Exhibit 159 is what I wrote down. And yes. Go ahead.
Mr. Miller, is that the recording you provided to the Waukesha Police Department?
Yes.
Do you believe this is a true and accurate depiction of the events at your home on November 21 of 2021?
Objection, relevancy.
Overruled. You may answer.
Yes.
In the upper right-hand corner of the recording, I noticed there's a date and time stamp. Do you see that?
Yes.
Objection, leading.
Do you believe that was
Hold on.
accurate?
Overruled.
I'm sorry.
There's, the witness's answer may stand. Go ahead, next question.
Do you believe the date and time stamp on the recording are accurate, sir?
Yes.
And what, if you could read, please, the date and time stamp on Exhibit 159.
November 21st, 2021, 04:48:16 p.m.
Move to admit Exhibit 159, Your Honor.
Objection, relevancy.
Overruled. Exhibit 159 is received.
I don't have any other questions. Thank you.
Thank you. Any cross, sir?
Yes, briefly.
Go ahead when you're ready.
Okay. Good morning, Mr. Miller.
Good morning.
Before today, it would be fair to assume that you saw that footage before today.
Yes.
And you stated a little bit earlier that when stepping out to view the Christmas lights, you noticed a SWAT team in your yard.
Correct.
What do you mean by SWAT team?
Fully armed, rifles in hand, helmets on, officers in my front yard. Well, and on the street of my front yard, I should clarify that, in the street of my front yard.
Did you notice any vehicle that they may have been in at that time?
I'm sorry, could you repeat that question, please?
Did you notice at the time that you observed the SWAT team in your yard, did you notice any vehicle that they may have been in at that time?
I did observe a squad car down the street. Whether it was theirs or not, I cannot say for sure.
And do you recall what police agency you turned the video footage over to?
Yeah, it was Waukesha Police Department.
Do you remember the name of the officer that you turned the video footage over to?
I am sorry, I do not.
Do you recall filing a report at that time?
No report was made.
So it'd be fair to say the extent of your interaction with law enforcement was strictly about the video footage.
Correct.
Do you recall if law enforcement followed up with you about the footage?
I don't believe so.
Did you yourself follow up with law enforcement about the video footage?
I did not.
And do you recall when you were subpoenaed to testify in this matter?
I'm sorry, I didn't hear the first part of your question.
I'm sorry. I have a bit of a cold, so.
Sure.
Do you recall when you were subpoenaed to testify in this matter?
I can't remember the exact date, but it was a few weeks ago.
And when you received the subpoena, did you follow up with the district attorney's office? I'm assuming that that's who served the subpoena.
I did.
Do you recall whom you spoke with?
I do not recall the name. Sorry.
Did you yourself file any claims in relation to this matter?
I have not.
Do you know of anyone who filed a claim in relation to this matter?
Personally, no.
To the best of your recollection, do you recall being contacted by the plaintiff in this matter?
And other than regards to the summons, no.
And you made reference to the summons.
Or subpoena. rather.
What was the plaintiff's name on the subpoena?
I believe so.
Do you recall what that name was?
State of Wisconsin.
Have you ever had any interactions with the state of Wisconsin?
Objection.
Grounds.
Irrelevant, vague, argumentative.
Grounds.
Sustained.
For those reasons, Your Honor, or?
Sustained. Yes.
Being that you identified the state of Wisconsin as the plaintiff, have they ever reached out to you in any way?
Objection.
Grounds.
Sustained as to the form of the question.
Have you ever had any personal interaction with the state of Wisconsin?
Objection. Vague,
Grounds.
irrelevant, argumentative.
Grounds.
Sustained.
For those reasons stated by?
Yes.
Would you yourself classify the plaintiff that you identified, state of Wisconsin? Would you classify them as a living human being?
Objection.
Grounds.
Vague, irrelevant, argumentative.
Sustained for those reasons.
Would it be fair to say that a state cannot be a human being?
It could be argued philosophically, I guess, yes,
And
but I don't know. No,
no?
personally, no, but philosophically, I suppose you could argue that the state is a person.
The state, one state?
I suppose it could be argued.
And with determination, how did you come to that determination?
Objection. He said he did. Your Honor, that's a misstatement of his testimony.
Sustained as to the form of the question. It's also not relevant.
Do you see the state of Wisconsin present in the courtroom today?
Objection. Irrelevant.
Grounds.
Sustained. Not relevant.
What was the last part, Your Honor?
Not relevant.
Have you ever seen the state of Wisconsin at any time?
Objection.
Grounds.
Argumentative.
Grounds.
Irrelevant.
Sustained for those reasons.
What reasons? I didn't hear.
For those reasons, it was also asked previously, and I sustained the objection.
That question wasn't asked previously, for the record. So to the best of your knowledge, is the state of Wisconsin the injured party in this matter?
Your Honor, I object and
Grounds.
ask you to direct the defendant to move on.
Grounds.
The objection is
I think the judge has to
sustained
do that, not
pursuant.
the DA.
The objection is sustained. Next question, please.
I'm sorry, I didn't hear the reason for the sustain.
It's not relevant.
Your Honor, I object to it not being relevant. He clearly stated
Mr.
the
Brooks,
plaintiff.
please move on. I've made my ruling. Thank you.
I don't know how that's not relevant. Seems to me that there's no plaintiff.
I remind the jury to disregard comments made by the parties. They are not evidence.
There's no plaintiff. No further questions.
Thank you, sir. Any redirect?
No, I'd ask that Mr. Miller be excused, please.
Sir, thank you. You may step down and you are excused.
Thank you.
How can an entity be a plaintiff?
Take a short mid-morning break for about 15 minutes. I'll rise for the jury, please. All right, it's 10:32. Be back in 15 minutes. We are in recess. Thank you. Morning break appearances are as they were before. State have another witness to call this morning?
Yes.
All right, then let's have the jury brought out.
Your Honor, for the record, subject matter jurisdiction has yet to be proven for the record.
Your objection to that is noted. I'm declining to revisit that issue, sir.
Is that a judicial determination?
It is.
All right, for the jury.
Thank you, everyone. Please be seated. Statement calls next witness, please.
Thank you. The state calls Specialist Kyle Becker.
Good morning, sir. If you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Kyle Becker, Kyle-E-B-E-C-K-E-R.
Thank you. Go ahead, your witness.
Thank you. Sir, how are you employed?
City Waukesha Police Department.
What's your job type?
Warrant specialist.
And directing your attention to the date of November 23, 2021, were you on duty that day?
Yes, I was.
What duties were you tasked with on that day?
Me and several other officers, detectives were tasked with being part of the search team canvassing the area for items.
Okay, and this was related to the investigation into the Christmas parade?
Objection, leading.
Yes.
Okay.
The objection's noted. It's overruled. These are foundational type questions, so I'll allow it. For the witness, though, please make sure you wait until I rule on objections before you answer. Thank you. Next question.
So you said the purpose of the team was to look for items, did you say?
Objection, leading.
Overruled.
Yes, items that we believe Mr. Brooks, Darrell Brooks, was wearing the night of the incident. He discarded.
Okay. And did you come up with a plan or a method to proceed?
Yes, we did. So we knew that he fled from the vehicle at 338 Maple Avenue in the city of Waukesha. So we directed our team around that area, and we were going to start on the 300 block of Maple, and we were going to work westbound in the backyards until we got to like Northwest Avenue, trying to look for items that might have been discarded by Darrell Brooks.
And what day was this that you set out to do this?
November
Objection,
23rd,
leading.
2021.
Was there an objection or not?
Yes.
Overruled. The witness may answer.
It was November 23rd, 2021.
What time of day were you performing this search?
It's approximately about 10:15 in the morning.
Did you personally recover any items of interest in this case, sir?
Yes, I did.
Can you tell us about that?
Yeah, the first item that we located was a blue sandal, or they also call it a slide, that was located at 322 Maple Avenue in the backyard. 322 butts up to 434 Dunbar, and in the backyards there is a chain link fence that separates the 2 yards. The first sandal that we located was our right-footed sandal, and it was on the maple side, 322 maple side of the fence, close by the chain link fence.
All right, I'm gonna put up 2 items, photographs. First one would be Exhibit 94.
Go ahead.
Is that on your screen, sir?
Yes, it is.
Do you do you recognize what is depicted in Exhibit 94?
Objection leading.
Overruled. You may answer.
Yes, I do.
Tell the jury what you see in 94.
It is the blue sandal that was outside the fenced chain link fence area like I described. It is a navy blue in color, and it also had a Milwaukee Brewers logo album on the front of the sandal, which appeared to be like torn or worn.
Do you believe Exhibit 94 is a true and accurate depiction of the area where the sandal was found
Yes, I do.
and the exact location where the sandal was found?
Objection leading.
Overruled. You may answer.
Yes, I do.
Permission to publish 94, Your Honor? Well, wait, before we do that, I'm going to have you identify 95 as well, and then we'll put them up.
Go ahead with the next exhibit.
Is 95 now on your screen, sir?
Yes, it is.
What is shown in 95?
The navy blue sandal that I just described.
Is it, similar, or how is 95 different from 94?
Objection leading.
Overruled. You may answer.
They were the same exact sandal, just different pictures.
That's what I mean. What's the difference between the photographs?
Objection leading.
Overruled. The witness may answer.
Just the angle of where the picture was taken.
Okay. Do you believe that 95 is the accurate representation of where and how the sandal was found?
Yes, I do.
Move to admit 94 and 95 and permission to publish, Your Honor.
Objection. Relevancy.
The objection is noted. Overruled. Exhibits 94 and 95 are received. Permission to publish granted. And then for my ladies and gentlemen in the jury, let me know when it shows up on the screens in the jury box, as there is a delay at times. All right, we're good. Go ahead.
Sir, if you could just orient us in the picture there. You had described in your testimony a chain link fence, correct?
Correct.
Does that separate 2 properties?
Objection leading.
Overruled. The witness may answer.
Yes, it does separate 2 properties.
And what are those properties, please?
Objection relevancy.
Overruled. The witness may answer.
The where the sandal is located right now, that is on the address of 322 Maple Avenue, and the opposite side of the fence, which would be to the south of that, would be 434 Dunbar.
Okay. So even though the properties abut, the street addresses are on different streets.
Yes, that is correct.
And 322 Maple, can you approximate for us the distance that is to the location where the red SUV was found?
Objection speculative.
Overruled. The witness may answer. Actually, let me do this. I'm going to sustain it as to foundation. I think another question needs to be asked of this witness regarding the red SUV.
Sir, I think you testified earlier that you set out to search the area around 338 Maple, correct?
Yes, that is correct.
And what was the significance of that address, please?
That was where the vehicle was located that Darrell Brooks was driving the night of the Christmas parade.
Okay. And could you please approximate for us the distance between the residence where the vehicle was found and the residence where this sandal was found?
Objection relevancy.
Overruled. The witness may answer.
If this is an approximate guess, I guess around 200 yards.
Okay. The device in front of you is a touch screen. Can you please circle the sandal in the photograph? then if we could please display 95.
Before you do that,
I'm sorry.
any capture of this being requested before? it's-
No, because I think 95 will do that for us, Your Honor.
All right, thank you, then. Go ahead, next exhibit.
All right, now 95 is up, sir.
Same thing, circle?
Sure,
Objection leading.
yes, please circle.
Overruled, the witness may answer by circling.
All right. I'd now like to show you a piece of physical evidence that's been marked as State's Exhibit 86. If I could get the assistance of the deputy, please. Could you please present that to the witness for me?
Was that, you said 86?
I was gonna ask the same thing because I missed that too. Can I have the number again?
Yes, 86, Your Honor.
All right, thank you. Exhibit 86. Not yet.
Sir, have you seen Exhibit 86 before?
Yes.
What is 86?
86 is the sandal that I located outside of 322 Maple Avenue.
One we are just seeing in the photographs 94 and 95?
Yes.
Okay. Move to admit 86, Your Honor.
Objection relevancy.
Overruled, Exhibit 86 is received.
Officer Becker, did you find any other items of significance to this investigation?
Objection leading.
Overruled, the witness may answer.
Yes, I did.
What else did you find?
I found another blue sandal, which was a left-footed blue slide sandal with the same Milwaukee Brewers logo album on it that was worn out. And then I also located a gray hooded sweatshirt that had a multicolored design or logo on the front of the sweatshirt. That sweatshirt was the same sweatshirt that we believed Mr. Brooks was wearing during the incident at the Waukesha Parade.
Where did you find these items?
These items were located, so that chain link fence that was up before earlier, it was on the opposite side south of that chain link fence, which would have been the address of 434 Dunbar Avenue. I was directed towards that area because due to the fact that I thought Mr. Brooks tried jumping the fence and that's how he lost the first sandal. So I was directed towards that area due to the fact in that vicinity there. So I was searching in the backyard of that area and I located a children's playhouse. This children's playhouse was made of wood and it had about 4 or 5 steps up till you got to the platform of the children's playhouse. There also was a slide connected to it that would lead down to the grass. I located in that platform area, I located the gray hooded sweatshirt that had a multicolored design. It's the same sweatshirt that we believe Mr. Brooks was wearing during that parade incident. And then in the close proximity to that sweatshirt was the other sandal, which was the left-footed sandal, which was a blue slide with the Milwaukee Brewers logo album that was somewhat worn. Matched the description of the one that we also found by 322 Maple.
All right, sir, I'm going to display on your monitor Exhibit 96.
Go ahead.
Do you see Exhibit 96?
Not yet.
Okay.
There we go.
All right, do you recognize what is portrayed in Exhibit 96?
Yes.
What is that?
Objection leading.
Overruled, the witness may answer.
That is the children's playhouse where I found the gray hooded sweatshirt and the left-footed blue sandal.
All right. Do you believe the photograph is a true and accurate depiction of the yard and item that you described for us when you saw it that afternoon?
Objection speculative.
Overruled, the witness may answer.
Yes, it was.
All right, we're going to go on to 97. What do we see in 97, sir?
That is the gray hooded sweatshirt with the multicolored design or logo that I located.
In the playhouse.
Correct, in the playhouse.
Okay. Do you believe this is a true and accurate depiction as you observed the events on November 23 of 21?
Objection, speculative.
Overruled, the witness may answer.
Yes, it is.
All right, and then 98, please. Please describe.
This picture is obviously the gray hooded sweatshirt that I just talked about, and then also the other left-footed blue sandal with the Milwaukee Brewers logo elbow that was worn.
Is this the position of these items as you found them, sir?
Yes, it was.
And do you believe this photograph is true and accurate as it's presented here today?
Objection, leading.
Overruled, the witness may answer.
Yes.
Move to admit 96, 97, and 98, and permission to publish, Your Honor.
Exhibits 96, 97, and 98 are all received, and permission to publish is granted as to each. And if the jury would please let me know when the monitors in the jury box also display what's on the large screen. All right, thank you. Go ahead.
All right, Officer Becker, could you please circle for the jury the children's playhouse that you've been describing for us in 96?
Yes.
Thank you. I'm not requesting permission to capture that, Your Honor. I'd like to move on to 97. Oops, there's 97. Okay. And where's the, this is a close-up of that same playhouse?
Yes.
Do you see the sweatshirt in this image, sir?
Objection, leading.
Overruled, you may answer.
Yes, I do.
Please circle it. Are you able to see the sandal in this photograph?
No, I'm not.
Okay. And then we'll move on to 98, please. And those are the two items together in the top portion of the playhouse, is that right?
Yes, that is.
All right. Now I'm going to show you these physical items. Please, Deputy, if you would assist me again. Number 84.
Sorry.
Do you recognize item number 84, sir?
Yes.
What is that?
Objection, leading.
Oh, overruled. I'm sorry. What was the number again?
84.
All right. Go ahead. You may answer, sir.
Yes, this was the gray hooded sweatshirt that I located in the children's playhouse.
All right. And 85. Thank you. Please identify.
This is the other sandal, which was a left-footed blue sandal slide with the Milwaukee Brewers logo that was also located in the children's playhouse.
Your Honor, permission to admit, or excuse me, move to admit 84 and 85.
Objection, relevancy.
Overruled. Exhibits 84 and 85 are both received.
And I'd like to ask, with the court's permission, if 84 can be published by the officer standing up and holding up 84 for the jury to view.
Objection, relevancy.
Permission granted.
So please hold up the sweatshirt, sir.
Objection noted.
Yes. The record to reflect the officer stood up in the jury box. He is holding the exhibit between his waist and forehead. That's the full length of a sweatshirt, and he has passed it from right to left of his body in front of the jury.
Thank you. And then if you would do the same thing, please, sir, you could set that one down, and if you could hold up 84 and 85, one in each hand, and display those for the jury, if that's okay, Your Honor?
Go ahead.
I'm sorry, 85 and 86.
Objection.
Your objection's noted. Go ahead. The witness is standing up still in the witness box. He is holding each one of those exhibits, which I believe is 85 and 86, one in each hand at shoulder height, and he turned a bit from right to left in front of the jury. Thank you, sir. You may sit down.
Specialist Becker, did you check with the homeowner to make sure that the property you just displayed did not belong to the homeowner?
Objection speculative.
Overruled, the witness may answer.
I personally did not. Somebody else may have.
And how about the sandal by the cyclone fence on the ground? Did officers check with the homeowner at that residence as well?
Objection
If you know.
speculative.
Overruled, if he knows, the witness may answer.
I do not know if I didn't personally.
Okay. Thank you, sir. I don't have any other questions.
All right, any cross for this witness?
Yes, just 1 second.
Do you want the items still up by the witness, or can they be taken back to this, or actually brought to my clerk since they're now evidence?
Oh, you can take it back to the clerk.
All right, if the bailiff would bring them to the clerk, please. And then when you're ready.
You testified earlier in questioning. Well, rather, let me back up. You said the name of the alleged suspect when questioned about the alleged suspect fleeing from the vehicle. At that time, did you know the name of the alleged suspect?
Yes, we did.
And how did you obtain that information?
From the detectives working the case.
So you yourself didn't know until you were told. Would that be fair to say?
I was part of the brief, so I knew too.
So you knew before you were briefed?
Yes.
So you knew before you were briefed, then why did you have to be briefed about that information?
Just the gatherings, we briefed every morning, and the gatherings from the day before, what we were all going to do and stuff like that, and what every detective's working something different, so that's, we just kind of gathered as a group like we do every morning and discuss what we all what we all saw. And
were you a part of the investigation the night of the incident?
Yes, I was.
And what was your what was your role in the investigation the night of the incident?
Well, I was activated for our SWAT team. I'm part of our Waukesha Police Department SWAT team, so we were activated at that time. So I was assisting in that matter at the time being, about the parade incident, due to the fact of all the injuries and victims and unknown suspects. At the time, we got activated for our SWAT team.
And you said unknown suspects. What do you mean?
At the time of the incident, we didn't know exactly who the suspects were, if there was one or two at the time. So this was all really fresh information that we received that night. So we got activated right away.
So is it possible that you didn't receive information of the alleged defendant until that evening?
I do not recall when exactly we found out who our main suspect was.
And in reference to the sweatshirt that you observed in the children's playpen. Do you have any information of how that got there?
Not exactly, no, because I didn't follow the footsteps of Darrell Brooks at night.
And seeing as how that you were actively investigating that portion of the investigation, why did you not ask the homeowners if the items belong to them?
I did not ask them. I located it, and then it was turned over to more of the detectives that were handling the case.
The
to
question was
make
why
contact.
why didn't you ask the homeowners?
I don't know. I just didn't.
So it would be fair to say you didn't know who the items belonged to at that point.
Fair enough. Yeah.
You made reference to, and the word you used was belief. You made reference to belief that the alleged suspect jumped the fence, and I guess that would refer to where the slide, as you referred it to, was found. How did you come to the determination that a fence was jumped?
During my training experience, my main job role as a warrant specialist, I go out and track a lot of suspects down, and a lot of times those suspects also flee on me. We're at to get in a foot pursuit with them. There's been multiple times where suspects jump over fences to try to get away from police. So that's why I came to that conclusion just during my training and experience.
Did you chase any suspects during your investigation?
No, I did not.
So it would be fair to say that you don't know for sure if any suspect jumped the fence.
That is fair enough, but just during my training experience, that's what I believe may have happened.
So it would be fair to say you weren't sure exactly.
I guess you could say I wasn't 100% sure.
And you testified earlier, and I don't want to misquote you. I think it was some question of determining the distance. I don't know if that was in reference to where the vehicle was found and where the items that you found were located. Was that the distance that was being referred to?
Yes, I believe so.
Thanks for that clarification. I didn't want to misquote you. How were you exactly able to determine the exact distance of that?
I wasn't able to. I think I may have stated it's a rough estimate or approximate.
So it'd be fair to say you don't know for sure the distance.
No, I do not know for sure the exact distance.
Did you at any time see anyone, I guess I will refer to alleged suspects, did you at any time see any alleged suspects drop any items?
No, I didn't.
Did you see any alleged suspects remove any items?
No, I did not.
And you stated that your search investigation was the next morning?
It was November 23rd, 2021.
And do you recall when that part of your investigation ended?
I would have to it'd be an approximate guess. I don't know how long we were out there exactly. It was that morning and then probably early afternoon, I'm guessing.
And was that the extent of your part in the investigation? After you completed the investigation part on the 23rd of November, 2021?
Yes, that is correct.
At any time after that, did you follow up with your part of the investigation where it was positioned in the investigation in full?
No, everything was turned over that day that I found the items to our forensics unit at the Waukesha Police Department, where they handled the custody of the evidence.
Were you ever after that date followed up with by any law enforcement after that initial date?
I don't really understand what you're saying.
After your part of the investigation was completed on that day, the 23rd of November, 2021, did any law enforcement officers follow up with you about your part of the investigation?
Not that I recall.
And you said you turned the items over to a crime lab, or?
No, it was a criminal evidence and forensics unit of the Waukesha Police Department, specifically Specialist Schmidt.
And from that point, do you know what happened to the items?
No, I do not.
Do you know of any procedure once you turn over the items? And well, I believe you said the. Can you say it again? I'm sorry.
Criminal
Evidence.
Yeah, criminal evidence forensics
Criminal
unit.
evidence. Is there any procedure after that in reference to the items? Like what may be done to the items?
Yeah, they would place them into inventory at the Waukesha Police Department. So that's Specialist Schmidt's primary job role at the Waukesha Police Department.
So once you turn over the items, that's pretty much the end of your part of it.
Yes.
it be fair to say that these items have been kept for quite a while now? Would that be fair to say?
Yes.
Are items usually kept for this length of time in investigations?
Yes. Typically, yes. Till the case is over.
So that it isn't unusual in any way to see items kept roughly a year or so.
No, that's not unusual, especially if it's evidence to a crime.
And what usually happens to the items after the investigation is complete?
You would have to ask the criminal investigations division, the specialist Schmidt that handles those types of cases. I don't know how they release those items.
So you're not sure, to your best of your knowledge, you're not sure.
No, I'm not.
Do you recall making a report in this matter?
Yes, I do.
And did you write it yourself, or was it typed by someone else? Or?
No, I believe I wrote my own report.
And you stated that this would be called a canvas search team?
Yes, that's correct.
And you stated or made reference to it being like a SWAT team?
No, I recall that you asked what I did the prior day of the parade incident. Now, I just advised you that I was activated for our SWAT team that day of the parade incident, the actual day. The items that I located on the canvas search team was on the November 23rd.
So, in reference to the SWAT team statement, what do you mean by SWAT team?
Our tactical unit at the Waukesha Police Department.
And what do you mean by canvas search team? Can you explain what exactly is a canvas search team?
That is the group of individuals that we had in our criminal investigations divisions. It was a detective specialist. There might have been some officers too. Gathered as a group. I think there was about 10 of us, and we searched the area to try looking for items.
And do you wear regular law enforcement gear, or is there any change in the gear?
Yeah, regular law enforcement gear. So that I wear day to day, every day.
To the best of your knowledge, did you yourself file any claims in this matter?
No, I did not.
You know of anyone who filed any claims in this matter?
No.
Have you at any time saw or read a complaint in this matter?
No.
And do you recall who you were subpoenaed by to testify in this matter?
Yeah, state of Wisconsin.
And who do you refer to when you say state of Wisconsin?
District Attorney's Office, Waukesha County District Attorney's Office.
Do you recall whose name was on the subpoena?
I do not recall. I'd have to look at the paperwork.
So to the best of your knowledge, would the state of Wisconsin be the plaintiff in this matter?
Yes.
And do you see the state of Wisconsin plaintiff in court today?
Objection.
Grounds?
Proper vague question.
Sustained as to the form of the question.
Is the plaintiff present in court today, to your knowledge?
Objection.
Grounds?
Irrelevant, legally inaccurate statement, Your Honor.
Sustained for both reasons.
Do you recall having any personal interactions with the plaintiff in this matter?
Objection vague.
Grounds?
Sustained as to the form of the question.
Have you ever been contacted by the plaintiff in this matter?
Same objection.
Grounds?
Sustained as to the form of the question.
If you were to see the plaintiff, state of Wisconsin, will you be able to identify him?
Objection argumentative.
Sustained as to the form of the question.
Would you classify the plaintiff, state of Wisconsin, as a human being or an entity?
Objection irrelevant.
Sustained, not relevant.
Would it be fair to say this isn't your first time during your career testifying in any type of criminal matter?
Yes.
Yes, as in?
I've testified before.
So it would be fair to assume that you understand plaintiffs and defendants, correct?
Objection
Grounds.
irrelevant.
Sustained, not relevant.
Are you aware that only a living human being can bring a claim against a defendant?
Objection irrelevant, argumentative.
Grounds.
Sustained for those reasons, and as to the form of the question.
To the best of your knowledge, who can bring a claim against an alleged defendant?
Objection irrelevant.
Sustained, not relevant.
No further questions.
Thank you, sir. Any redirect?
No redirect of this officer, Your Honor.
All right, thank you. Sir, you may step down.
Thank you.
I could start with another officer, but I don't think I'll complete his testimony.
What I'd like to do at this point is advise the jury about what is to happen next. I'm advised that everything is ready to go. So, ladies and gentlemen of the jury, you will now be taken to a garage attached to the Waukesha County Courthouse to view the vehicle recovered by the Waukesha Police Department. You will be taken to the garage by the jury bailiffs. During your trip to and from the garage, or while there, you are not to discuss this case with anyone. While at the garage, you are not to talk, and no one is to talk to you about the case except the judge. You are to remain with the other jurors. You are not to conduct an independent investigation now or at any time during the trial. The court is taking the jury to the garage to provide the jury with an opportunity to view the vehicle, as it is not possible to bring the vehicle into the courtroom. Other than the vehicle, anything you see there is not evidence in the case and should not be considered as evidence. At this time, please rise for the jury. And the jury bailiffs will wait until further instructed as to when to bring them over. question was asked about whether they could bring notebooks, and I instructed that they should not. All right, thank you. Be seated. We will be in recess while the court and the parties participate, or at least observe, the jury view. And given that it's 11:35, unless something unanticipated happens that I would need to put on the record right away, then we also will be taking the lunch break after the jury view. I believe we'll be over there for, let me put it this way, I don't think the process is going to take more than a half hour. I think it will take much less than that. I think what might take more is just getting all of us there and situated. But let's say it takes us to noon, we'll take an hour for lunch, so I would expect the parties to be back here at 1. All right, thank you, everyone. Back on the record. It is just after 1 p.m. Appearances are as they have been. I do want to make a very brief record regarding the jury view. I did have Madam Reporter take her steno machine and make or take a contemporaneous record of the little bit that was said while we were there. I can state for the record, and I also had Madam Clerk take some minutes. The court arrived at 11:44. The state arrived. The defendant arrived shortly thereafter. The parties were each given an opportunity to do a walk around before the jury came in. The defendant did that. And then I walked around as well with my clerk. And then we all were positioned in various locations within the garage. The belly chains and handcuffs were removed from Mr. Brooks. He did not have leg restraints on that I could see. And so when the jury was brought in, he was not in any of that. And then I instructed the jurors at that point, our civilian bailiff, Michael, was in the lead. I said, please come in, walk around the vehicle one time slowly with the jurors, and then exit. That is what they did. 2 videos were made. One was prior to anyone being in there. It was just the sheriff's department personnel, I should say prior to the parties being in there. And they took a video of the garage and then a walk around the vehicle that was provided to me at the conclusion. It was on a large type drive. And then I provided that to Mike Nyman and Zach Tremaine, who then provided that to the media. And then the second part where we all were in there and the jury came through, that was also captured on video. All of that was put on a flash drive and will be marked as Court's Exhibit 1. Along with the docket entries Madam Clerk will make. And then, of course, if need be, if a transcript is ever needed, I did document a few things as we went through that process. So that there's that contemporaneous record as well. Any party feel the need to add to the record I've just made from the state?
No, Your Honor, thank you.
From you, sir?
Not to that, no.
Okay, thank you then. All right, then I know the jury is ready to be brought back out. I believe the state has additional witnesses.
We do, Your Honor, and I have another large poster board that I'd like to show with the next witness. So I don't know if you'd like us to put it up on the witness stand now before they come out, or?
Do we need the easel for that?
Yeah, we'll need the easel too.
All right, since there's no jury out, you can put that on the witness stand now.
Thank you.
Maybe put it facing backwards, and then that will be there for the next witness.
Sure, thank you.
All right, and then anything from you, sir?
In regards to this?
Any other preliminary matters that you are asking the court to address?
Were my filings actually filed?
You're talking about from this morning?
Yes.
Have they been scanned in so that you can get the originals back? Is that what you're asking?
Yes.
I will ask Madam Clerk if that has happened.
They have.
All right.
It has.
Let me see. I think in our papers that we have been keeping, there might have been another filing from you. So whatever we have, they've all been entered into the record, and you're getting back as a courtesy those filings.
That was the one this morning, and then these are the 2 originals that I had not given back yet. There were 2 that I gave him immediately, like I scanned them in right away, and then gave them back. These are the 2 I'm still holding.
There was 2 other ones, so I have one from October 5, one from October 13, and then one from October 19. These, just so we're clear, sir, I'm providing these as a courtesy back to you because the clerk's office policy is once they're scanned in, they are destroyed, because then what's in the electronic file is what's kept. They do not have the docket entries though, because you requested the originals back, so I'll provide those to you. Okay, then with that, we'll have the jurors brought out.
Subject matter jurisdiction, Your Honor.
The court's declining to address that further. I stand by my written decision that was entered last week.
So we won't be proving it for the record?
I stand by my written decision that was entered last week, sir.
Judicial determination?
It is a judicial determination.
All rise for the jury.
Thank you, everyone. Please be seated. The state may call its next witness.
Thank you. The state will call Detective Justin Rowe.
Good afternoon, sir. If you would please make your way to the witness stand, which is to my right. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Justin, Justin, Rowe, Rowe.
Go ahead, your witness.
Thank you. Detective, how are you currently employed?
City of Waukesha Police Department.
Can you briefly describe for the jury your experience in law enforcement?
From 2003 to 2009, I was a security police officer with the United States Air Force. And then from 2009 to present, I've been a member of the Waukesha Police Department.
And your current rank is that of detective?
That's correct.
I'd like to direct your attention to the date of November 23, 2021. Were you on duty that day, sir?
Yes, I was.
Do you recall what your assignment was that day?
I was tasked with going to the Maple Avenue and Northwest Avenue area neighborhoods to search for items that may have been discarded by Darrell Brooks.
And were you alone in that task?
No, I was accompanied by a whole team of other detectives and investigators.
Before you traveled to the neighborhood, did you have a plan of action?
We did. We planned to begin at 338 Maple Avenue, which is where the vehicle was left prior to Darrell Brooks fleeing the scene south. So we had begun at that location and began to canvass our way south and west.
Were you present when any items were discovered that were relevant?
Yes, I was.
And just very briefly describe what those items were, sir.
Objection, leading.
Overruled, the witness may answer.
Specialist Spakowitz and I were walking in the parking lot of 322 Maple Avenue, which is a large apartment complex, and we came across a right-footed sandal, a blue sandal, up against a fence area that separates the Dunbar neighborhood or street homes from the Maple Avenue apartment complex.
Are you aware of any other items that were recovered during this effort on that same day of November 23, 2021?
Yes, a short distance from that sandal, some other investigators did locate a sweatshirt and a left-footed blue sandal.
Now, in addition to looking for items, did you and other detectives attempt to obtain video from homeowners and businesses in the area?
Objection, leading.
Overruled, it's foundational, the witness may answer.
Yes, we did.
And do you recall obtaining a video from the school district?
Yes, we did.
And do you recall what building or buildings from the school district video was recovered from?
Objection, leading.
Overruled, the witness may answer.
It's a building that's right on Maple Avenue. It's, we refer to it as the School District of Waukesha. It's their administrative building, also known as the Lindholm Building.
And you obtained video from that location?
Yes, we did.
Did you also obtain video from homeowners on Dunbar?
Objection, leading.
Overruled, the witness may answer.
Yes, we did.
Specifically 435 Dunbar?
Correct.
Objection, leading.
Overruled, it's foundational. Sir, please wait until I rule on the objection. Thank you.
And how about Central Street or Road?
Yes, we did.
Did you have an opportunity to review those videos that were collected?
I did.
And did you see anything of significance to this investigation in any of those videos?
Objection, speculative.
Overruled, the witness may answer.
Yes.
I'm going to show you an item that's been marked as exhibit number 131. And we're going to show it on your monitor first, okay? So let me know when it's up.
It's up.
All right, and we're going to just take it out of presentation. There we go. Okay.
What exhibit is it?
This is 131, Mr. Brooks. What do you know Exhibit 131 to contain, Detective Rowe?
This is a video that is taken from 425 Dunbar Avenue, which is the south side of Dunbar Avenue. And if you see on the near the upper left-hand corner, the northern intersection area, there is a red sort of blur near the bottom of a driveway right before the intersection. And that is going to be Darrell Brooks on that sidewalk, and he's going to cross the street.
And
Okay.
hold on 1 minute. I'm just going to remind the jury, it's up for the jury to determine what the facts are, not what any witness's opinion may be. You will ultimately need to decide who is in that video. Go ahead.
And I should ask a broader question. The exhibit itself, the whole exhibit, does it contain, do you know what's in Exhibit 131?
Yes, I do.
Does it contain more than one video, sir?
Objection, leading.
Overruled, I'll allow it. The witness may answer.
I believe this is one video of it itself.
Sure, but the exhibit contains multiple videos and
Correct.
Objection,
still
leading.
shots?
Yes.
Okay.
Objection noted. I'll overrule it. It's foundational. Go ahead.
What are you looking at right now, sir?
I'm looking at the beginning of the video of Dunbar Avenue.
Okay. Do you believe, well, strike that. I'm going to ask the assistant to play this video for you at your monitor, and then I'll ask you a question, okay?
Okay.
Before you do that, for the record, how long of a clip is it?
I was just looking for that because we're now in a PowerPoint, Your Honor. I don't know that I can tell you exactly until we get to the end.
Looks like 9 minutes or something.
9 seconds and
Oh,
9.56 seconds, Your Honor.
All right, thank you. Go ahead.
All right, so we're playing this for you, Detective Rowe. All right, were you able to observe the video?
Yes.
And were you able to observe anything of significance to this investigation in the video?
objection, speculative at that point.
Overruled. The witness may answer.
Yes, it appears the defendant is crossing the street.
This exhibit, I'm sorry, Are you aware of the other videos and pictures contained in Exhibit 131?
Yes.
Objection leading.
Overruled, the witness may answer. Once again, please wait till I rule on the objections.
Do you believe all of the videos and pictures in Exhibit 131 are true and accurate based off of the videos that were obtained from the homeowners and businesses that you testified to previously?
Yes.
Move to admit 131 and permission to publish, Your Honor.
Objection. Directly to the video.
Your objection is noted. It is overruled. Exhibit 131 in its entirety is received. And did you ask for permission to publish?
I did.
Go ahead.
And for the record, Your Honor, this is a PowerPoint. What's being displayed at the moment is slide number 1.
Thank you. Go ahead.
Is it on the jury box? Okay. All right, please play the video in slide 1. All right, the video has played completely, Your Honor. I'm going to ask to move to slide number 2.
Go ahead.
Do you see what's shown on slide number 2, Detective Rowe?
Yes.
Describe what we're seeing in slide 2.
Upper left-hand corner, you're going to see another still image of the original video, and then below that you're going to see a zoomed-in, cropped image of the figure that would be crossing the street.
Okay. Have you seen this video on other occasions, sir?
Yes,
And obviously the zoomed-in image is quite blurry.
absolutely.
Okay. When we played slide 1, were you able to make out any details about the person in slide 1 that was crossing the street?
Yes, it appeared the person had a red shirt.
Okay. All right, we're going to go to slide number 3, please. And you testified about receiving video from the school building at 222 Maple Avenue, is that right?
Objection leading.
Sustained as to the form of the question. Please rephrase.
What is shown on slide 3?
Slide 3 is a view towards the rear parking lot of the Lindholm building, or also known as the School District of Waukesha Administration Building.
And I'm going to request that we play the video in slide number 3, Your Honor, in its entirety.
Do you happen to know how many seconds?
5.97.
Thank you. Go ahead.
Objection relevancy.
Overruled. You may play.
Did it play? Yep. I'm sorry, I missed it. Okay, we'll go to slide, next slide. Lost track, we're on 4 or 5, slide number. Going to slide number 4. All right, so again, the camera, or strike that. What are we seeing on slide 4?
So again, we're seeing a still shot of the previous video we just viewed, and then there's a zoom in function below that where it shows a cropped out photograph of a figure.
Okay. And you've seen this video yourself in person, sir?
Yes.
What do you recall about what you were able to observe about the figure or subject walking there behind the school?
Objection leading.
Overruled. The witness may answer.
The figure moves from right to left through the parking lot or north to south up until a fenced in, until it reaches the fence on the left side of the picture.
All right, next slide, please. Do you recognize the image in slide number 5?
Yes.
Or is it 6? It's 5, okay. Please tell us what you recognize this area to be.
This is also the Lindholm building. This is a camera that is deeper into the parking lot, which means that it will be a closer view of the previous video.
Okay. And, I'm going to ask that we play this clip, Your Honor, and for the record, it's a total of 20.81 seconds.
Go ahead.
Objection.
Your objection's noted. Go ahead and play.
Thank you. Please turn to the next slide. What do we see in slide number 6?
Upper left-hand corner is a still shot of the video, and below that is a screen capture of a figure in that photo.
Okay. Next slide, slide 7. So currently, we're looking at a black screen, correct?
Yes.
Do you know what this video is going to show, sir?
Objection speculative. He's black.
Overruled. The witness may answer if he's able.
Yes, it's another home security camera at 126 Central Avenue.
All right. It's a total of 20 seconds, 20.09 seconds. And we will play in its entirety, Your Honor. And with sound on this one, yes, thank you.
Excuse me.
All right, next slide, please. What do we see on this final slide, sir?
Upper left-hand corner is a still shot from the video, and the screen that's been cropped at the bottom is a image of the defendant.
All right. That completes Exhibit 131. Detective Rowe, based on these video clips that you obtained and the canvas that you and your team did in the neighborhood, were you able to put together a map basically tracking the travels of Darrell Brooks through the neighborhood that afternoon?
Objection. I don't consent to being called that name in this meeting.
The objections are noted. Overruled. The witness may answer.
Yes.
And I should include, do you know if, do you know the location where Darrell Brooks was arrested?
Objection.
Yeah.
I don't consent to being called that name in speculative.
Overruled. The witness may answer.
Yes, I'm aware he was arrested on Elizabeth Street.
Okay. And are you aware of reports to other officers as far as citizens that had contact with Mr. Brooks in the area of Elizabeth Street?
Objection. I don't consent to being called that name. Leave.
Noted. The witness may answer.
Yes, I'm aware.
All right. Behind you, sir, is a large poster board that's facing backwards. I'm going to ask you to please assist me by putting that face forward on the easel behind you.
Can you please tilt that so that the court and Mr. Brooks can see as well?
Yes, and we're also going to put up the digital copy, Your Honor. I just wanted to.
Oh, okay. Then that's fine then.
Okay.
Thank you.
I'll have him work off the digital copy, but before you sit down, Detective Rowe,
Sure.
in the bottom right-hand corner of that poster board, there is a sticker. Do you see that?
Yes, it is.
Objection. Leading.
Could you help us by telling us the exhibit number? I'm sorry.
That's okay. It's foundational. I'll allow the question to be asked. Go ahead and finish your question and answer.
What's the exhibit number, Detective Rowe?
130.
Okay.
Thank you.
Detective Rowe, do you believe that Exhibit 130 is an accurate summary of the travels and the contacts by Mr. Brooks on the evening of November 21, 2021?
Objection. I don't consent to being called that name.
Overruled. The witness may answer.
Yes.
Move to admit 130 and permission to publish, Your Honor.
Objection.
I'm sorry. I cut you off. What's the basis, if you have?
Relevancy.
All right. The objection is noted. It is overruled. Exhibit 130 is received. Permission to publish. An electronic copy is granted.
Thank you. All right. Detective Rowe, I know we're back out so we can see the whole map at this point. We will zoom in a moment, but the northern most event that's reflected on the map reads what?
Officer Skolton shoots at SUV at 4:39 p.m.
Okay, do you know that to be accurate based on your knowledge of this investigation?
Objection leading.
Overruled. The witness may answer.
Yes.
And then there appears to be a red line from that point going south down the middle or right side of the map. Do you see where I'm referring to, sir?
Objection
Yes, I do.
leading.
Overruled. It's foundational. The witness may answer.
Yes, I do.
What does that red line from the star where we noted Officer Skolton fired, the red line going south, what does that represent, sir?
The solid red line is the route taken by vehicle.
Okay. And where did it go? What roads?
Objection leading.
Overruled. Go ahead and answer.
Vehicle traveled south on Northwest Avenue, made a left-hand turn to go east onto Prospect Court. Vehicle then drove behind some residences on Maple Avenue before coming to a rest in the driveway of 338 Maple.
Okay, I'm gonna ask Ms. Gussie to please zoom in on that upper right-hand quadrant of the exhibit, please. And specifically the area of 338 Maple, please. Okay. So you said the vehicle traveled through the backyards off of Prospect Court, is that right?
Objection accident issue.
Sir, please wait until I rule on the objection. The objection is noted. It's overruled. Now you may answer.
Okay. Can you just, that's a touch screen in front of you, so just kind of point out the area that you're speaking of right now.
I'm sorry, could you repeat the question?
Yes. Using the touch screen, can you point out the path of the vehicle that you just were describing for us?
Objection leading.
Overruled. Go ahead.
And when it came down West Avenue, right?
Yes.
And what road did it turn onto?
Turned east onto Prospect Court.
And then when it turns off of Prospect Court, is that a road?
Objection leading.
I'm sorry, when it left Prospect, I'm sorry.
Sir, which question were you objecting to?
The last one.
About which way it turned? Or turning onto Prospect?
The way it was actually
You know what? I don't even remember what it was, so I'll sustain it and ask the state to re-ask.
Okay, sure. At some point, did the vehicle leave Prospect Court?
Yes, it did.
When it did that, was it on a roadway?
No.
So the line you drew south from Prospect Court represents what, sir?
Objection leading.
Overruled. The witness may answer.
Backyards?
On the far right corner of the map, do you see a blue dot in the same area we're talking about here?
Objection leading.
Overruled. The witness may answer.
Yes.
And what does that represent, please?
The camera at Les Paul School?
And what's the address of Les Paul School,
Objection.
if you know, or the
relevancy.
street?
Overruled. The witness may answer.
I don't know the address, but it is right off Maple.
Okay. And you see just below that, there's a yellow dot with the name Wauwatosa Officer Sailors. You see that?
I do.
Okay. Now, you've stopped drawing your line there, your yellow line over the red line. You see what I'm referring to?
Yes.
And in that area, I noticed the line becomes dashed. Do you see that?
Yes.
Objection leading.
Overruled. The witness may answer. Again, please wait until I rule on the objection.
Yes.
Thank you.
What's the difference between the red solid line and the dashed line, sir?
The dashed line is the path that the defendant took on foot.
Okay. And do you see then, moving back to the left on the map, the two boxes in white depicting where the sandals were recovered?
Objection, leading.
Overruled, the witness may answer.
Yes.
Is that consistent with your recollection, sir?
Yes.
The dashed line then moves, so there's two green X's, correct? You see where I'm referring to, sir?
Objection, leading.
Overruled, the witness may answer.
Yes.
And then the red dashed line moves to the left or west from the second green X, correct?
Yes.
What's going on at this point, sir?
This is a point where the defendant is traversing through yards towards the west.
Okay. And did we just see the video of him crossing the street there on Dunbar?
Objection, leading.
Overruled.
Yes.
Move up a little, please, or more to the back. Yep, there we go. Okay.
Clear the line, please, Madam Clerk. Thank you.
Is the Wyndham building on this map, sir?
Yes.
Could you point it out? Did we just see the two videos from those two cameras at the Wyndham building in the last exhibit, 131?
Objection, leading.
Overruled, the witness may answer.
Yes.
Okay. Keep going south on the map. What's the next event that's noted, sir?
Do you want, can we clear?
Yep, yes, clear, I'm sorry.
Thank
And
you.
maybe we can move further south on the map. Thank you.
So the first thing that I see is makes phone call at 4:47 p.m. Dominic Capron at 417 Central Avenue.
Okay, is that the location of Central Avenue, sir? I'm
Yes.
sorry, 417 Central Avenue?
Objection, leading.
Overruled, the witness may answer.
Yes, it is.
Okay. And are you aware of conversation also reported by Sean Backler at his residence on Central Avenue?
Yes.
Is his residence shown on the map, sir?
Yes.
Can you please circle these two conversations that you just identified for us?
Objection, leading.
Overruled, you may indicate on the map.
Okay. Now I see the dash line moving to the west again. Do you see that, sir?
Yes.
What's happening in this area, please?
Objection, speculative.
Overruled, the witness may answer.
This is the camera at 126 Central Avenue. Mr. Brooks is seen on camera moving to the west at 4:48 p.m.
Was that in Exhibit 131 that we just showed the jury?
Objection, leading.
Overruled, you may answer.
Yes.
Which video was that one? Do you remember?
Objection, leading.
Overruled, you may answer.
It was the, I believe it was the last video that we had watched prior to showing the map.
Okay. Now at this point, the dash line ends. Is that right?
That's correct.
Why is that?
Objection, speculative.
I'll allow the witness to give his opinion.
Because we don't have any indication as to where or when Mr. Brooks crossed West Avenue to get to Elizabeth Street.
Are you aware that there was a reported contact between Mr. Brooks and a witness identified as Aaron Cordes?
Objection, leading.
Overruled, the witness may answer.
Yes, I'm aware.
And is that area where that meeting occurred depicted on this map?
Yes, it is.
Where did that meeting occur?
It happened just west of Northwest Avenue on Elizabeth Street.
And is Aries Industries shown on this map, sir?
Yes, it is.
Could you identify Aries Industries? Are you aware of video from that location showing person appearing to be Mr. Brooks approaching the front door lobby of the business?
Objection, I don't consent to being called that name.
Noted, the witness may answer.
Speculative. Speculative.
Overruled, the witness may answer.
Yes.
Okay. And then finally, the last red X on the bottom left corner there, what does that depict, sir?
That depicts 553 Elizabeth Street, the location of arrest, which was at 5:14 p.m. And that is the residence of Daniel Ryder. And Mr. Brooks makes and receives a phone call at 5:03 to 5:05 p.m.
Do you believe this map is an accurate documentation of the investigation, again, as to the travel of Darrell Brooks this evening, on the evening of November 21?
Objection, speculative, and I don't consent to being called that name.
Your objections are noted, overruled, the witness may answer.
I'm sorry, can you repeat the question?
Sure. Do you believe this map is an accurate summary of the travel and whereabouts of Darrell Brooks at various points on the evening of November 21?
Objection, speculative, and I don't consent to being called that name.
Your objections are noted, they are overruled, the witness may answer.
Yes.
All right, thank you, Detective. I don't have any other questions.
Any cross-exam for this witness, sir?
Yep.
All right, thank you. Begin when you're ready.
So, Officer Rowe, you repeatedly referred to the alleged defendant's name. How did you come into that information?
Based on the entirety of the investigation.
And when did you come into the knowledge of the alleged defendant's name?
I don't remember.
When did your part of the investigation start?
After he drove the SUV through the parade, I was called at home to come in and help the departments with the investigation.
And just so we clear for the record, is the jury asking you questions or me?
I'm sorry, I did not hear the question. Repeat your question, please.
Well, I was referring to when I ask a question, he turns towards the jury as if they're the ones asking the question.
That's not a question, Your Honor. That's a
It is a
statement.
question.
We did ask a question about that.
Yes.
I think you're asking why does he do that? To that extent, the witness may answer.
I'm here to present the case to the jury.
So, I follow that fundamentally. But for the sake of making sure you hear the questions right, wouldn't it be fair to say that you should pay attention to the questions being answered, or being asked, rather?
Assumes the fact, not an evidence.
Sustained as to the form of the question. Please rephrase.
Wouldn't it make sense to focus on the questions so you can hear them clearly?
Objection, argumentative, still assumes the fact, not an evidence.
Sustained.
You made reference to you being here to present the case to the jury. So is that the reason why you decided to testify?
Objection to the relevance.
Grounds?
Overruled, the witness may answer.
I don't understand your question.
Were you able to hear my question clearly?
I don't understand your question.
Were you able to hear my question clearly?
Objection, argumentative, Your Honor.
Sustained. Next question, please. Or rephrase the previous question to the one that was asked just now.
What was not understood about the question that you were asked?
Objection, argumentative.
Grounds?
Sustained as to the form of the question. Please rephrase.
What wasn't clear about what I was asking?
Same objection, Your Honor.
Grounds.
The objection is sustained. Let's go back and ask the question that he says he didn't understand and rephrase it, please, or move on. Your choice.
Was your sole reason for testifying here today?
Objection, relevance.
Let's let Mr. Brooks get the question out. Go ahead.
Apologize, I thought that was it.
Are you testifying today strictly to prove your case to the jury?
Objection, misstatement of his testimony.
Grounds that that's what he said.
Sustained as to the form of the question, misstates the prior testimony.
That's what he said. So why did you decide to testify here today?
Objection, that's a legally inaccurate question, Your Honor.
Please rephrase the question. I'm sustaining the question asked as to the form of the question.
I don't know how I'm supposed to rephrase that. Without having the same form of the question. That helps.
I'll rule if there's an objection, but ask a question, please.
Did you seek to testify here today in this matter?
No.
So how did you ultimately come to that decision?
Objection, that's a misstatement, Your Honor. It was not his decision.
Sustained as to the form of the question assumes a fact, not an evidence.
Were you subpoenaed?
Yes.
Do you recall by whom you were subpoenaed to testify?
District Attorney Sue Opper from the Waukesha County District Attorney's Office.
And at that time you were subpoenaed, you decided to testify.
I don't believe it's my decision.
Well, it would be fair to say that you didn't have to show up, right? That'd be fair to say?
No, I had to show up.
But would it be fair to say that you could have chosen not to?
No, it would not be fair to say that.
Exhibit 131 that was shown to you. Have you seen that video footage before today?
Yes, I have.
Do you recall who showed it to you before today?
I don't recall who showed it to me.
Would it be fair to say you've seen it multiple times before today?
Yes, I've seen it a number of times.
And do you recall when you were first shown that video?
Not off the top of my head.
Was it the same day of the incident, the days following, sometime after?
I don't recall when I saw the video the first time.
And what about Exhibit 130? Had you seen that video footage before today?
Objection, Your Honor, 130 is the map.
Or the map? Have you seen the map before today? I don't really think it's...
Just for the record, I'll sustain the objection just because it referenced the wrong number, but I believe you rephrased. So go ahead, the witness may answer.
Can you ask the question again, please?
Had you seen the map of Exhibit 130 before today?
Yes, I have.
Multiple times as well?
Yes, numerous times.
Any idea why you viewed it so many times, multiple times?
Unsure.
Were you able to obtain any more information upon seeing the map numerous times that you didn't obtain when first seeing the map?
No.
So it would be fair to say you pretty much knew what the map was detailing each and every time you saw it.
Yes.
And on that map, Exhibit 130, you made reference to at some point the dotted line, and it stops at some point. That'd be fair to say?
Could you be more specific?
The dotted line that was referred to on the map.
Do you want the map brought up? Would that be helpful to you?
Or maybe might be helpful to him.
He's got the large map, but if you want to.
So, if you can see the dotted line on the map behind you,
Yes.
is it fair to say that the dotted line stops at some point? Around Central Avenue, maybe?
Yes, there's a couple lines that seem to come to Central Avenue or egress out of Central Avenue that do stop.
And you stated that, well, what was the reason that you stated that that line stops, the dotted line?
I stated that it's because we don't know the exact location where you cross the street to get over to Elizabeth Street.
And why, were there no cameras present at that point, or how did you lose the path of travel at that point?
We didn't find any cameras or any eyewitnesses in that area.
So it would be fair to say at that point you weren't sure what happened.
I know that you crossed the street at some point. We just don't know where.
How do you know that?
Because you were arrested on Elizabeth Street.
Did you see any crossing of, I think you said that was West? Would that be West Avenue that you were referring to, that you don't see any crossing of?
What's your question?
Is that West Avenue that you stated that you didn't see any crossing of?
That is Northwest Avenue.
Or Northwest Avenue, I'm sorry, I don't know the streets. Northwest Avenue. And you don't have any visual footage or any eyewitnesses, as you said, to say for sure if Northwest Avenue was crossed.
We didn't obtain any witness statements or any eyewitness or any video of the suspect crossing the street.
And what day were What day were you doing your part of the investigation? Was that the same evening or the next few days after the incident, or
Can you clarify which investigation you're talking about?
the one that you took part in? Your part of the investigation.
Are you, I don't understand what time frame you're asking for.
What day did you start your part of the investigation?
Well, we started the investigation as soon as he ran people over in the parade.
And you were there?
I responded to the parade after he had done that.
Were you at the parade?
No, I was not.
So it'd be fair to say you were on call.
No, I was not.
So it'd be fair to say you don't know when your part of the investigation started then, right?
It would not be fair to say that.
You don't recall what time it was when you started your part of the investigation?
As soon as I responded.
And you don't recall when you were dispatched to respond?
It's in my report. I don't remember the time exactly, but it's in my report.
And at that time, did you know the identity or name of any alleged suspects at that time that you were dispatched?
The time that I was sent to the city of Waukesha, I did not know the identity of the suspect.
You made reference to a report. Do you recall when you wrote that report, or did you write the report yourself?
Yes, I typically type my own reports.
And do you recall when you submitted that report?
I have no idea what day I submitted the report.
So when you were first dispatched, what did you do?
I drove to the city of Waukesha and met with members at the Waukesha Police Command Unit.
And were you dispatched to any location from that point?
I was not dispatched.
Were you sent to any location from that point?
I was assigned with taking a number of investigators with myself and walking the entire parade route, going from establishment to establishment, bar to bar, restaurant to restaurant, and obtaining phone numbers and names of people who were present at the parade and who had witnessed something and would be followed up with later by a member of the Detective Bureau.
So it would be fair to say you did some interviews at that time?
Yes.
Do you recall how many?
No.
And after conducting these interviews, what did you do?
I went home.
So at that time, after conducting your interviews and then going back to your home, did you have the name or ID of any suspects at that time?
Yes.
And whom were you told by?
I don't recall.
Do you recall who you submitted your typed report to?
I don't understand your question.
Do you recall who you submitted your typed police report to?
No?
I'm assuming your law enforcement agency doesn't type up reports and just leave them sitting on the desk. Would that be fair to say?
That'd be correct.
Any reason why you wouldn't recall who you gave your report to?
Well, it's electronically submitted.
And from there, does it have a specific sergeant or lieutenant or captain or someone that it goes to from that point? If you recall, or if you know?
I wouldn't know.
So it'd be fair to say, once you type a report and submit it, you're not sure who sees it.
Correct.
Would you say it's fair that because of you not knowing who your report is submitted to, that your report can be altered in some kind of way? Especially being that you don't know who sees it?
The reports are done via PDF style reporting. It's protected by my username and my password. And when it's submitted, it's usually not altered unless I request it to be altered.
But it is fair to say that there's a possibility that it could be tampered with because you don't know for sure who all sees it.
It's entirely inaccurate.
How so?
My report is accurate. My report is the way that it was written, the way that I wrote it myself.
So you've had a chance to read your submitted report after you submitted it?
Yes.
And to the best of your knowledge, is exactly word for word as you remember typing it?
It is my report. It is what I typed, and it is accurate.
Word for word?
Yes.
Do you recall how many pages long the report was?
Objection, relevance.
Grounds.
Sustained. Not relevant, please move on.
Do you recall if the report was lengthy?
Objection, relevance.
Grounds.
Sustained. Next question, please.
Grounds for the sustain?
Relevance.
And you stated that you read the report after you submitted it. Do you know how long it was before you were able to see the report that you typed?
Objection, relevance.
Grounds.
Sustained.
Well, he already answered that.
Then I'll object as asked and answered, Your Honor.
Sustained.
That question wasn't answered, but okay. I see. Do you recall when you typed your report?
Objection, relevance.
Grounds.
Sustained. Not relevant.
How's that not relevant if he already answered that he typed a report?
Please continue, sir.
Grounds for the sustain.
Relevance.
He answered that he typed a report. So how's it not relevant if he recalls when he typed it?
Please continue, sir.
Got to be kidding me. Did you file any claim related to this matter?
No.
Do you know if anyone who did?
Did what?
Do you know of anyone who filed a claim in relation to this incident?
No.
Do you know who the plaintiff is in this incident?
Objection,
Grounds.
relevance.
You may answer that question. Go ahead.
Can you ask the question again?
Do you know who the plaintiff is in this incident?
Well, plaintiff would be the state of Wisconsin.
Is the state of Wisconsin a human being or entity?
Objection,
Grounds.
argumentative.
Sustained on relevance grounds.
Have you ever had any interaction with the plaintiff in this incident?
Objection.
Grounds.
Relevant, legally inaccurate.
Grounds.
Sustained as to the form of the question.
Were you ever contacted by the plaintiff in this incident?
Same objection. Your
Grounds.
Honor.
Sustained as to the form of the question.
Would you call the state of Wisconsin a living, breathing human being or
Asked and
entity?
answered.
Grounds, because I didn't ask that question.
It's not relevant. Sustained. Next question.
It's very
please.
relevant. Seems like there's no plaintiff.
Jury will disregard statements made by
Come
the
on, man.
attorneys
Come on,
they,
man.
and
You're
the
trying to
parties.
be
They are
slick.
not evidence. Please
Stop
ask
trying to
a
be
question.
slick. So to your knowledge, the plaintiff is the state of Wisconsin. Do you see him present in the courtroom today?
Objection,
Grounds.
irrelevant.
Sustained.
Can you
relevance.
identify the plaintiff, state of Wisconsin?
Same objection.
Grounds.
Sustained. Sir, please continue with, and not on this topic. Next question, please.
To the best of your knowledge, you're not even sure if you've ever even had any interaction with the plaintiff, state of Wisconsin, correct?
Objection, argumentative, and compound.
Grounds.
Sustained.
Definitely wasn't compound. Would you consider yourself an injured party in this incident?
Objection,
Grounds.
argumentative.
The witness may answer.
No.
Have you read or seen the complaint?
No.
No further questions.
All right, thank you, sir. Any redirect?
No, thank you.
All right, thank you, sir. You may step down.
Detective Rowe should be dismissed, please. And yes, could we get the exhibit?
Yeah, why don't you grab that exhibit and take it? That one has the exhibit sticker, correct?
Yes.
All right, we can keep it by the state for now, and then later on it can be brought over to the clerk. All right, the state may call its next witness.
It's gonna call Dr. Ryan Schultz.
Good afternoon, sir. If you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and my clerk, Teresa, who's on my left, will swear you in. Do we need this easel up? No. All right. We're gonna have.
Yeah, or Detective Reglin can retrieve it.
Yes.
She's got it.
Thank you. Thank you. All right. Thank you, sir. Please remain standing. Raise your right hand.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Ryan Schultz, RyanSchultz.
Thank you. Go ahead, your witness.
Thank you. Sir, how are you employed?
I work for the Wisconsin State Patrol.
How long have you been in law enforcement?
I've been in law enforcement since 2014.
Have all those years been with the Wisconsin State Patrol?
Yes.
What is your current position?
My current position is the mechanical inspector for the Wisconsin State Patrol Technical Reconstruction Unit.
Can you describe the duties of that position?
Objection, relevancy.
Overruled. The witness may answer.
My job basically is to conduct thorough and systematic inspections of vehicles that have been involved in crashes. That can entail something as simple as taking photographs and looking at light bulbs to something more in depth, or actually take the vehicles apart and actually look at the moving parts of the vehicles.
Did you receive any training in order to perform those duties?
Objection, relevancy.
Overruled. The witness may answer.
Yes.
Can you briefly describe that training for the jury?
Objection, relevancy.
Overruled. The witness may answer.
A lot of the training that I received was on the job from prior inspectors. Prior to this, I was a diesel mechanic, and in addition to that, I have ASE and SAE certifications.
And not having any interest in cars, what are those certifications?
Objection, leading.
Overruled. Foundational. The witness may answer.
SAE is for the electrical components in a car, basically, for the part that I am certified in. ASE is for the mechanical components, which stands for the Automotive Service Excellence, is what I believe it stands for.
What is the purpose of a mechanical inspection?
The purpose of a mechanical inspection is to determine if there was anything that was incorrect, defective, or broken on a vehicle prior to the crash that would have caused the vehicle itself to cause or contribute to the crash.
On December 6, 2021, were you directed to go to the Wisconsin State Crime Lab to view a vehicle?
Objection, leading.
Overruled. The witness may answer. It's foundational. Go ahead.
Yes.
What information did you have prior to going to that location?
Objection, speculative.
Overruled. The witness may answer.
The information that I was given is that I was to set up an appointment there to look at a Ford Escape that had been involved in a crash in the parade in Waukesha.
Did you go to that location on that date?
Yes, I did.
Did you do a mechanical inspection of the vehicle that you were sent to look at?
Objection, leading.
Overruled. The witness may answer.
Yes, I did.
After performing your inspection, did you draft a report?
Yes, I did.
And did that report contain the findings of your mechanical inspection from December 6th?
Objection, leading.
Overruled. The witness may answer.
Yes.
I provided to you prior to you going up on the stand what's been marked as State's Exhibit 83. Do you have that in front of you?
Yes.
Can you briefly identify it for how it's labeled, how many pages it consists of?
What exhibit is that?
Exhibit 83.
It's the Crash Reconstruction Mechanical Inspection Report.
So the whole report is exhibit 83?
Correct.
Yes.
The whole report?
Go ahead. I haven't ruled on it yet, so go ahead and ask your questions, Attorney Gazy.
Sir, how many pages does this report consist of?
10.
And that is front and back sides?
Correct.
Objection.
Overruled. The witness may answer.
And on the face sheet of Exhibit 83, what information does it contain on that as it relates to this investigation?
At the top, it contains case number and recon number, which match my name, the reconstructionist, and then it begins the report and vehicle identification information, and then on the bottom, it's marked with exhibit number 83.
What car were you inspecting?
Objection, leading.
Overruled, the witness may answer.
2010 Ford Escape.
And what color was it?
Objection leading.
Overruled, you may answer.
Red.
And the license plate number associated with that vehicle?
A. Adam, D. David, P. Paul, 9256.
And on the report, the vehicle identification number on Exhibit 83, where did that information come from?
The vehicle identification number I verify on the inside of the door jamb of the vehicle. There's two VINs on each vehicle. One's a public VIN under the windshield and one is inside the door jamb of the vehicle. I always use the one inside the door jamb of the vehicle first, take note of it, and then cross-reference it with the public VIN on the vehicle to make sure that they both match.
And did they in this case?
Objection. I have the 10 pages and nowhere on here does it say exhibit. Nowhere on here.
That's because it was marked for purposes of trial. It has an exhibit sticker now. So your objection's noted, it's overruled, and the
Why am I
witness,
not privy to the same?
the witness may answer the question. It's been marked as an exhibit. Go ahead, sir.
Can you restate the question? I forgot what it was.
I think I did too, but let's go with this one. Is the VIN number that you saw on the door, you said that you cross-referenced it with the VIN number, public VIN number. Did you do that in this case?
Yes.
And did they match?
Yes.
Does it give a drivetrain description on that first page or front page?
Yes, it does.
And first of all, I don't know what that means, but what is that?
Objection leading.
Overruled. The witness may answer.
Drivetrain description describes the drive of the vehicle, basically how it's operated on the roadway. So in this case, it's an automatic transmission, doesn't have a clutch, you don't have to shift the gears, and it's front wheel drive, meaning that it's not all wheel drive or rear wheel drive like a pickup truck, it's just front wheel drive.
And is there a picture on the front of Exhibit 83?
Yes.
Objection leading.
Overruled. The witness may answer. Just a reminder to wait until I've ruled on any objection. Thank you.
Yes.
And what is that picture of?
It's a picture of the 2010 Escape.
That you did the mechanical inspection on?
Objection leading.
Overruled. The witness may answer.
Yes.
Have you authored this report?
I did.
Have you had a chance to review it since you've authored it?
Yes.
Is the information contained within this report accurate?
Objection leading.
Overruled. The witness may answer.
Yes, it is.
I would move State's Exhibit 83 into evidence.
Objection.
Your objection's noted. It is overruled. Exhibit 83 is received.
So is my paperwork ever gonna say exhibit 83, or is it just gonna be this?
Mr. Brooks, I'll take that up outside the presence of the jury later, but we're going to continue.
It
Go
was
ahead.
brought up in front of the jury.
Mr. Brooks, we're going to continue with the questioning of this witness.
What is y'all trying to pull up there?
Mr. Brooks, please.
This is
No
ridiculous.
one's,
No, please, nothing.
the exhibit, to my understanding, has previously been provided to you. You have it. It's now been marked as an exhibit for trial
Y'all got
purposes.
something I don't have though.
Go ahead.
That's not how it's supposed to work. It's supposed to be fair.
Attorney Basie, I trust that this was previously turned over.
It was, and I believe the defendant has a copy of it in front of him.
Thank
And
you.
where does
Please
it say
continue.
exhibit 83? It doesn't say that this was going
Again,
to be
we'll take
used
this
as
up
an
outside the
exhibit.
presence of the jury later. It's not something we need to do right now. Go ahead, ask your questions.
Thank you, Your Honor. And I would object and move to strike from the record any commentary that the defendant was making in the last 5 minutes.
What was that?
Court will strike the commentary that was made. I'm not sure if it was picked up or not, but as a reminder to the jurors, the statements made by parties and lawyers are not evidence. The testimony and other evidence that's received is the evidence the jury will ultimately consider. Go ahead.
Thank you. Sir, can you briefly describe the condition of the vehicle when you inspected it on December 6th?
Yeah, the vehicle had quite a bit of front end damage. The bumper cover was pushed back, the grille was pushed back into the engine bay and into the radiator. That was also pushed backwards in towards the engine. The hood was folded up in the air. Both lights were broken out of the front. There was quite a bit of debris and unknown things stuck to the exterior of the vehicle. And there was also some damage to the sides of the vehicle.
Do you know why you had to go to the Wisconsin State Crime Lab in order to do the inspection?
Objection leading.
Overruled, the witness may answer.
I was requested to go to the state crime lab to do the inspection because they had not yet completed DNA sampling. So until they had it finished, it was going to be retained inside the crime lab. So in the interest of not moving the vehicle again, once they were done with DNA, they had me come to the crime lab to do the testing and inspection.
So the first section of your report, and I'm just going to direct your attention to page 3 of Exhibit 83, talks about the tires and the suspension and tie rods. Do you see that?
Objection leading.
Overruled, the witness may answer.
Yes.
And can you describe for the jury what part of the inspection, describe this part of the inspection?
Objection leading.
Overruled, the witness may answer. The report's been received by the court, and the state may direct the witness to various points at its discretion.
When was it made an exhibit? Because I wasn't aware of that.
Go ahead, Attorney Basie. You may continue.
Thank you. Sir, can you describe the information contained in the first section of the report under the heading Tires, Wheels, Steering, Suspension, Brakes?
Objection leading.
Overruled, the witness may answer.
So under this section, it's broken down into 4 parts. One for axle 1 left, which is the driver's side front axle. The left side would refer to it as you're sitting in the vehicle facing forward. The right side would refer to the passenger side. So axle 1 is the frontmost axle, axle 2 is the rearmost, left and right, and it breaks each individual wheel end component systems down. And then from that, I take each one apart and inspect them thoroughly: brakes, tires, steering components on the front axle, obviously, suspension condition, and anything else that's at the wheel end that I can inspect.
And did you do that in this case?
Yes.
What observations did you make?
First, on axle 1 left, which would be the driver's side front, the tie rod end was worn. About 1/8 of an inch of play in the tie rod end, in the ball joint itself. So when you turn the steering wheel or turn the wheel, there was a little bit of play in the tie rod. Still attached, still intact, still functioning, still able to steer the vehicle, but just worn to the point that it needed replacement before it got any worse.
Was that something that would create any problems in operating the car, for example, on November 21st, 2021?
Objection speculative.
Overruled, this witness may answer. Hold on, he's been qualified under 907-02. I direct your attention to 907-02 through 907-07, Mr. Brooks. Go ahead.
I don't consent to being called that name, and that's referring to a specific date. How do we know that's not speculation?
The objection's noted, it's overruled, the witness may answer.
It would not. The vehicle would still steer and drive just the same as any other vehicle. It would just have play in the steering wheel, and it would make a little bit of a clunking noise potentially when you turn the wheel. You would maybe hear a clunking noise from that left front tie rod.
Again, operationally, the person driving that car wouldn't have any trouble steering based upon that issue?
Not at all.
Okay. What other observations did you make?
Other observations I made were that all the tires were evenly worn on all 4 axle ends. I believe it was the left rear, the left rear axle, the tire on that axle was bigger than the other 3. So there's also a chart referenced later in my report that shows the difference between the 2. The tires that are recommended to be on the vehicle are size 235/70 R16, which was what was equipped on the vehicle, except on the left rear, which was 245/75 R16, which is one full size bigger in dimension and aspect ratio.
What, if any, impact would that have on how a person's ability to drive that vehicle?
So one size bigger in tire is usually not the end of the world, being that it's the single tire, it can have an effect, but it's on the rear of the vehicle. Being a front wheel drive vehicle, the speeds are reported off of the front axle of that vehicle. So that's where the speedometer would get its speeds from. The only time it would be notable would be during a heavy ABS brake application, and that would be at a higher rate of speed with full brake application where the ABS system kicks in on the vehicle. That's where it could be noticeable, and by could be, I mean the sizes are very similar. They're about 1.5 inches in difference. Revolutions per mile are not that far apart. The ABS system might not even pick up a difference between the two.
When you say at higher speeds, are we talking, what are we talking?
Higher
Leading.
Overruled, the witness may answer.
Higher speeds, I mean something like highway speeds, 55 miles an hour, 70 miles an hour or greater.
Any other observations made with regard to in that area?
The only other observations that I made were that all the brakes were in good working condition and had adequate thickness left on the brake pads for stopping of the vehicle. All 4 brakes were in good working shape and they were able to be locked at the time of inspection.
So, and let me clarify if I didn't ask you this. The information you were provided was that this vehicle was involved in a crash?
Objection, asked and answered.
Overruled, given the nature of the testimony being provided, the state may clarify that. So go ahead, you may answer.
Yes.
And do you know the date of that crash?
I know it was in November. I don't know the exact date.
Okay, thank you. So with regards to the braking system, was there anything, did you find anything at all in your inspection of that vehicle that would have caused the brakes not to work or not to work effectively on the date of the crash or prior to the crash?
Objection, speculative.
Overruled, the witness may answer.
No, I did not.
Actually, since your inspection took place after the crash, would that be your same answer with regard to, as it was on December 6, 2021, there were no brake problems?
Objection, speculative.
Overruled, the witness may answer.
That is correct. The brakes still functioned at the time of inspection fully.
Thank you. What was the next area that you then inspected?
The next area that I inspected was the electronic system and general cabin system of the vehicle, cabin being where the occupants sit inside of the vehicle. I did that by examining light bulbs on the exterior of the vehicle and then systematically working my way into the vehicle where I could.
What observations did you make in that area?
Both headlights were, the lenses were damaged, but the lights were still working. The lights were in the high beam position and in the automatic position from the driver's cabin.
What does that indicate?
Objection, leading.
Overruled, the witness may answer.
So that indicates that when the vehicle was left at the last time, that the vehicle headlights were in the automatic position, meaning that if it's dark enough out, that the headlights would turn themselves on, and the selector stick was in the high beam position, meaning that the last time the lights were in use, they were in high beam mode.
Thank you. Continue on.
From there, just examine the throttle linkage, horn, and the other driver controls from inside the cabin.
So let's talk about the throttle controls. First of all, what is that?
So
Leading.
everyone's,
Objection.
Overruled, the witness may answer.
everyone's familiar with the throttle pedal in the vehicle. You press the pedal, and it makes the vehicle accelerate. From there, on this specific vehicle, it's an electronic signal that is transferred from the throttle pedal to the throttle body on the vehicle's engine on the intake. That electrical signal opens a butterfly valve, which allows more air and fuel into the engine, speeds the engine up. If you let off the throttle, it reduces and closes that valve. On this particular vehicle, I checked the throttle pedal first inside the cab. It was free moving, no binding, no obstructions. I was able to smoothly press it to the floor and release it, and it acted just as it should. From there, I went under the hood of the vehicle. On this particular vehicle, the crime lab asked that I did not open the hood just because of the amount of DNA evidence on the front of the vehicle. They didn't want me to come in contact with anything, so they asked that I not open the hood if at all possible, which on this vehicle, I was able to still access the throttle because of the way the hood was bent up in the air. I was able to actually reach in from the side of the vehicle and access the throttle body components through the damaged hood portion where I normally would not have been able to reach. From there, I was able to look at the exterior of the throttle, and everything was in clean, clear working condition, no visible damage, no visible issues. I removed the intake tubing from the engine and inspected the actual throttle plate itself, which was in the closed position. Closed position indicates either an idle or that the vehicle is turned off. I was able to then actuate the butterfly valve itself from fully closed to fully open, and when I released it, it went back to fully closed just as designed by Ford.
Did there appear to be any problems with the throttle?
No, there was not.
I'm just gonna, I know you call it a throttle, I call it a gas pedal, it's one and the same, correct?
Objection leading.
Sustained as to the form of the question. Please rephrase.
What is the difference between a gas pedal and a throttle?
Nothing.
Thank you. What was your next area?
The next area I went on to was the seat belts inside the vehicle. And then from there, I actually was able to test the vehicle for function.
Did you then come to a conclusion section of your report?
I did.
And is that starting on page 5 of 10?
Yes.
Okay. Did you check the power steering system?
I did.
And what observations did you make of that?
Aside from the ball joint that was loose that I described earlier, the entire rest of the power steering system was intact and functioning properly.
So there are no problems that would cause the car not to steer appropriately?
Objection leading.
Sustained as to the form of the question. Please rephrase.
Did you observe any problems with regard to the steering?
Aside from the ball joint, no.
Thank you. Now, in your report, you indicate a gross vehicle weight rating. Do you see that on page 5 of 10?
Objection relevancy.
Overruled. The witness may answer.
Yes, I do.
What is that?
The gross vehicle weight rating is the amount of weight that the vehicle can physically carry safely, and that number is administered by the manufacturer.
So that includes people within that car, is that what you're saying?
Objection speculative.
Overruled. The witness may answer based upon his training and experience.
Yes, that would include all vehicle, the vehicle weight, occupants, and cargo.
And the curb weight, what is that? I mean, generally, what is it now?
Objection leading.
Overruled. The witness may answer based upon his training and experience.
The curb weight of the vehicle is the weight of the vehicle as it rolls off the floor at the assembly plant. And that's without fuel and coolant and oil and things like that. And it's a dry weight of the vehicle. It's what the vehicle itself with nothing in it physically weighs.
Thank you. If someone had reported hearing a clicking sound while this car was driving in front of them, was there anything that you found in your report that would be consistent with a clicking sound being heard?
Objection, hearsay.
Overruled, the witness may answer.
There was a lot of damage to the front of the vehicle. It would be impossible to say what a clicking noise could come from, being as there's a lot of moving components under the hood with the belt pulley, the engine fan, things like that. Anything could be stuck in a tire. It would be impossible to say if there would be a clicking noise from this vehicle. I was actually not able to drive it physically to test it. I was only able to just start it.
Can I ask why you were unable to drive it?
Objection, relevancy.
Overruled, the witness may answer.
There's actually two reasons I was unable to drive it. One, again, with DNA evidence on the exterior of the vehicle. Two, there wasn't enough gas in the vehicle to move it.
Okay. So the car was on empty when you observed it?
Objection, leading.
Sustained as to the form of the question.
How much gas was in the car when you inspected it?
Objection, leading. Answer.
Overruled, the witness may answer.
There was, the gauge read E for empty, and the notation on the infotainment center originally said 2 miles to empty, and then on the second key cycle it said 1 mile to empty.
When you said key cycle, when you started it, or when you turned the key, what observations, if any, did you make?
Objection, leading.
Overruled, the witness may answer.
So when I tried to start the vehicle, it was very sluggish. It turned over, but it wouldn't fire, it wouldn't do anything. And then it made like a hiccup sound, like it was going to try to start, mimicking basically a vehicle that's out of fuel. And when I tried turning the key again, then the vehicle actually did start, did idle, and did run like it was supposed to. That's when I saw that the fuel gauge, the distance to empty gauge, went from 2 miles to 1 mile, indicating that the vehicle was very much so out of fuel almost. And I recorded this with my camera, and I tapped the throttle to do a rev test on the engine. The engine revved and went back to an idle. When it went back to an idle the second time, it then sputtered and turned off.
Which would indicate what?
It would indicate that it's not getting enough fuel to run correctly.
Thank you. Now, if a witness had testified that when the vehicle went in front of them, they heard a high-pitched, like a revving sound, based upon your examination, what would that be consistent with?
Objection, hearsay.
Overruled, the witness may answer.
There's a lot of different things that could cause that. It could be heavy acceleration from someone pressing the throttle on the vehicle. It could be noise that is amplified because the engine bay is now open to the exterior, so you can hear the engine noises coming from the engine bay of the vehicle. It could be an exhaust-related item. It could be a lot of different things, to be honest.
When you were doing an examination of the undercarriage of the vehicle, did you observe a muffler?
No, I did not.
I want to show you what's been previously admitted, Exhibit 73. It'll show on the screen in front of you, and I'd ask that it be published as well.
Objection, leading.
Overruled. Permission to publish 73.
Sir, do you see the picture that's marked Exhibit 73? It's not actually marked, but it is Exhibit 73.
I do.
What is depicted in that photograph?
Objection, speculative.
Overruled based on his training and experience. The witness may answer.
That it appears to be an exhaust muffler and a couple chunks of wood and overturned dirt.
The muffler that's observed in this picture, would that be consistent or inconsistent with a 2010 Ford Escape?
Objection, speculative.
Overruled. This witness may answer and provide an opinion. Go ahead.
By just looking at a picture.
Overruled. The witness may answer.
Yeah, y'all think y'all
You can cross-examine the witness about that, sir.
I
Go
don't
ahead.
got to. Y'all trying to pull a fast one.
It is a vehicle muffler. Without seeing the ends of it and where the inlet, outlet are, and actual measurements, it would be impossible to see what vehicle it came from, but it is an automotive muffler.
And sir, at the end of your inspection, do you come to a conclusion with regard to the mechanical fitness of this vehicle?
I do.
And what was that conclusion?
My conclusion was that the tie rod on the left front end of the vehicle that's responsible for steering, the joint was worn and had been worn prior to the crash. This is not something that just happens immediately or overnight. If it would have been due to crash damage that this was damaged, I would expect to have seen a lot more impact in that area with bent metal or distorted items. The tie rods are very tough parts, so that to me indicates that it was worn prior to the crash occurring, and the tire, obviously unless somebody changed it in between the crash occurring and my inspection, the tire was a different size than the other three prior to the crash, and it had been driven like that. I did not see any issues from the tie rod affecting steering as far as it relates to the alignment of the vehicle. Once things are worn and they start to get excessively worn, they manifest themselves in incorrect tire wear. A tire might chop or feather. That was not present on this vehicle. Had the left rear tire been an issue on the vehicle, I would have expected to see that manifest itself in an ABS, which is an anti-lock brake system failure or a trouble code in the vehicle. When I ran the vehicle and with the key in the ignition in the on position, there were no diagnostic trouble codes present on this vehicle indicating any issue whatsoever.
And two things that I guess I need to cover. Do you check to see if there are any recalls in a vehicle in coming to your conclusion?
Objection, speculative, and do we still need this exhibit?
Thank you. We can take that down, and your objection's noted. It's overruled. The witness may answer.
I do check for recalls, yes.
Were there any on this vehicle?
There were not recalls on this vehicle. There was only an extended service warranty from Ford, which had since elapsed due to the mileage on the vehicle.
Now, you talked about the brake system in terms of the brake pedal within the car and its that it was operating correctly. Do you recall that testimony?
Objection, leading.
Overruled. It's foundational. The witness may answer.
Yes, I do.
Now, when a person activates that brake pedal, what is happening within the car?
There's actually a lot of things that happen within the car when you activate the brake pedal. When you press the brake pedal, it pushes on it's called a push rod, but it actually pulls on it. It pulls on the rod, which goes into the brake master cylinder, and that master cylinder is what pumps hydraulic fluid from the brake fluid reservoir to each independent wheel. On this vehicle, it's equipped with anti-lock brakes. It goes through an ABS modulator first. From there, it sends a signal out to stop or slow down, depending on the amount of pressure that you apply inside the cab. Depends on how much braking force you get at the wheel ends. In a very heavy brake application, as I had discussed before, where the vehicle is still trying to maintain momentum, the ABS system can override, and that's where you would get the vibration in the pedal that many of you may have felt before. That's your ABS system doing its job, not allowing the wheels to lock themselves up. What it's actually doing is pulsating the fluid in the vehicle.
And when you talk about brake pads, how do the brake pads, where are they located, and how do they relate to the pressing down of a brake pedal?
Objection, leading.
Overruled. The witness may answer.
So when the brake fluid reaches each wheel end, there's a set of calipers with pistons, and those pistons actually come out and they act like a clamp, and they squeeze the two brake pads together. They're located between the two sides of the piston and on the exterior of the brake rotor, and what that does is it creates a pinching motion, and that pinching motion slows the rotation of the disc down, which is the brake disc, which is attached to the wheel hub. And that's what slows the vehicle.
And just for the record, he was using his right hand to demonstrate kind of a squeezing motion. He had it, and I would describe his hand in a C motion, maybe 3 to 4 inches between the thumb and the fingers, and then pressing together a couple of inches.
Thank you. Are there any other components to the braking system in a car?
Objection, leading.
Overruled.
There's a parking brake system in the vehicle.
But other than that, so you've covered every aspect of the braking system in this particular vehicle, is that correct?
Objection, speculative.
Overruled. The witness may answer.
Yes, I have.
Did you observe anything at all that would have prohibited this vehicle from stopping if the brake pedal had been applied?
No.
Is there anything that you observed or documented with it during or in your mechanical inspection report that would have contributed to the crashes that this car was involved in?
Objection, as an answer.
Overruled, the witness may answer.
No.
Thank you.
All right, thank you. Any cross-exams?
During your inspection, did you see any bullet holes?
Yes, I did.
Do you recall where? Back up. Do you recall how many bullet holes you observed?
I do not recall a number of them. No, I knew there were more than one.
The ones that you observed, do you recall where they were?
I do believe one might have exited through either the windshield or rear window, and one was in the side of the vehicle, if I remember correctly.
And did you find any shell casings?
No, I did not.
And you said you did the inspection on December 6th?
That's correct.
Do you know if the vehicle had been do you know if anyone attempted to start the vehicle in between that time of the crash and your inspection?
Not to my knowledge, no.
But you don't know for sure?
That's correct.
You made reference to the left rear tire being bigger than the other tires.
Yes.
Can you give a little bit more clarity on how that would affect the vehicle?
So one larger tire on the vehicle would obviously make the vehicle lean ever so slightly away from whichever side is larger than the other. In this case, the amount of difference between the two tires, it's about 1.5 inches in difference in radius. So in radius, you get half of that amount in height. So it would be about 3/4 of an inch difference in height. That amount of difference is not noticeable in a vehicle. The other thing that it would cause is premature tire wear from one side to the other over time, to where one tire might wear faster than the other. The suspension might not act correctly because it's not at the same ride height anymore. So eventually over time, those are things I would expect to potentially see from that. Each vehicle acts differently with different size tires on it. There's no one size fits all.
So different vehicles act differently to having a bigger fitting tire.
Yes.
You made reference to it to a vehicle leaning away from the side that's bigger.
Correct.
Would that in any way create a slight pull to the vehicle, to either side?
In my experience, that small amount would not, no.
And you made reference to the high beams. I don't remember exactly what you said referring to the high beams. I guess you made reference to them being used at some point.
The high beams were activated when I did my inspection, meaning that when the headlights are on, they were in high beam mode. The selector stick was pressed forward for the high beams.
And why would a vehicle use high beams?
Usually a driver uses high beams to see better or to illuminate things better.
So that would primarily refer to if it was nighttime?
Correct.
Would you say, with your expertise, it wouldn't make sense for a vehicle to use high beams in the daytime?
There are limited uses for them in the daytime, yes.
And what are some of the uses from your knowledge?
Generally, the high beams shine brighter, so even with sunlight shining on them, other vehicles can see them. It's a thing that we use on the highway as law enforcement sometimes. We'll use the high beams at a crash scene. We'll turn the high beams on so oncoming traffic coming in during the daytime sees that brighter light from the vehicle. It's just a little bit of the thing to help oncoming vehicles see.
So it would essentially be for identification purposes?
Not so much for identification, no.
Well, what do you mean when you refer to for oncoming traffic to be able to?
More for visibility is what I mean, so that it stands out to the other traffic. It doesn't look like it belongs because the lights look very bright. It gets the other driver's attention, the same as the red and blue lights on the top of the cars.
Gets them to notice that law enforcement is present.
Correct.
That's what I meant by ID purpose, for them to be able to see.
Then yes.
Were you able to inspect the entire engine?
I was not able to inspect the entire engine.
And what parts of the engine were you not able to inspect?
The only parts that I was unable to inspect would be down in the front by the belt pulleys area. I could see that the radiator was pushed into it, but I couldn't see what components had been damaged by that, as far as like water pump or anything like that. And I do not usually take the engines down, meaning I don't take them apart as part of my inspection anyways. My main under the hood inspection components would be non-engine related aside from the throttle.
You made reference to the water pump. Did you notice any water leaking?
Yes, there was coolant that had leaked from the vehicle.
From the water pump?
I don't know where it actually had leaked from, but I know that there was a lack of coolant in the vehicle. It could have come from a lot of various different places. It was no longer leaking when I saw it. It was empty.
So you didn't actually observe it leaking?
Correct.
So it'd be fair to say you don't know where the leaking came from?
That's correct.
Were you told that the vehicle was leaking?
No, it just has a low coolant level, meaning it leaked from someplace, or it had never been filled properly.
So at that time, it'd be fair to say you weren't sure if it had been filled properly or if it was leaking?
Either is possible.
But it'd be fair to say you didn't know for sure which of the two?
Correct.
You made reference to a loose ball joint. Can you give a little bit more clarity on exactly what is a ball joint?
So the ball joint is at the wheel end. When you turn your steering wheel in your vehicle, there's a shaft attached to the wheel. It goes down to a rack and pinion system. The pinion is a round gear. The rack is a flat piece of metal with gear teeth on it. As you turn, it pushes the tie rods left and right. As you turn left and right, On the end of each of those tie rods is a ball and socket joint, much like the hip joint on a human being. It's a ball that fits inside of a socket, and what that does is it allows the wheel to turn left and right as it's being pushed by the tie rod without any binding or any issues in between.
That is clarity. I don't know anything about cars, so. And you said there was a loose ball joint?
Yes, the left front was loose.
And to what effect could that affect the vehicle?
The amount that it was loose, it would only wear more with more use. As those components start to wear down, they start to have a little play. The longer the vehicle is operated without proper repairs, the worse the play gets. The worse the play gets, then you can start having issues with improper tire wear and so on and so forth, until it gets to the point that it actually separates. The ball and socket themselves will separate from each other.
And then what happens at that point?
If the ball and socket joints separate, you would lose steering at that wheel. The other wheel would still be able to steer.
From your inspection, can you tell roughly how long this loose or this ball joint was loose?
I cannot tell exactly how long, no. I can say that it was loose before the crash occurred, just based on the fact that it was worn, not broken.
So with your expertise, would it be fair to say that needed to be taken care of?
Yes, that needed to be corrected.
And you made reference to the gas. The vehicle having difficulty starting. Would that be fair to say?
Yes.
And reference to the axles, you made reference to taking them off the vehicle?
The axle I do not take off of the vehicle at all.
What did you do in regards to the axle?
The axle ends, wheel ends, that's where the brake components are mounted. So I remove the wheel and tire from the actual axle end.
I think that's what I was referring to.
Okay.
I'm sorry if I misquoted. I know you made some reference to removing something. I just assumed you meant the axle. When you inspect the axle and remove, you said the wheel?
Yes.
What is being expected at that point?
So when I remove the wheel and tire from the vehicle, I remove all four of them one at a time. And that's where I actually look at the brake components themselves, being the brake pads, the brake calipers, pistons inside the caliper, brake rotors, and then I get a better view of the tie rod that I was just speaking about, because it's actually next to the wheel on the axle end of the vehicle.
You said the tire rod?
The tie rod, ball joint that was loose.
Oh, okay. So what, I think you just were clear about the ball joint and tire rod. Is there a difference between the two?
Yes, the ball joint is the joint itself, and it's on the end of the tie rod.
Did you notice anything wrong with the tire rod? the actual tie rod, not the ball joint?
No, there was nothing wrong with the tie rod.
Just 1 second, I'm just looking over these notes.
Go ahead.
On page 9 of your report, and you did give some clarity to this. I'm just curious to know, on page 9, well, first of all, you wrote this report yourself, correct?
Yes.
On page 9, the second sentence, I'm assuming you still have the exhibit 83.
Yes, sir.
It says, I noted a worn tie rod end on the left front wheel end. Was that in reference to the ball joint and not the tie rod?
Yes. They're one and the same. The tie rod end is a ball joint. It's two different ways to refer to the same component.
Okay, clarity. It doesn't say ball joint right here. Would that be fair to say?
Correct.
And what is the high mount brake lamp?
The high mount brake lamp is on the back of the vehicle. You have the right brake light and turn signal, left brake light and turn signal, and then there's the third brake light that's like usually in the rear window or at the top of the back of the hatch of the vehicle. That's the high mount brake lamp.
Okay. And it was inoperable when you inspected it?
That's correct. Both of those were inoperable during inspection.
So they didn't work?
Correct.
So it'd be fair to say if someone was viewing the vehicle from behind, they would be able to see because those were inoperable?
Yes, at the time of inspection, those lights did not work.
And you also stated that it is unknown if they were working prior to the crash or damaged during the crash. That'd be fair to say?
That's correct.
That you would know either way?
No, I would not have a way to tell when that light bulb went out.
No further questions.
All right, thank you. Any redirect? Before you do that, I'm just gonna have my jury stand for a second. Go ahead. You can stand here. All right, thank you. Be seated. Go ahead.
So you testified on cross-examination that the right and high mount brake lamp were inoperable. Do you recall that?
Yes.
How about the left brake lamp? Was that operable or inoperable?
Objection. Leading.
Overruled. The witness may answer.
The left stop lamp was working.
Now, sir, just going back again to this ball joint, you stated that, I guess, was your testimony and cross-examination that unless the ball and socket is separated, you can still safely operate that vehicle?
Objection. Mischaracterizes what was said.
Based on the form of the question, I'll allow the witness to answer.
Yes.
And the ball and the socket on this vehicle, were they separated?
They were not.
Thank you. Now, your inability to fully inspect the engine, I want to direct you to that area of the vehicle. Does the engine control acceleration?
Objection. Relevancy.
Overruled. The witness may answer.
No, it requires driver input.
Does the engine control braking?
No, it does not.
Does the engine control steering?
Objection. What is the relevancy?
Overruled. The witness may answer.
No, it does not.
Does the engine control gear shifting?
Objection. Relevancy.
Overruled. The witness may answer.
It does not.
Finally, sir, you had talked about actually coolant or some type of water. I wasn't sure if you're talking about the water pump or the radiator. Do you know what was leaking, if anything?
Objection. Asked and answered during cross.
Overruled. The witness may answer. It's redirect.
Yes, so water pump, water coolant, it's all interchangeable as far as the cooling system for the engine goes. And the coolant system was low at the time of inspection and had been leaking, but from where, I do not know.
And again, does that control the steering,
No,
the braking,
no,
the acceleration?
no.
Finally, sir, you had talked about on cross-examination the presence of the high beams being on during the daylight. Do you recall that line of questioning?
Yes,
Specifically, you had indicated that sometimes the state patrol uses their high beams during the day. What was that for?
Objection. That was answered.
Overruled. The witness may answer. It's redirect.
to increase visibility.
Is that of any assistance if a vehicle is coming up behind people?
Objection. Speculative.
Based on his training and experience, I will allow him to answer.
No.
Thank you. Nothing further.
All right, thank you. You may step down. I will take that. Thank you, sir. And once the witness passes, I'll excuse the jury for an afternoon break. It's just about 3:06. We'll take about 15 minutes. I'll rise for the jury. You can be seated. Mr. Brooks, I know the last thing you said, I heard you say that's hilarious. What were you referring to?
I was referring to, like, are you serious? Some of the same things that I ask on when it's my time to question the witness can be overruled. But when the same thing is done and I object, it's nothing. It's just thrown. It's just thrown to the side. I just think that's funny.
Well,
I
sir,
really
I
do.
don't find it funny, number one. Number two,
You're not in my position either.
The court rules on the objections at the time that the objections are made. I know, and I wanted to address this briefly. You can have a seat. You had questioned during the testimony of this witness, Exhibit 83, because I believe what you were saying is, and you can tell me if I'm wrong on this, the copy of the report you have does not have an exhibit sticker on it.
It don't.
Right, and
You want to see it?
I don't doubt that your copy does not have an exhibit sticker, because at the time the report was provided to you, and I'll have the state correct me if I'm wrong on this, it would have been provided through the course of discovery. I'd also note that on April, I believe 22nd of 2022, the state filed a notice of expert naming Inspector Ryan Schultz as an expert witness and indicated that he would testify consistent with his report. And then I directed your attention to the statutes in the rules of evidence dealing with expert testimony, specifically starting at 907.02 through 907.07. That is why I didn't stop during the testimony to have a discussion outside the presence of the jury, because at that point, the objection to not having an exhibit sticker on your report is not, would not prevent the court from receiving the exhibit once the proper foundation was laid, which in my opinion it was. And the fact that your document didn't have that specific exhibit sticker doesn't diminish the fact that I know from your cross-examination you were referring to the report. At times you referred to it by page number. It was clear from your questioning that you had reviewed it. I would just note two examples. You asked some questions regarding visibility and the impact of the high beams. That was one example. And then secondly, questioning him about the ball joint and whether it needed attention and what that would mean. And so I just wanted to
That didn't
make
come from the report, Your Honor. The
a
only
record
thing
of
that
that.
came from the report was from page 9, when I was trying to get clarity about why it said worn tie rod.
Oh, and you actually questioned the
And-
witness about the different tire and what that would mean. So I thought three good areas of cross-examination that you covered. As far as the other issues I think that you might have when there's redirect, I'm not going to explain what redirect is, sir, but again, for my position, there's direct examination, there's cross-examination. The state or any witness, any party that calls a witness always has the opportunity to ask the direct exam questions and then redirect based upon what's asked during cross-examination. Sometimes that does mean there's some repetition, but I didn't see anything through the redirect of this witness that I thought was improper. So I just wanted to make a record of that. I am going to caution you, sir.
Do you understand what I was saying?
But you, during multiple times during the questioning of that witness, you were mumbling under your breath. You say disparaging remarks toward the court, toward the witness, or toward the process.
So if it was disparaging, what did I say?
Sir,
Because
you
I don't-
say things like it's not fair, or you make noises that suggest like you're disgusted with the ruling that is made.
So you're assuming what I mean by that, and when did I say
Mr.
it
Brooks,
wasn't
I'm
fair?
just making a record
Yeah,
because
but
it's
you're making
important
an
that
incorrect record.
it's important that you demonstrate courtesy and decorum through these proceedings, and that you give respect to the witnesses who are testifying in the process.
Did
As
the
you-
witness feel disrespected? Did the witness say anything about feeling
Mr.
disrespected?
Brooks, I'm not gonna engage in this
'Cause I don't think he
back and
did.
forth with you, because first of all, it's a mischaracterization of my observations, number one, and
Yeah,
number
but
two,
your
it's my
observations are
job.
incorrect.
It's
If
my
it-
job to ensure that under 90611, that there's the effective presentation, and I'll just refer you to that once again. I'll read it into the record.
You don't need to read it.
Under
You don't need to
906
read it. Just make sure that you make a correct
the judge shall exercise
record.
reasonable
Don't lie on the
control over the mode and order of interrogating witnesses and presenting evidence so
gonna
as
get
to do
addressed
all of
every
the
time.
following. Make the interrogation and presentation
Every time.
effective for the ascertainment of truth, avoid needless consumption of time, protect witnesses from harassment or undue embarrassment. Sub 2 talks about the scope of cross-examination. Sub 3 talks about leading questions, and when leading questions may be used to develop the witness's testimony. So with that, we'll take our break. I'll start the 15 minutes. It's 3:13. We are in recess. Thank you.
Madam Chair, one thing on record?
Go ahead.
Okay. I did actually take note of when the court overruled one of Mr. Brooks' objections, his
don't
response
consent to being
was,
called that name,
stop
Your Honor."
trying to be slick.
Yep, I did say that.
So,
Alright.
just for the record, I thought that that was very disrespectful.
Thank you. I would agree.
Judge, can we discuss scheduling at some point as well, either now or on the
When
return?
we come back.
Why wasn't that addressed right when it happened?
Honestly, Mr. Brooks, I'm really trying hard not
Because
to
that's
highlight
the
your
definition of trying to
misconduct
be slick.
during the trial. I'm trying my best here to
I don't see
frankly
that.
minimize
I don't
pointing
see
those
it.
things out to the jury and instead pointing
don't
them
see it.
out outside the presence of the jury. You may have noticed I've even started to say I'd remind the jurors that the comments of the parties or the attorneys are not evidence, so as to cast a broad brush and not simply highlight your conduct.
I haven't noticed anything, and I don't
But all right, we're in
refer to
recess.
what
Thank you.
conduct
It's
you referring
3:14.
to. If you're gonna be biased, then somebody.
Thank you. Please be seated. We'll go back on the record. Do you want to talk scheduling?
Yes, Your Honor, thank you.
Go ahead.
And thank you for a little extra time here. I spoke with the defendant about his witnesses for tomorrow, and I believe he's filling out the paper that I asked him to so we can get his witnesses here. I can tell the court this. I have 2 crime lab analysts to testify yet this afternoon. They're both here. One's, the next one is from the Milwaukee lab, the second one's from the Madison lab. So if we could complete their testimony today, it would be greatly appreciated. I don't know how late you intend to go today or how long it will take, but I'm being optimistic. Our final witness would be a recall of Detective Casey briefly for some follow-up matters. And then we would be in a position to rest. I don't hold out hope that we'll probably be able to rest yet this evening, but maybe, depending on how late you go and how smooth things move along.
All right, thank you. I appreciate that information, and I appreciate the parties discussing off the record some of the issues related to the defense witnesses, so that's great to hear. I can go a little bit later tonight, and I would say no later than 6, but if need be, if we can get through those 2 witnesses and Detective Casey, that would be great. But let's see how we go.
Okay, thank you.
All right, sir, did you have anything?
Yes, I do. Detective Casey already testified. What would be the significance of him testifying again?
Well, let's take that up later. I want to deal with the lab analysts who are here first and not delay their testimony any further. So, other than that issue, do you have anything else?
Yeah, I thought he was released from his subpoena. At least that was my guess.
I honestly don't recall whether that question was asked of me. I know he's the court officer and he's been here. I'd have to take a look at the record from when he testified and see if there was any reservation or have the state make an offer of proof, and we can go from there, but I'm not going to do that right now. I want to have those lab analysts testify they're here, and we can take up more fully the issue with Detective Casey after they're done testifying.
So how late do we plan on going?
I will go as late as 6 o'clock if need be. So I want to keep pushing along. I want to...
Yeah, that's definitely pushing it here.
That's not that late, sir. We've stayed till 5:36. Previously, there were times during jury selection we stayed till probably 7 or 7:30. The last 2 nights we did break at about 4:30, 4:45, and so I'm willing to go a little bit later tonight. So it's 3:30 now. We'll see how things go.
I was making that for saying that on the record because in my position that is kind of late.
Well, let's start now and we'll get going, and maybe we don't have to go that late. So bring the jury out.
Are we going to address subject matter jurisdiction?
The written decision that I previously entered is what I will stand on. I'm not going to address it any further.
Is that verified proof?
Sir, my written decision is the decision on subject matter jurisdiction.
Is it verified proof? Because it hasn't been proven on the record, and that was not verified proof. It has yet to be proven.
I am denying the request by the defendant to verify subject matter jurisdiction. That's denied.
It has to be proven for the record.
I disagree with you as a matter of law. The
Show
jury's
me,
coming
show
out.
Me lawful law.
All rise for the jury.
Show me by lawful law. Unless you make an tacit agreement that you don't have to prove subject matter jurisdiction on the record by law.
All right, welcome back, ladies and gentlemen of the jury. It's about 3:37. I know you're all filing in, so I'll wait till you all get in.
Not yet.
And welcome back to the rest of you who are filing in after our short afternoon break. I just wanted to let everyone know I have let the parties know if need be. I'm willing to stay between 5:30 and 6 this evening. I know there's 2 witnesses for sure, the state intends to call and I intend to get through. It's kind of the timing and whether there's a third witness tonight or not. I'll decide a little bit later. But at this point, the state may call its next witness, and the rest of you may be seated, of course.
Thank you, Your Honor. The state calls Chris Johnson.
All right, Mr. Johnson, if you would please make your way to the witness stand, which is on my right. It is up a riser. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat. The first thing I will ask you to do is to state your first and last names for the record and then spell each.
My name is Chris, C-H-R-I-S, Johnson, J-O-H-N-S-O-N.
Thank you. Go ahead, your witness.
How are you employed, sir?
I'm employed as the Chief of the Office of Crime Scene Response for the Division of Forensic Sciences, Wisconsin State Crime Laboratories.
What is your educational background and training briefly?
I have a Bachelor's of Science degree in molecular biology from Marquette University. I started my career approximately 16 years ago in the DNA analysis unit as a forensic scientist. As a forensic scientist, I went through an extensive training program to be a DNA analyst, and I've carried many positions since then.
And as chief of the crime response unit, what are your duties and responsibilities?
My duties are twofold. I have an administrative aspect and a technical aspect. The administrative aspect is to oversee and monitor all operations or all aspects of the crime scene response program operations. My technical aspects come into play when I receive calls from law enforcement to respond to scenes to provide technical assistance. My primary duty as the technical aspect is to preserve the integrity of the evidence at crime scenes. This is done through proper examination, recognition, documentation, and collection of physical items of evidence. Furthermore, another technical aspect I have is to write confidential reports of findings, and this basically summarizes any examinations and processing techniques that are used on scene and is a summary of the findings from those techniques. Lastly, I testify in court when needed.
Is there a set procedure you follow when you are asked to respond to a crime scene?
Yes.
What is that, please?
Objection leading.
Overruled. The witness may answer.
If law enforcement is at the scene and would like the crime lab crime scene response team to respond, they simply call the lab that's in their jurisdiction, and basically the call will get routed to me and I'll dispatch a team to the scene.
And on November 21 of 2021, was the crime scene response unit asked to respond to an incident in the city of Waukesha, county of Waukesha, state of Wisconsin?
Yes.
What was the nature of the call?
The nature of the call was to respond to an address on Maple Street to begin processing a vehicle that was abandoned in the driveway of that residence.
Were you given any limited information as to the significance of the vehicle?
Yes, it was reported to me that the vehicle was more than likely involved in running through the Waukesha Christmas Parade.
Were you aware that it was reported pedestrians had been struck during the event?
Yes, that was reported.
The objection is noted. I'll allow it as it is foundational. The witness may answer.
Yes.
Now, when I think of a crime scene, I typically think of a place or a location. Does your unit also cover processing of a vehicle like this?
Yes, in this
Overruled. You may answer.
in this particular circumstance or situation, the vehicle itself can be considered a crime scene in and of itself.
And in your years with the crime lab, do you have prior experience processing motor vehicles that were suspected to have been involved in fatal collisions with pedestrians?
Objection leading.
Overruled. Foundational. The witness may answer.
Yes, I've processed several vehicles related to that.
Okay. Did you personally respond to the address at 338 Maple?
Yes, I was one of 2 people responding.
Who else responded?
Julie Avila.
And does Julie work with you?
She does.
What's her task or primary responsibility?
Objection leading.
Overruled. Foundational. The witness may answer.
For this particular scene, I was what is called the team leader, so I'm in charge of all aspects of processing the scene. Julie was a crime scene response photographer, so she was tasked with appropriate documentation via photographs.
Okay. Do you recall about what time it was when you arrived on scene?
I arrived on scene approximately at 8:15 p.m. on 11/21/21.
And I'd like to show you a series of photographs, and I'm going to have multiple sets of photographs to go through with you. This is the first set, and the set contains 4 or 5 pictures. So they're going to show up on your screen first, sir, and I'm going to ask you to identify these photographs, and then we'll work backwards and present them to the jury with the court's permission, okay?
Okay.
So first on the screen is Exhibit 67, which I believe was previously admitted? Yes. Yes.
Yes.
All right.
Objection.
Overruled.
Sir, do you recognize the objects depicted in State's Exhibit 67?
Yes, this is a overview showing the front end damage of the red Ford Escape that's parked in the driveway of 338 Maple
Okay.
Avenue.
Next, we're going to present to you Exhibit 93. What's depicted in 93, please?
This is a close-up showing the damage of the front end of the vehicle, the red Ford Escape that's parked in that driveway.
All right. I should have asked you this. Prior to the photographing of the vehicle, is it been moved or altered by you in any way, sir?
No.
Objection leading.
Overruled. Foundational. The witness may answer.
No.
Please put up for the witness number 68, which has been previously admitted.
Go ahead.
Objection.
Overruled.
Please describe, sir.
This is the photograph's taken at an angle, the front passenger side of the vehicle, but again showing the damage of the front end of the vehicle.
Number 102. You recognize that photo, sir?
I do.
Please describe.
This is
Objection.
Overruled.
This is a mid-range photograph of the driver front quarter panel, showing a side view of the damage of the hood and the quarter panel.
And number 103. Please describe.
This is a overall photograph of the back end of the red Ford Escape.
Do you believe these 5 photographs are true and accurate depictions of the way the vehicle looked on the driveway at 338 Maple that evening, sir?
Objection leading.
I'm sorry, I was trying to get a hold of my witness list. Could you re-ask the question?
Yes, Your Honor. Do these 5 photographs truly and accurately depict the way the vehicle looked at 338 Maple Street on the evening of November 21, 21?
Objection leading.
Overruled. Foundational. The witness may answer.
Yes.
Move to admit 67, well, 67 and 68 are already in, so move to admit 93, 102, 103, and permission to publish all 5.
Objection. Relevancy.
Noted. Overruled. The exhibits are received. Permission to publish granted, specifically 67, 93, 68, 102, 103. I realize some may have been received previously, but to be thorough, I wanted to put that on the record.
Thank you. All right, Mr. Johnson, 67 you testified was an overview photograph?
Yeah, it's an overall photograph of the.
Overruled, they're now being shown to the jury. It's proper, it's foundational as well. Go ahead.
Yes, this is a overall photograph showing the location of the vehicle, but specifically also showing the front end damage of the vehicle.
All right. Next, 93. Please describe.
A close-up.
Overruled, go ahead.
A close-up of the damage that has been sustained on the front hood area, bumper area of the red Ford Escape.
Next is 68.
Objection.
Overruled.
Mid-range photograph showing the damage, front end damage, specifically from a reference point of the front passenger corner of the vehicle.
I observe on the bottom of that photograph there appears to be some liquid substance on the ground. Do you see that, sir?
Yes, I do.
Objection leading.
Overruled, foundational. The witness may answer.
Do you remember seeing that substance that night?
Yes.
Were you able to tell what it was?
Objection speculative.
Overruled, based upon his training and experience, he may answer.
Not specifically what type of fluid it is, but some kind of engine compartment fluid.
From this vehicle?
Yes.
Okay. Number 102, please.
A mid-range of the driver front quarter panel, also showing what I describe as a white headband on the broken driver door mirror.
Is that illuminated in some fashion?
Objection
Yes.
leading.
Overruled, the witness may answer. Just a reminder to wait until I fully rule on the objection before you answer.
I apologize. Yes.
How was it illuminated?
Objection leading.
Overruled.
It has white LEDs that are within the cloth and they're blinking on and off.
Okay. And then last would be 103.
Objection.
Please describe. Oh, I'm sorry, he objected.
Overruled. Go ahead.
An overall from the further into the driveway showing the back end, the rear end of the red Ford Escape.
All right. Now, after these photographs were collected on Maple Street, did there come a time where you planned to move the vehicle?
Yes. Part of the process in arriving at a scene, there are 3 steps. There's a scene approach, scene assessment, and a scene processing strategy. So the scene approach starts with the moment I receive a call and start thinking about what evidence might be present, just knowing the limited facts or the limited information that I have during the call. When I arrive on scene, I do a scene assessment. So I did a walkthrough of this particular vehicle, around it, and including the property. Determined from that what my processing strategy would be. So going back to answer the question, my thought and my processing strategy this particular night was to collect anything that would be fragile in nature off of the vehicle and then get it transported to a more environmentally friendly secured facility to continue processing in the subsequent days.
Was that for your comfort or for some scientific reason?
Objection speculative.
Overruled, the witness may answer.
It was very cold that night, so it was difficult to process. It was very windy, but it was for a purely scientific standpoint of doing the necessary steps of collecting whatever I needed and I deemed fragile. Collect that stuff, and then let's get it into an enclosed trailer and transport to a secure facility that's nearby.
So what items, if you recall, did you remove that you had deemed fragile?
Objection leading.
Overruled, the witness may answer.
There were first some items that were in the yards or yard of this particular residence, some examination gloves and a winter hat that was in the backyard. So those items were collected. Of particular interest on the vehicle was the headband that was around the driver door mirror that was broken. So that was important to collect because during transport, that most likely would have fallen off. So that's what I'm talking about, fragile evidence.
Okay. So that item was removed?
Correct.
What about the front bumper? We saw that laying on the driveway. Was that secured in some fashion?
Objection, leading.
Overruled, you may answer.
Yes, to make transport easy, the bumper would have had to be lifted up with bungee cords and resecured. Otherwise, as the tow company is moving that vehicle, the bumper would just continue to go underneath the vehicle, further damaging or maybe even eliminating or getting rid of physical evidence that might be on that bumper.
So were you the person that secured that front bumper?
I was there and I assisted with the tow company.
Okay. Where'd you take it?
So it was taken from this residence and it was taken to Waukesha County Sheriff's Office secured facility.
Is that nearby here in Waukesha?
Yes.
Okay. Ask Madam Clerk if you could turn off the display, please, and I'm going to present to the witness only another series of photographs, starting with 105.
Go ahead. Do you know how many?
8.
Sequential?
Yes, 105 through 112.
Thank you.
Objection. Relevancy.
Well, I haven't seen them yet, so I'll have to wait, but you can put them up and then I'll make a ruling.
I think we're ready on our end. We're just waiting for Madam Clerk.
Oh, sorry. I'll leave it alone. You hit it. We just nixed each other twice.
105.
All right.
There.
Given what I see on the screen, the objection is overruled.
Okay. And Your Honor, for the sake of time, I'm just going to ask the witness to look through these photos just as if he had them in front of him, and then I'll ask some foundational questions. So 105 is on the screen. Do you see it, sir?
Yes.
Do you need more time to review that photo?
No.
106, please.
Yes.
Do you need more time to review that photo?
Objection,
No.
leading.
Overruled. The witness may answer.
107,
Yes.
do you need more time?
No.
108,
Yes.
do you need more time?
No.
109,
Yes.
need more time?
No.
110,
Yes, I recognize and I don't need more time.
111,
I recognize and I don't need more time.
and 112.
I recognize that photo and don't need any more time.
Where were each of these photos taken?
Each of these photos were taken at that secure facility that where Waukesha County Sheriff's Office, their secured facility. This is indoors of that facility.
Okay. And do you believe each of these photos is a true and accurate representation of what the vehicle looked like once you towed it to the secure facility?
Yes.
A move for admission of 105 through 112 and permission to publish, Your Honor.
Objection.
Noted. Exhibits 105, 106, 107, 108, 109, 110, 111, and 112 are all received. Permission to publish granted as to all.
So in this photograph, sir, is the, what's the condition of the front bumper, please?
Objection, leading.
Overruled. Foundational. The witness may answer.
The front bumper is secured in somewhat, should be its original position with those bungee cords that we previously talked about.
Okay. Next, 106, please. Please describe.
Overall photograph, the front driver's quarter panel, including showing the hood damage.
Was there an effort by you to try and match the pieces of the bumper to the frame of the body, or is that just the way it came together?
Objection. Speculative.
Overruled. Go ahead, you may answer.
At this time, I was not trying to physically match anything together. It was just for the purpose of securing it for transport.
Okay. What is the position of the driver's side window in this photograph, sir?
The window is down.
Is that the way you found it?
Yes.
Objection.
Overruled. The witness may answer. He responded to the scene where the vehicle was located and can testify based upon his knowledge.
107, please. Please describe.
An overall photograph from the point view of the front passenger side of the vehicle.
Next, 108.
Objection.
Overruled.
Please describe.
An overview of the front of the vehicle, including the front passenger quarter panel and the front passenger door.
What position was the front passenger window in?
Down.
Is that the way you found it?
Yes.
Okay. 109. Please describe.
An overall photograph of the passenger side of the vehicle. Including in this photograph is the front quarter panel, the front passenger door, and the rear passenger door.
And along the front passenger door and the rear passenger door, do you see anything remarkable?
Objection. Leading.
Overruled.
Spanning the length of both doors is quite a significant scratch.
Have you seen scratches like that before in processing motor vehicles, sir?
Objection. Relevancy.
Overruled.
I have.
What is that consistent with, please?
Objection. Leading.
Overruled.
Coming into contact with another item.
Thank you. Number 110. Please describe.
An overall photograph showing the rear of the passenger side of the vehicle. Specifically noting that the rear passenger window, that window is not down, it was actually shattered.
Okay.
Broken. And also showing in this photograph are 2 apparent fired bullet defects.
Okay, I have some other photos more specific to that in a minute. Thank you. 111.
Objection.
Overruled.
Please describe.
An overall photograph from the vantage point of the rear passenger side of the vehicle.
And then 112, please.
Objection.
Overruled.
An overall of the vehicle from vantage point rear driver side of the vehicle.
Is the rear driver's side window, what position is it in, please?
That is up.
And is that the way you found it?
Yes.
And it looks like there's substance on the exterior of the vehicle on the driver's side. Do you see what I'm referring to, sir?
Objection. Leading.
Overruled. The witness may answer.
Yes, I do.
Do you know what that item or substance was?
Objection. Speculative.
Overruled. Based upon his training and experience and his personal observation of the vehicle, he may answer.
Not knowing what specific fluid that might be, I did do a presumptive test to see if it's possibly blood.
Okay.
All tests that I did of that liquid that's on the driver's side came back negative for the
Okay.
possible presence of blood.
And was it sprayed along the most of the driver's side of the vehicle?
Objection. Speculative.
Overruled.
Yes.
Okay. Now, I'd like to move on, sir, and ask you, did you do an interior inspection of the vehicle
Yes.
and an exterior inspection of the vehicle?
Correct.
I'd like to highlight some specific areas, starting with the interior of the vehicle. Would you have processed the entire passenger compartment and cargo space of this vehicle?
Yes.
And what types of things would you have been looking for, sir?
Based on my former experience, looking for surface types that might contain potential DNA evidence. So specifically, anything that's in the vehicle that would have been handled to control the vehicle, or handled in a repetitive manner, or with some kind of force. So for example, the steering wheel, the gear shifter, those items were swabbed by myself for the potential of DNA. We also looked at surfaces within the vehicle and processed those for the possible presence of latent fingerprints.
Do you remember locating an object on the front passenger seat of the vehicle?
Yes.
I'm going to ask that we display to the witness only Exhibit 117. Do you recognize what's shown in Exhibit 117, sir?
Yes, there's a hat that's on the front passenger seat cushion.
Is that the way the object looked when you found it?
Yes.
Move to admit 117, permission to publish, Your Honor.
Objection. Relevancy.
Overruled. Exhibit 117 is received. Permission to publish granted.
Could you please, it's a touch screen in front of you, circle the hat that you just described for the jury? And then to your left, sir, on the witness stand, before you took the stand, I placed an item up there that's been marked as exhibit number 87. You see that on the table there?
Yes.
Can you identify exhibit 87?
Yes, this is the winter style hat that I collected from that front passenger seat.
Okay. Like to show another photograph to the witness, exhibit 118, please.
Objection.
Overruled. Go ahead.
Do you recognize the object in exhibit 118?
I do.
Do you believe this photo is a true and accurate representation of the object as you found it on the vehicle?
I do.
Objection. Speculative.
Overruled. Your answer may stand again. Just wait till I rule on the objection, please.
Move to admit 118, permission to publish.
Exhibit 118 is received. Permission to publish granted.
Please describe.
This is a close-up photograph of the clothing items that were pinned to the windshield by the crumpled hood, and it was being held in place by that hood pinning the items against the windshield, as well as that wiper arm.
Okay. Did you eventually remove these items?
Yes.
What did you find them to be?
It was a detachable hood from a jacket as well as a winter hat.
And can you just point out on the touch screen which is which?
Objection. Leading.
Overruled.
That's the hood portion, and that's the hat portion.
Okay, thank you. Did you find any U.S. mail or paperwork inside the vehicle?
Objection. Relevancy.
Overruled. The witness may answer.
Yes, I did.
Were there any names associated with the U.S. mail or paperwork inside the vehicle?
Objection. Relevancy.
Overruled. The witness may answer.
Yes.
What was that name?
Darrell E. Brooks Jr.
Was there an address, if you can recall?
Objection, relevancy.
Overruled, the witness may answer.
There was, but I don't exactly recall it.
Sure. Also on the table next to you, sir, is your report that I've marked as exhibit number 90. Do you see that?
Yes.
Wait. Placed on the table.
Go ahead, Attorney Hopper.
Well, objection, how did it get on the table?
Your objections noted, it's overruled. Record will reflect that there's a copy of a crime lab report. It has an exhibit sticker, number 90, with the case number of this case. Handing it back to the witness. Go ahead, you may question.
How did it get on the table? Who placed it on the table?
Attorney Hopper indicated she placed it there.
When did that happen?
Attorney Hopper, go ahead, continue.
Did you author this report, sir?
Yes, I did.
If you review the report, would you be able to see the address for Darrell Brooks that was noted in the paperwork from the inside of the SUV?
Objection, I don't consent to being called that name.
Please
Noted, overruled.
Yes, I would.
Please do that, sir.
Objection,
Overruled.
grounds for the overrule.
The witness may answer.
Grounds for the overrule.
Go ahead, sir.
The address for the pieces of mail that I recovered was 4014 North 19th Street, Milwaukee, Wisconsin, 53209.
Thank you.
Objection, that should be strike. When he asked the question, he said he didn't recall, so how can you force somebody to recall?
The witness's recollection was refreshed through the use of his report, which he indicated he documented the address. Your objections noted, it's overruled. The answer will stand. Go ahead, next question, please.
Yes, and actually, if I could back up 1 minute and ask Ms. Gussie to put back up 117. Got to ask a question about 117.
Go ahead.
And if we could display it, please, Madam Clerk.
Nobody got to answer no questions.
Mr. Brooks, please refrain from interrupting. You'll have an opportunity to ask
I
your
have an
questions
objection
on
of
cross.
how stuff got to the table without my knowledge. That should be known. That should at least be noted for the record.
It was
I wouldn't
noted
be able to do that.
Your objections noted, it's overruled. Go ahead, Attorney Hopper.
So that needs to stop happening.
In
It needs
addition
be
to
fair.
that,
All right, I'm gonna excuse the jury. All right, for the jury.
Can't keep doing stuff without. It should be a fair trial. That's my right. Shouldn't be able to do things without my knowledge. And then pass it off to the jury like that's fair. They deserve to know that too.
The rest of you can have a seat as well. As soon as the jury's out, I'll make a record. All right, Mr. Brooks, you are well aware that the reason
consent to being called
documents
that
are
name.
being put on the
I don't consent to
witness
being
stand
called that name.
are because this court indicated it would limit the movement of the parties due to your custodial status to keep things fair.
And I
You are
merely asked, how did
attempting-
it get there?
Sir, do not
I'm not
interrupt
enti-
me, or
I'm
you will
not
forfeit your
entitled
right
to
to be
know how it got
present
there?
in this courtroom.
So
Do
you
not
holding me in
interrupt
contempt?
me.
Are you holding me in contempt?
I'm gonna make a record.
Are you holding me in contempt?
I'm not answering your questions.
So then you're not holding me in contempt.
Do not interrupt me again, or you will go to the other courtroom.
Under what lawful law?
All right, he's interrupted me once again. We're gonna clear the courtroom. He's being disrespectful. I'll make a record once he moves. Unless you can promise me right now that you let me make my record without you interrupting me, sir.
You gonna make your record? You can make your record.
Then please don't interrupt me.
Don't hold me in contempt.
I've never said any such thing.
Removing me from the courtroom, Your Honor, is essentially holding me in contempt.
All right, no, you're forfeiting your right to be present under Illinois versus Allen.
I didn't forfeit
I'm
anything.
gonna start talking, and if he interrupts, then I will close this courtroom, and he will be taken to the next courtroom. Mr. Brooks, you are well aware that the court made some pretrial rulings related to whether there would be, they can stay in, I haven't closed it yet, he's not interrupting me, whether the parties could approach the witness stand. And I did that because you're in custody and I'm not gonna allow you to approach the witness stand while in custody. That is why various precautions have taken place to limit, frankly, that from happening. Throughout this trial, there was one instance at the very beginning of the case where I allowed the state to approach a witness. I corrected that. That hasn't happened since. We've had bailiffs take items up to the witness stand, or the items have been given to the witnesses, or they've been placed on the witness stand. That's proper. There is nothing wrong about that. Nobody's trying to pull a fast one over you. No one is doing something that's not permitted by this court, or frankly under the rules of decorum and courtesy or the presentation of evidence in this case. Frankly, from my perspective, sir, your attempts and your comments are to try to dig in at this jury and to somehow create doubt about the presentation of this case or the fairness of these proceedings without the party, meaning the state, having an opportunity to refute, explain, or correct it. I've taken the jury out at this point to admonish you that any further mumbling under your breath or not recognizing when I uphold or sustain an objection, that I will take as a disrupting interruption meant to disrupt the proceedings. I'm not holding you in contempt. I'm well aware that that's one of my options. I choose not to do it for the reasons that I've stated on the record previously. All right, you can forfeit your right to be present at any point in time during this trial by your conduct under Illinois versus Allen. When it is disruptive, when it does not follow the simple rules of courtesy and decorum, I draw your attention once again to SCR Chapter 62, which has been previously provided to you, which is under the statute there. These constant mumbling and interruptions during the proceedings. I haven't made a record of them today, but I will now. Started at 9:01, then there was 5 at 9:02, 3 at 9:03, 4 at 9:04, 1 at 9:05, 2 at 9:05, 1 at 9:06, 3 at 9:08, again at 9:17, 9:27, 10:31, 1:05, there was talking over by you at 2:03, 5 interruptions at 2:14, 2:15, 2:17, at 2:19, audible muttering, 2:31, 2:33, what I would describe as inappropriate, like muttering under your breath, 2:35, at 3:06, there was the hilarious comment, at 3:11, there was what I would describe as arguing about the muttering and the irony of it all. At 3:12, there were 4 interruptions. At 3:37, more 4:09, 4:10, more mumbling. At 4:11, twice, and at 4:12, 9 different times. So I think I've made an ample record of the disruptions today. I've been abundantly patient with you. I've, again, as I stated earlier, I've even limited how I tell these things to the jury about how to disregard, and I simply say the jury is to disregard comments and statements made by the parties or the lawyers, as those are not evidence. So I'm warning you, do not interrupt again. If this jury comes back, or when they come back and you do that, then you will be removed and you will forfeit your right to be present for the examination of this witness. Let's bring the jury back in.
Well, you might as well remove me then, because what you're doing is not fair. I can't even rebut what you're saying. I didn't interrupt you. I let you make your incorrect record.
Mr. Brooks, I'm bringing the jury out and we're continuing. We're gonna get through these witnesses.
And I'm not stopping you from doing that.
Through your behavior, you're not gonna delay these proceedings today.
I'm not trying to delay the
continue.
proceedings, so I wish you would stop being incorrect on the record and saying what I'm trying to do if you don't know that. You don't know what I'm trying to
I'm
do.
bringing the jury out, I'm not gonna argue with you.
Then don't. Because I'm not arguing with you either. I'm stating facts.
You're raising your voice, it's very
Because I'm
angry tone,
tired of you
and
always
it's
making a
yelling
record.
at me.
You're making a record of me trying to look bad. I know what you're trying to do. It's not gonna work.
I'm making a record of what's accurately
You're
being
making
done
a
in my
record of
courtroom.
incorrect statements. That's what you're doing. You're not making a record of
Mr.
not
Brooks,
being
I'm
able.
advising you to be quiet because the jury's coming back out.
You're advising me to be quiet. Is you telling
I'm
me to be
advising
quiet?
you to be respectful when the
Are
jury
you
comes
telling
out.
me to be quiet, or are you asking me?
I'm asking you and advising
Okay.
you.
Thank you for correcting that, because don't nobody tell me what to do. I don't tell nobody else what to do.
I'd appreciate
We're all
if you
we're
lower your
all
tone
adults
of
in here.
voice
I've
and
never
not yell at
told
me,
you to
sir.
do anything at all.
Sir, I'd appreciate if your tone of voice would change.
I would appreciate if you would ask me. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All rise for the jury.
Not gonna work. I'm supposed to be scared of getting removed or something.
Thank you, everyone. Please be seated. Statement continue its examination of this witness. I believe we're on Exhibit 117.
Yes, we had 117. Madam Clerk, would you please turn the display back on? Mr. Johnson, were there other items on the front passenger seat besides the blue winter hat?
Objection leading.
Overruled. The witness may answer.
I do recall a cell phone being present on that front passenger seat.
Do you remember what kind of cell phone?
An iPhone.
I also see some items that look like maybe headphones or charging cable, something like that. Do you see that, sir?
Objection leading.
Overruled. Foundational. The witness may answer. The exhibits previously been received.
Objection speculative.
Overruled.
I do see that.
Do you remember something like that on the front passenger seat?
Yes.
Okay. And how about on the floorboard of the front passenger seat? Is there an item there, sir?
Objection leading.
Overruled. You may answer.
Yes.
What do you remember that item was?
A TV.
Okay. And to the left of the TV, the white colored object?
I don't recall what that is.
Okay. But this is the exact way the passenger seat looked when you recovered the vehicle, correct?
That's correct.
Okay. Now, if we could please go to Exhibit 116 and put up for the witness only. Sir, do you see Exhibit 116 in front of you?
I do.
Do you recognize this photograph?
I do.
Do you believe this to be a true and accurate depiction of the interior of the SUV?
Yes.
Move to admit 116, permission to publish.
Objection. Relevancy.
Overruled. Exhibit 116 is received. Permission to publish is granted.
What's in the photo of 116, please?
This is an overview of the rear passenger seat. That rear passenger compartment contained several clothing items and miscellaneous items.
Okay. And was the condition of the back seat like this when you found the vehicle, sir?
Objection speculative.
Overruled. The witness may answer based upon his knowledge of recovering the vehicle from the scene and his training and experience.
Yes.
Now, for the witness only, I'm going to please ask Ms. Gussie to put up 113, 114, and 115 for his review.
Go ahead.
Is 113 up?
Yes,
Okay, do you recognize that item?
I do.
Okay. Next, 114. Do you recognize 114?
Yes,
And 115, do you recognize 115? There it is.
I do.
Okay. Do you believe these three photographs truly and accurately depict the vehicle, these areas of the vehicle, sir?
Yes,
Move to admit 113, 114, and 115, permission to publish.
Exhibits 113, 114, and 115 are all received. Permission to publish granted.
Please. Oh.
Jury would let me know when the jury box monitors are on. All right, thank you very much.
All right. Please describe 113, sir.
that is an apparent fired bullet defect that's in the windshield of the Ford Escape.
Is that the rear view mirror on the left side of the picture?
Yes, this photograph would be from the inside looking through the windshield.
Were you able to tell the path of travel for the bullet?
Objection, speculative.
Please describe.
Overruled. You may answer.
Yes. The fired bullet that caused this defect most likely came through that rear passenger window that was shattered and entered the vehicle and then exited the vehicle through the windshield.
So that's a exit damage that we're seeing there.
Yes.
How can you be sure?
Windshields have laminated glass, and so the directionality of a fired bullet going through laminate glass, there's an indicative laminate tag, we call it. So that shows the direction of the fired bullet.
Okay. Number 114, please. Please describe.
That's an apparent fired bullet defect. I call this a striking defect. That's on the roof rail of the passenger side of the vehicle.
Okay. Why do you call it a striking defect?
It didn't penetrate any part of the vehicle. It was more of a glancing kind of ricochet.
Okay. And then number 115. And if you could zoom in on that back left. Yep, thank you. Please describe.
This is an apparent fired bullet defect. I call this a perforating defect because it actually went through the exterior door skin and went all the way through into the inside of the vehicle.
Did you ever find the fired round in the vehicle?
Yes, I did recover a fired bullet and fired bullet fragment from the rear cargo area of the vehicle.
Okay. Was there any evidence that that bullet traveled any further than the cargo area of the SUV?
Objection, speculative.
Overruled. Based upon the witness's training and experience and examination of the vehicle, he may answer.
No, the bullet stayed in that rear cargo area.
Okay. Now, aside from examining the interior and the exterior of the vehicle at ground level, did you attempt to look underneath the vehicle?
Yes, the first processing strategy, if we go back to that, I wanted to get everything collected from all sides of the vehicle and inside of the vehicle before putting it on a vehicle lift to examine the undercarriage of the vehicle.
So you did do that?
Yes.
What kinds of things are you looking for on the undercarriage?
Looking for anything that shouldn't be normally present on the undercarriage of a vehicle. So I was looking for any hairs, fibers, any potential biological fluids such as blood.
Did you find any such objects?
Objection, leading.
Overruled. He may answer.
Yes, I did.
Did you collect those items?
Yes, I did.
You had described for us earlier swabbing of the steering wheel on the interior of the vehicle. Do you recall that?
Objection, leading.
Overruled. The witness may answer.
How do you go about swabbing a steering wheel, sir?
Objection. What's the relevancy?
Overruled. The witness may answer.
The best way to collect DNA evidence from a surface is to use a two-swab technique. The first swab is a swab that's slightly moistened with deionized water, and basically swabbing the surface and then following up that swab with a dry swab. So it's a two-swab process, a wet swab followed by a dry swab, and that becomes one item of evidence.
Same thing for the gear shift?
Yes.
What do you do with these swabs after you collect them?
I put them into the appropriate container and then seal that container, write my description of that particular item of evidence, and eventually that evidence is transferred to a unit at the crime laboratory for analysis. In this particular case, those items, anything for DNA, is going to be transferred to the DNA analysis unit.
Did that happen?
Yes, that did.
And how about the hat, States Exhibit 87? Did that get transferred to another unit for further analysis, to your knowledge?
Yes, so any clothing item that's
Hold on, there was an objection. Grounds?
Relevancy.
Overruled. The witness may continue answering.
Clothing items that are worn by individuals are a really good source of transfer of DNA. So yes, I collected that hat and it was transferred to the DNA analysis unit.
Your report Exhibit 90, did you believe that to be a true and accurate narration or summary, I should say, of your work in this case, sir?
Yes, I do.
Move to admit number 90, Your Honor.
Objection. Relevancy.
Overruled. Exhibit 90 is received.
I don't have any other questions then, Your Honor.
All right, thank you. Cross-exam, please.
You said you do DNA analysis, correct?
No, I did DNA analysis for nearly 10 years. I don't actually do DNA analysis anymore.
So at the time of the incident, were you doing DNA analysis?
No.
So who did the DNA analysis on all the items that were found during your investigation?
DNA analyst Trevor Nailed.
Did you see the results of those DNA Did you see the results of those DNA tests?
We did have conversations.
Did you see them?
No.
So it'd be fair to say you don't know what those results were.
I didn't verify it. Like I said, we just had conversations.
So do you know the results of the DNA analysis?
In particular, is there a particular item?
For any of the items?
I don't recall the exact results, no.
And you made reference to the gunshot that you stated stayed in the rear cargo. Where in the rear cargo did you find that shell casing?
Objection, that's a misstatement. It wasn't a shell casing, Your Honor.
Shell casing, fragment, same thing.
Hold on, there's been an objection. I'll sustain the objection. It mischaracterizes the testimony and ask that you rephrase it.
Did you find a shell casing, a bullet fragment?
I found a fired bullet fragment.
Where did you find the fired bullet fragment?
It was really close proximity to where the rear latch comes down and hooks in to stay closed. So on the floor of the rear cargo by where the actual cargo door comes down.
And you said a latch that comes down?
Yeah, so how doors latch, like car doors latch, you know where the latch is? So where the rear cargo door came down and latched, it was in really close proximity on the horizontal surface of that rear cargo area.
Did you observe if the bullet fragment had struck anything?
It struck some items in that rear cargo area.
Do you recall what it struck?
I don't.
You made reference to a headband being on the rear view driver's side mirror, correct?
Correct, it was on the driver's door mirror.
And from your expertise, how would you, in your opinion, guess that it got there?
By coming into contact with something or someone that was wearing it?
And do you know that for sure?
No, but based off of my experience of a lot of years of examination of physical items of evidence.
But it'd be fair to say that you don't know exactly.
No, I wasn't at the parade. No.
And you stated that you were present for the towing of the vehicle, correct?
Yes.
Do you recall at any time anyone's attempting to start the vehicle?
No.
And you stated that the bumper was, I guess, moved at some point so it wouldn't drag under the vehicle. I'm guessing that's what you said. If I'm wrong, you can.
No, that's correct. Yeah, we used bungee cords to secure it off the ground so that when we're moving it or putting it on the flatbed to go to the actual enclosed trailer, that it wouldn't be constantly going underneath the vehicle.
When towing the vehicle, what was it placed on?
Because of the amount of traffic or cars that were parked on the road, the towing company couldn't get the enclosed trailer right to the end of the driveway. So the vehicle was put onto a flatbed truck and then driven a few houses down, where then it was transferred to an enclosed trailer and then removed from the scene.
So with the bumper, being that it was first placed on a flatbed truck, as you say, at that time, what the bumper had, what problem would the bumper had caused if it wasn't going to be physically dragged or anything at that point?
I'm not sure I understand your question.
What kind of problem would the bumper pose if the vehicle was on a flatbed truck?
The whole point
essentially what I'm saying is, to give you more clarity, how could the bumper be dragged at that point?
It was being removed from the surface of the driveway onto the flatbed. So if the bumper weren't secured in an upright position, it would be pulled, and the bumper, as the vehicle is going this way, the bumper would be pulled underneath the vehicle.
So once it was secured on the flatbed truck, would the bumper still pose any problem?
The vehicle on the flatbed, the bumper was in a secured position.
If it wasn't bungee corded, would it have posed a problem?
Yes.
How so, if it wasn't moving?
The whole purpose was to secure the bumper in place to preserve any physical evidence that might have been on the bumper.
And do you recall who did the actual towing?
The company is Complete Towing and Recovery.
And you stated to want to get the vehicle to a environmentally friendly, secure location?
Yeah, a better term would be environmentally controlled.
What do you mean by environmentally controlled?
Proper lighting, outside of the elements, outside of view of the public, so an enclosed building.
Why the reference to outside of the public?
It's easier to do examinations in a controlled environment.
Would it be fair to say at that time, before it was told, the vehicle had been secured, checked? That was done out in public, so what would be the difference at that point?
I'm going to go back to my original statement of what my primary duty is. My primary duty is to preserve the integrity of the evidence. So that night, I was concerned with doing the necessary steps that I deemed relevant to collect, and then get that vehicle to a more suitable environment, just based off of how much more work and analysis and processing that vehicle would entail.
Fundamentally, I follow what you're saying fundamentally. The question, though, is by the time you arrived to the scene where the vehicle was located, were you aware that the vehicle had essentially been already investigated?
No.
So you had no knowledge that the vehicle had been secured, had been pretty much investigated by that point?
Well, I was aware that the vehicle was in a secured state. I don't know what happened prior to that. There was very little information that I received on the initial phone call because of the hectic nature of everything. So I had an address, and I knew that the vehicle was being secured by law enforcement.
So law enforcement were present when you arrived to the scene?
Yes.
And at that time you had learned, did you learn any knowledge from the law enforcement other than what you were told during the phone call?
No.
Do you recall who you were called by?
I was called by Special Agent in Charge Dave Klabundy of the Division of Criminal Investigations.
Do you recall what time you arrived at the scene?
I arrived at approximately 8:15 p.m.
Do you recall what time the vehicle was found?
I don't recall.
Do you recall anyone telling you or mentioning what time the vehicle had been found?
I don't recall.
So it'd be fair to say before you arrived on the scene, you have no knowledge of what's been happening around the vehicle?
That's correct.
You say you made reference to a hat being found in the background. Do you remember saying that? Or in the backyard, rather. I'm sorry, not the background, the backyard, I meant to say.
Yes.
And at the time that you observed this hat in the backyard, do you, from your expert opinion, do you recall it having any relevance to the vehicle?
No, it was an item of evidence or a potential item of evidence that just seemed out of place. So in those types of situations, I always collect those types of items.
But you weren't sure at the time if it had any involvement with the actual vehicle?
No.
Was there anything significant that stood out about the hat?
Just the location.
Did you find any blood on the hat? Did you find, or is it just pretty much just a hat in the backyard?
I didn't do a thorough examination of the hat.
So as far as you were concerned, it was basically just taking in the evidence as a precautionary thing, or?
Yeah, it was an item that just seemed out of place, so I collected that hat.
Did you at any time obtain knowledge about the relevancy of that?
No.
All the photographs that you were shown, had you seen those photographs before today?
Yes.
Do you recall if they were taken the same night of your investigation or multiple nights or days, rather?
There were multiple days.
And do you recall why you had to, or do you recall why those photos had to be taken over a multiple day span?
Yes, the vehicle needed a comprehensive evaluation or processing examination of pretty much every single side and surface of that vehicle.
And to do that, photograph wise, would have took days?
Yes.
So when did you start actually doing an investigation of the items inside of the vehicle?
That would have been the 22nd, November 22nd.
So the next day.
Correct.
And so did you yourself do analysis of the outside of the vehicle?
Yes.
Same day, 22nd of November?
Yes.
So you kind of started the outside and the inside pretty much roughly at the same time?
Yes.
Do you recall how long your complete investigation took?
Mine along with my colleagues?
Yours.
Mine. The examination itself of just me examining the vehicle?
Just you.
Probably over 40 hours. And that does not include the report that I'm writing. It doesn't include the process of going through the report, everything. But my examination, at least 40.
And so I'm assuming you did the report after you completed the initial investigation part?
Yes, the report's a summary of my processing.
And define summary. What do you mean by summary?
It pulls everything together. It details my examinations and any findings I have from those examinations.
I always view summary as not every detail, but pretty much like it's much as would be relevant, but not every single detail. Would that be fair to say?
This report is comprehensive in the terms of it lists every single item that was collected.
So why would you refer to it as a summary?
It's a summary of the examination and processing. That's the best way to describe it. It's not a dictation, in other words.
What do you mean by dictation?
There are other reports that other agencies may do that are dictated, right? I did this, then I did this, then I did this. This is a summary. This isn't a dictated report.
So what exactly did you summarize in your report?
My examination and processing strategies that I used, and the items of evidence collected, and any relevant findings associated with those examinations.
Did you do any examination of the cell phones?
No, I collected those and transferred those to a detective with the Waukesha Police Department.
Do you recall who that detective was?
David, his last name is spelt, I believe, Foyen, Foyen.
So at the time that you turned the phones over, did you do any do any more work in regards to the phones?
No.
Do you recall doing any investigation on the airbag control module?
No, I don't do that.
Do you recall obtaining a search warrant to conduct an inspection on the ACM?
I'm sorry, I didn't understand you.
An inspection of what?
The ACM, I guess that would be the air control module. I'm guessing that's what that's
Thank you.
referencing.
No, since I don't do that type of analysis or examination, I didn't obtain any search warrant with that.
Any reason why I would say that in the paperwork?
Objection vague.
Grounds.
Sustained as to the form of the question. As to what paperwork you're referring to.
I'm guessing. I don't know what it will be called, but it says conclusion inspection summary. And the conclusion inspection or conclusion/inspection summary. Do you recall?
Is it from this witness?
Huh?
Is it from this witness?
Yeah.
Okay. Go ahead.
I don't think that is from this witness, John. I don't see anything like that in this Exhibit 90. Are you perhaps still looking at Inspector Schultz's report from the State Patrol, the last witness?
What page number do you have? And I'll take a look at it 90 and I'll compare it.
This says page 5.
Yeah, he's looking at the last exhibit from Inspector Schultz, 83.
What? It says Chief Christopher Johnson.
Oh, it does say that in 83. It
I'm-
says, if I can read for completeness, or you can, it says, upon arrival, I met with crime scene chief Christopher Johnson from the Wisconsin State Crime Lab.
No. That's not what I'm reading from.
Okay. Chief Johnson had obtained a search warrant to conduct the mechanical inspection and to image the data retained within the escape's airbag control module ACM.
Yes.
Correct?
Yes.
Okay. So that was written by Inspector Schultz, who just testified, not this witness. To clarify the record here.
Thank you.
I apologize for that. It's all in the same paperwork with Chief Johnson, so maybe that's where the confusion comes in.
The record would reflect this witness's last name is Johnson, so I think that's
Yeah,
understandable.
I didn't know. I was just reading what I have here.
Fair enough. Keep going.
Do you recall at any time obtaining any type of search warrants pertaining to the vehicle in this incident?
Yes, I have obtained a copy of the search warrant.
And do you remember what that search warrant was for? What was the intended search?
To search the vehicle and process it for any biological fluids, hairs, fibers, any electronic equipment, any personally identifying information.
And the ACM would fall under the lines of the mechanical side of.
Yes.
Okay. At any time during your inspection, did you observe anyone try to start the vehicle?
When I was with Investigator Schultz, when he came to my laboratory, he attempted to start it.
And after you already stated that your initial part of your investigation before the report totaled 40 hours. At that time, after you had completed your report, did you do any more investigating in regards to the vehicle?
After my report was complete?
Yeah, after you had done the 40 hours that you stated with, and then the actual report.
No. Once my report's done, I didn't do any further examination of the vehicle.
And after that was completed, had you received any follow-up from law enforcement after you had completed everything?
No.
Had you yourself followed up with law enforcement about the investigation after you completed your initial part?
No.
You yourself didn't file any claims in this matter, did you?
No.
Do you know of anyone who filed any claims in this matter?
I don't.
And do you recall who you were subpoenaed by to testify?
I was subpoenaed by District Attorney Sue Opper.
Do you recall when that was?
I believe it was sometime, I don't exactly recall when.
And did you follow up on that subpoena?
No.
After you had received it?
No.
Have you at any time seen or read any complaints in regards to this incident?
No.
Do you know who the plaintiff is in this matter?
The state of Wisconsin?
Would you label that as a person, an actual human? Grounds.
Sustained, not relevant.
You ever actually seen the plaintiff in this matter?
Objection.
Grounds.
Sustained.
If you saw the plaintiff, would you be able to identify the plaintiff?
Objection,
Grounds.
irrelevant.
Sustained pursuant to 9611. Sir, please move on to a different line of questioning.
Just trying to establish who the plaintiff is, Your Honor. Do you see the plaintiff present in court today?
Objection,
Grounds.
irrelevant.
Sustained.
Would you consider yourself to be an injured party in this matter?
No.
No further questions.
Thank you. Any redirect?
Just very briefly. Mr. Johnson, you said when you arrived on Maple Street, there were police officers present,
That's correct.
and you said the vehicle was secure at that point.
Correct.
Objection.
What do you mean?
Leading.
The answer may stand. Next question. Overruled.
What do you mean by that, sir?
The perimeter was secured with crime scene tape, and there were officers that were standing at the location where the vehicle was.
Would it have been possible for a member of the public or any curious person to just walk up and touch the vehicle or do anything to the vehicle?
Objection. Speculative.
Based upon his training and experience, he may answer. Overruled.
They would have been stopped by law enforcement.
Thank you, that's all I have.
All right, thank you, sir. You may step down. While he's stepping down, if my jurors and anyone else in the courtroom want to stand, I do want to get through one more witness tonight.
And then the exhibits that Mr. Johnson has, Your Honor, what would you like done with those?
I'll take them.
All right,
I have 90 and 87.
yes.
What was 87?
87 is a hat.
I'm not sure if I did move that, but I would move that into evidence, so we will need that item for the next witness, please.
Okay, I'll put that back.
Thank you.
Objection to that. That
Noted.
before
it's-
you showed me that, I didn't even see what that was. If you would have
I'll
never
show it to
told,
you again.
I know, but if you never would have told me, I never would have even know what that was, because I didn't see it till you just moved it.
The witness had it up on the stand, but here it is. It's exhibit, marked as exhibit 87. Go ahead and say, state has moved it into evidence. I believe there's an objection. It's
Yes,
noted,
there is an objection.
Overruled based upon the testimony of the prior witness. It is received. And who do we have coming up to the stand?
Your Honor, the state next calls Trevor Naled, and for the record, he was handed a copy of Exhibit 91 on his way to the witness stand.
All right. Thank you. Sir, could you please stand and raise your right hand? My clerk, Teresa, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Be seated. And just for the record, what is 91? I know you're going to get to it, but
91 is Mr. Naled's report, Your Honor.
all right. Thank you. Then, all right. Good. I guess evening, sir. The first thing I will have you do is to state your first and last names for the record, and then spell each, please.
Sure. My name is Trevor Naled, Trevor Naleid.
Thank you. Go ahead.
Thank you, and I'm sorry for mispronouncing your name. Sir, where do you work?
I am employed by the Wisconsin Department of Justice at the State Crime Laboratory in Madison.
And what is your position there?
I'm a senior forensic scientist in the DNA analysis unit.
How long have you worked there?
11 and a half years.
Could you please describe the work you do there?
Sure. I examine evidence for the presence of biological fluids such as blood, semen, and saliva, and then attempt to extract the DNA from those items. From there, I will make comparisons to standards from known individuals in the case.
And what's your educational background, please?
I have a bachelor's degree from the University of Wisconsin-La Crosse in biochemistry and a master's degree from the University of Florida in forensic DNA and serology.
Do you have any training specific for your position at the Wisconsin State Crime Lab?
I do, yes.
Please describe that for the jury.
I underwent approximately a 1-year-long internal training program that included the screening techniques we use, presumptive and confirmatory tests for blood, semen, and saliva. Excuse me. From there, I learned the extraction techniques, quantitation, amplification, and typing methods that our lab uses. From there, I learned data interpretation as well as statistical analysis.
Did you do any casework while you were in training?
Mock cases.
Okay.
I completed two competency tests, 2 mock cases, a mock court, and then after completing those, I completed an extensive written exam as well as statistical tests.
Did you actually work with DNA samples, processing and analyze DNA samples during your training?
I did, yes.
About how many times?
About 175 samples.
Is the Wisconsin State Crime Lab accredited?
Yes, it is.
What does that mean?
Our lab's accredited under the ISO 17025-2017. Essentially, it's just a voluntary program that any lab can enter to show that it meets established standards. They control our proficiency testing that's done twice a year.
Do you personally have any certification or accreditation personally?
No, just the lab accreditation.
Just the lab, okay. How many forensic DNA cases have you worked?
Just over 500.
And about how many DNA samples have you processed?
Over 2,000.
Overruled, the witness may answer. I'm sorry, will you repeat your answer?
Over 2,000.
Have you previously testified in court before?
Objection, relevancy.
Overruled, the witness may answer. As a reminder, there may be objections. Please wait until I rule on those objections until you answer. Go ahead, you may answer.
Thank you. I'd like to ask you a little bit further about DNA analysis and how that works, okay?
Sure.
What is DNA? We hear a lot about it. What is it?
DNA stands for deoxyribonucleic acid. It's essentially the genetic blueprint that makes us what we are. It codes for us to have 2 legs, 2 arms, hair color, eye color, etc.
And where's DNA found in the human body?
Objection, leading.
Overruled, foundational, the witness may answer.
DNA is found in the nucleus of a cell.
Is it the same in every cell throughout the body?
In every cell that has a nucleus, yes, such as white blood cells and skin cells.
And is that important in your analysis?
Objection, leading.
Overruled, foundational, you may answer.
Yes, it is.
Why?
Objection, leading.
Overruled, go ahead.
It's important because we can take samples, evidentiary samples that may be from blood or saliva, and compare them with known standards, which are typically buccal swabs, which are swabs from the inside of the cheek, or dried blood standards in the case.
Does each individual have unique DNA?
Everybody except identical twins is unique.
Okay. Are you familiar with something known as STR analysis?
Objection, leading.
Overruled, foundational, the witness may answer.
Yes, I am.
What is STR analysis, please?
STR stands for short tandem repeat analysis. Over 99% of DNA is the same from person to person. So we're looking at that 1% that varies from individual to individual. Short tandem repeats are very small sequences of DNA that repeat over and over. So at one location, I may have 12 of these repeats, where another individual may have 14.
Is that distinction important?
Yes.
Why?
We can type standards from anybody associated with the case and make comparisons from the evidentiary profile to the standards to either include or exclude individuals.
All right. I'd like to direct your attention to Exhibit 91. Do you have that item in front of you, sir?
Yes, I do.
What is 91, please?
91 is my confidential report of laboratory findings dated April 29th, 2022.
And do you know if it relates to events occurring in the city of Waukesha on November 21 of 21?
Objection leading.
Overruled, foundational, the witness may answer.
Yes, it does.
Okay. Were you given some items to process for DNA analysis?
I was, yes.
Were you given DNA standards to compare any profiles that you may develop from the evidence to known individuals in the case?
Yes, I was.
Do you remember who you got standards from?
I do.
Are you able to name them, or if you need to refer to your report, you may, but just let us know.
Okay. Can I read off the report?
You may read off your report. What page are you reading from, sir?
I will be reading page 2.
Okay. Go ahead.
Objection.
Overruled, the witness may do so.
I received buccal swabs, so cheek swabs from Erica Patterson as well as Darrell Brooks. I received dried blood standards from Wilhelm Hospital, Tamara Durand, Jane Kulick, Leanna Owen, Virginia Sorensen, and Jackson Sparks.
Is there a difference between those two, the method in which they were submitted, the buccal swab versus the dried blood standard?
Objection leading.
Overruled, foundational, the witness may answer.
Yes,
Are you able to do the same thing with them?
I am, yes.
And what is that?
Just extracting the DNA off them to essentially put a profile to the individual.
Okay. And how do you use those profiles that you develop from the known standards?
We compare them to the evidentiary profiles that we develop.
All right. Now, you processed many items related to this case. Is that correct, sir?
Objection leading.
Overruled, foundational, the witness may answer.
Yes, I did.
I'm going to direct your attention to just a few select items for my purposes, okay? On page 7 of your report, Exhibit 91, you have reported on analysis you were able to perform on some swabs from the steering wheel of the vehicle in question. Is that correct, sir?
That's correct.
And the swabs were obtained by another member of the crime lab, is that right?
Objection speculative.
Overruled, the witness may answer.
That's correct.
How do they get to you?
They were collected by analyst Chris, our chief now, Chris Johnson in Milwaukee, and they were mailed over to the Madison lab.
Okay. Were you able to develop any DNA profiles from the swabs of the steering wheel in this case?
Yes, I was.
What were your findings?
It was a 2-person mixture with at least 1 male.
Can you explain for the jury what that means, please?
We can look at a profile, and based on how many peaks there are at different locations, each person will have a maximum of 2. So if you have 3 peaks at a location, you know that you have more than 1 person there. And so in this case, we were able to say that it was a 2-person mixture.
Were you able to identify who those 2 people would be?
Objection speculative.
Overruled, the witness may answer based upon training, experience, and investigation and analysis in this case.
Yes.
How did you do that, sir?
I ran it through this program called StarMix.
Is that a computer program?
Yes, it is.
What is that, please?
Objection leading.
Overruled, the witness may answer.
StarMix is a mixture deconvolution software that we use. Previously, it was pretty difficult to distinguish different contributors in mixtures, and now we have this software that's actually a 2-part program to do that.
How does it work?
Objection leading.
Overruled, you may answer, sir.
The first part takes inputs by the analyst, such as number of contributors. So we'll look at the profile and determine that. But it also looks at the total amount of DNA amplified and essentially makes its own profile for comparison purposes. It will then compare it to the actual profile and determine if it's a good enough match. It will then generate another completely random profile, and if it's better and a better match, it will accept it. If it's not, it will deny it, and it will keep doing the accept over and over hundreds of thousands of times until it has a profile that is a very, very good match to the theoretical profile.
Safe to say a human being will be very challenged to do the same analysis.
It would take a very long time, yes.
Okay. And the software that you use, the STAR Mix or STR Mix, is that used in other labs around the country, sir?
Objection speculative. I don't know it's used around the country.
Overruled, the witness may answer.
Yes, it is.
Is it a reliable method of performing DNA analysis, in your opinion, sir?
Yes, it is.
Has it been accepted in courts and other cases?
Objection speculative.
Overruled, the witness may answer.
Yes, it has.
More than once?
Objection leading.
Overruled, you may answer.
Yes.
Do you know about how many times STAR Mix has been used in Wisconsin courts?
Objection speculative.
Overruled, the witness may answer.
Since we brought it online in January of 2020, it's been accepted over 100 times in the state of Wisconsin.
Did you have to receive some specific training in how to utilize this software?
Yes, I did.
And did you complete the courses?
Yes, I did.
Okay. Did you use STAR Mix to analyze the DNA profile, this two-person mixture from the steering wheel of the Ford Escape?
Objection leading.
Overruled, foundational, the witness may answer.
Yes, I did.
What conclusion did you draw?
Based on it being a two-person mixture, Erica Patterson and Darrell Brooks are both very strong support for inclusion. They're both greater, or it's at least 1 quadrillion times more likely to observe the DNA profile if it's a mixture resulting from them plus an unknown over 2 unknowns.
So the odds of it being Mr. Brooks' DNA versus some other random person in the world are very, very rare, correct?
Objection leading, and I don't consent to being called that name.
The objection is noted. I'll sustain the objection as to the form of the question. Just ask that you rephrase.
Can you explain for us what you mean by very strong support for inclusion?
Yeah, we have a verbal qualifier based off of the validation that the company, the StarMix creators, as well as an internal validation have come up with. And the highest number we'll report is greater than 1 quadrillion. So this is higher than the number we're reporting greater than 1 quadrillion, but the number is actually higher than that.
Okay. I'd like to move on then to the gear shift. Did you receive swabs from the gear shift of the red SUV?
Yes, I did.
Were you able to develop a DNA profile from the swab from the gear shift?
Yes, I was.
What did you find?
That was a 3-person mixture, also with at least 1 male.
I'm sorry, you trailed off at the end. A 3-person mixture, what?
With at least 1 male contributor.
Okay. Were you able to do any further analysis on that DNA profile?
I ran that through StarMix as well.
And what conclusion did you reach?
Objection leading.
Overruled, the witness may answer.
The same as the steering wheel. So Erica Patterson and Darrell Brooks are both very strong support for inclusion.
Meaning that their DNA is on that gear shift.
Objection leading.
Sustained as to the form of the question. Please rephrase.
Please, again, state in layman's terms for the jury what that means, sir.
Both Erica Patterson and Darrell Brooks, there's at least 1 quadrillion times more likely that it's the mixture, it's at least 1 quadrillion times more likely to observe the DNA profile if it's a mixture from H1, meaning the person of interest, and 2 unknowns versus 3 unknowns.
The person of interest being Darrell Brooks?
Objection, I don't consent to being called that name and just leading the witness.
Overruled. Noted, but overruled. You may answer.
We run StarMix for the profile itself, and then each individual standard is run. So each person will have its own individual stat. So in this case, both Erica and Darrell are greater than 1 times 10 to the 15th, which is our 1 quadrillion.
All right, thank you. Sir, up on the table to your left, there's an item in a bag that's been marked as exhibit number 87. Do you see that? Yes, could you pull that down and take a look at that for me, please? Do you recognize exhibit number 87?
I do, yes.
And is that an item that you worked on?
Yes, it is.
Were you able to develop a DNA profile from exhibit 87?
Yes, I was.
What did you find?
That was a 2-person mixture with at least 1 male contributor.
And were you able to analyze that further using StarMix?
I was.
What conclusions did you reach?
Erica Patterson has very strong support for exclusion. Darrell Brooks has strong support for exclusion. Wilhelm Hospital has very strong support for inclusion. He is above that 1 quadrillion threshold that we have.
Okay. And last, I'm not sure, Madam Clerk, if you still have the exhibit handy. If not, we can just talk about it. I'm looking for the sweatshirt that was item number 84, exhibit
It's still
84.
here.
It is?
Hold on.
Okay. Judge, would you please hand that to the witness?
Yes, the record reflects I'm handing exhibit number 84 to the witness. Go ahead.
Thank you.
What was the other exhibit number? That?
The hat is 87 and the sweatshirt is 84.
Sir, do you recognize item number 84, or exhibit number 84, I should say?
I do.
Is that an item that you processed?
Yes, it is.
Were you able to develop a DNA profile from exhibit 84?
Yes, I was.
What did you find?
I first looked at this. Typically, we'll swab, if we're trying to find the wear of an item, areas that skin contacts. So on shirts, a lot of times we'll swab the back of the neck area or the cufflinks. So I swabbed both of those. There was a reddish brown stain on the right sleeve that tested presumptive positive for blood. So I took that, a cutting of that. And then there were 5 hairs. There were more than 5 hairs, but I took 5 hairs that looked like they had roots on them for extraction.
Okay. And were you able to develop any DNA profiles from any of those swabbings or hairs?
Yes, I was.
Which? Let's start with swabs.
Okay. The swabbing of the collar of the sweatshirt was a 3-person mixture with at least 1 male.
How about the cuffs of the sweatshirt?
The cuffs were also a 3-person mixture with 1 male.
And how about the stain on the right cuff?
That was a 2-person mixture with at least 1 male.
Okay. Going back to the collar, the swab of the collar, did you use StarMix software to rule in or out the possibility of Mr. Brooks being included in that profile?
Objection, I don't consent to being called that name and just leading the witness.
Noted, overruled, the witness may answer.
Yes, I did.
What was your finding?
Mr. Brooks has very strong support for inclusion. He's above that 1 quadrillion threshold.
Okay. How about the cuffs on the sweatshirt? What was your finding and ultimate conclusion as to Mr. Brooks' likelihood of DNA in that mix?
Objection, I don't consent to being called that name, leading the witness.
Noted, overruled, the witness may answer.
that three-person mixture with at least one male. The same thing. Darrell Brooks was very strong support for inclusion, greater than 1 quadrillion times.
And the last item you said was a stain on the right cuff of the sweatshirt?
Correct.
Did you reach any ultimate conclusion as it relates to that item?
That was a two-person mixture with at least one male contributor.
And what was your conclusion?
Both Erica Patterson and Darrell Brooks are very strong support for inclusion.
You said that substance was a presumptive positive for blood?
Correct.
Objection leading.
Overruled. The witness may answer.
That's correct.
All right, thank you, sir. I don't have any other questions at this time, but I would move Exhibit 91 into evidence, his report, Your Honor.
Thank you. I'll take Exhibit 91 is received. Any reason to keep the exhibits to the witness?
Can I see that last exhibit? I'm thinking
91?
The
Or the
87
sweatshirt?
with the sweatshirt.
You want me to hold it up or?
Yeah. Is that 87?
That is 84.
84?
This cat that I'm holding up is 87. And then he has 91, which is his report. I'll keep that in front of him for now, or he can keep that in front of him for now. Go ahead when you're ready.
These DNA analysis with star mix. I'm a little curious to get clarification on what does it mean when you say mixture? What exactly does that mean?
A mixture just means that it is more than one person present in the profile.
So by it being more than one person present in the profile, would it be fair to say that that would constitute it being more than one person?
Yes.
The gear shift had a three-person mixture, so would that apply to the gear shift the same, that it would likelihood that it's three different people's DNA on the gear shift?
That's correct.
And for the steering wheel, a two-person mixture, so that would be two people for DNA for the steering wheel?
Correct.
Do you recall when you did this DNA analyzation rather? I'm sorry.
On any specific item or all of them?
Do you recall when you did all the items, I guess?
So most of the items were collected in November. They were not transferred to the Madison lab until the end of January. So I started, I believe January 31st was the first day that I started analysis. And then my report was written April 29th.
So you started the analysis at the end of January?
Correct.
And you did your report in April? Why so long?
I generated 583 pages and my report's 15 pages long, so that takes a little bit of time.
So you broke down the 583 pages into 15.
Correct.
To the best of your knowledge, do you know why it took from November to January for you to actually get the items that you were going to analyze for DNA?
Other than me picking up the case then, not really, no, I don't know.
Do you know where the items were kept prior to you receiving them?
Yes.
Can you state for the jury and for the record?
Our evidence technicians, when they came to the Madison lab, put them into storage where all evidence is stored.
Were the items sealed like they are now?
Yes.
And so I'm assuming you had to unseal them, get them out of the sealing packages to do the analyzation. Would that be fair to say?
That's correct, yes.
And did you yourself alone do the analyzation, or did you have other people that you worked with?
I did all of the DNA myself.
Did you repackage the items after you were done yourself?
Yes, I did.
And did you return them back to where you had received them from, or did you keep them at your, I think you said the Madison lab?
I'm based out of the Madison lab, yes. Typically, when we're done with evidence, we will return them to our evidence technicians, who will then put them back into storage. When the case is done, the evidence is then returned to the submitting agency.
So the items are still at your lab, is from your knowledge?
Now?
Yeah.
No.
Well, I asked that, let me give you some clarity. I asked that because you said at the completion of the case, they would be returned to the agency that you received them from. So I was kind of trying to get clarity on that. So do you know if they were returned to the agency you received them from already?
I believe they were.
So it'd be fair to say in this situation, the items weren't continued to be stored at the Madison lab.
That's correct.
A lot of these DNA analysis, I noticed that specifically the DNA was analyzed for 8 people. Would that be fair to say?
Sounds right, yes.
And specifically referring to the analysis that had 3-person mixtures and things of that nature, what happens to the 3rd-person mixture that is excluded? Is it any way?
The question.
Oh, I'm sorry.
I'm sorry, I don't understand the question.
Well, I guess I'm referring to when someone is excluded, which I interpret as ruled out, there's still that mystery 3rd mixture. Can that 3rd mixture be identified in some way, or how does that work?
I'm sorry. Yes, we would need a standard submitted from another person who they believe could possibly be the source of that DNA.
So would it be fair to say for the analysis that you did that had 3-person mixtures, there's still a DNA that you found that's unknown?
That's correct.
And can you explain what is CODIS? Is that pronounced right? CODIS or Kodak?
Yes, it is.
Can you explain what CODIS
Sure.
is?
CODIS stands for the Combined DNA Index System, and it is a database of known individuals.
And when you find that a DNA, I'm guessing, I don't know if the right word to use would be sample, or I don't know if that's correct. When you come to the conclusion that a DNA sample is not eligible for entry into CODIS, what exactly does that mean?
There are certain rules that we must abide by for putting profiles into CODIS. Depending on where it's collected from, pretty much determines the eligibility on whether or not we can put it in.
One of your analysis had a 4-person mixture. Were you able to determine out of the 8 DNAs that you ran if any of those DNAs were found on that specific item?
Your Honor, I object that it's vague. I'm not sure which item he's referring to.
I'm referring to, it says brim of maroon winter style hat.
What page are you on, please, sir?
6.
All right, so you want directing the witness to page 6?
Yes.
That particular item?
Yes, that's where I'm reading from, yes.
Okay, thank you. Did you ask the question?
Yeah, I said this one in particular, the one I'm referring to, has a 4-person mixture. Did your analysis identify any one of those 4 people out of the 8 DNA samples that you were analyzing?
No, it did not.
Would it be fair to say for pretty much all the items that you did analysis on, there were at minimum 2 or 3-person mixtures?
No.
And why would you say that?
Typically in our reports, we lump the star mix samples together. If you look before that, it will have items that were single source profiles.
That's why I said the majority, or if not all. I didn't say every single one.
I wouldn't say the majority, no.
Certainly looks that way. The is it autosomal? How do you say that word? I'm sorry.
Autosomal.
Autosomal STR-DNA results and conclusions. That starts on page 5. Would that be fair to say?
That's correct, yes.
And ends on page 13. Would that be fair to say?
That's correct, yes.
Would it be fair to say that page 13, 12, 11, 10, 9, 8, 7, and 6, out of all those pages, only 3 have single source, and all the rest of them have at least 2 or 3 mixtures. Would that be fair to say?
No.
And can you point out where the inaccuracy may be?
Sure.
In case I'm not being accurate?
Yeah, on page 6, the first profile that you're looking at, cuttings of the apparent hair from the gas tank strap, that's a single source profile.
That's one.
The next line, the cutting of the unlit end of the blunt is 1.
2.
Cuttings of the apparent roots from the hairs, which is CC4, CC5, and CC8. So that's 3 items right there.
So you're looking at the actual heading?
That's correct.
And is that it from?
On that page, yes.
Any other pages?
Which direction, Mr. Brooks, forward or backwards?
I don't consent to being called that name. We're going from page 6.
Are you asking single source profiles?
To page 7. From page 7, do you see any single source? Or yes, I guess it would be called single source.
No. From page 6 to 13, as you previously stated, those are my star mix ones. So each one of those is going to be a mixture profile.
So the majority of them have mixture of persons.
From those pages, yes, but there are many single source profiles before the star mix conclusions.
Do you recall who you turned your report over to once you finished your report?
For technical review.
I'm sorry, can you repeat that?
For technical review.
I'm referring to once you had finished your written report. Do you recall who you turned that over to?
Yes.
Can you state it for the jury and for the record?
Kelly Gajewski was my tech reviewer.
Can you spell that last name for the record?
It's Gajewski, Gajewski.
Thank you.
And do you know what happened to the written report from that point?
After she reviews it, sent it back for edits, and then I fixed those. It was approved by her. Then it goes to a supervisor for an administrative review.
Fix the edits? What do you mean by fix the edits?
If there's any typos or anything like that, it'll come back. Or if I forgot to initial a page or something like that, I'll fix those and then send it back to her for approval.
Working with law enforcement, which you've stated you've done numerous times. And in regards to written reports, to your knowledge, are you aware of officers taking a creative writing course?
Objection, relevance.
Sustained. That's the fourth question.
Have you yourself ever taken a creative writing course?
Objection, relevance.
Sustained. Not relevant. Next question.
Have you or anyone you know filed a complaint in this matter?
No.
Would you consider yourself an injured party in this matter?
No.
Ever directly talk to the plaintiff in this matter?
I don't know how I would talk to the state of Wisconsin.
Can you repeat that? I'm sorry.
I do not know how I would talk to the state of Wisconsin. It's an entity, not a person.
Not a person, right. No further questions?
Thank you. Any redirect?
Yes. Sir, on page 6 of your report, you were identifying for the defendant the some of the single source profiles that you developed. Do you recall that?
Yes.
And one of the items you described as items CC4A, CC5A, and CC8A. Do you see that?
Objection, leading.
Overruled. The witness may answer. Go ahead.
Yes, I do.
What do those items represent?
Objection, leading.
Overruled. The witness may answer.
Those are cuttings of the apparent root ends of the hairs that I took off the sweatshirt.
Forgot to ask you about the hairs.
Objection, leading.
Did you, I'm sorry, that was a statement. I'll move on, Your Honor.
Thank you.
You told Mr. Brooks on cross that you developed a single source profile for those hairs. Is that right?
Objection, I don't consent to being called that name, and it's leading the witness.
The objections are noted. Overruled. The witness may answer.
That's correct.
Who was the source of those hairs on that sweatshirt, State's Exhibit number 84?
Objection, speculative.
Overruled. Go ahead and answer.
Darrell Brooks is the source.
Thank you. Nothing else.
Great. Thank you, sir. You may step down. as I would love to have another witness, we're going to break for the night because it is 5:49. So, with that, I will give the instruction that I've been giving every night to the jurors. So please listen. Do not begin your deliberations and discussion of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging, or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial is completed, you are free to discuss this case and communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are excused for the evening. I'll briefly discuss scheduling with the parties and then let Michael and Jen know when to report tomorrow. Thank you. All rise for the jurors, please. We good? Oh, there's the door. Thank you, be seated. Just briefly as to scheduling tomorrow, since we had a late evening, how about we start at 9 a.m. tomorrow? Any objection from the state?
No.
From Mr. Brooks? No. All right, 9 a.m. tomorrow. For scheduling purposes, I'll take up, obviously, tomorrow morning, whether the state can recall Detective Casey. That would be your last witness. All right, then, sir, you have the option, should you choose, of an opening statement. So you should be prepared for that. And then to call witnesses, I believe you've worked with Attorney Opper, or do you need to provide her with anything regarding that tomorrow? All right, anything else from the state?
No.
Any,
I don't have anything at this time, Your Honor. If you excuse us, then I'll make sure I get that paperwork from Mr. Brooks or the defendant, and we'll be ready to go.
all right, anything else from you, sir?
Oh, yeah, we're starting at 8:30, right? Or are we starting at 9 as well?
We're starting at 9.
Okay, then Ms. Basie corrected me because we have to discuss Attorney Casey's testimony, but we also anticipate we'll have a motion in the morning, or I can tell you what it is right now, but I know the
Well,
hour's
we can
getting
then,
late.
I mean, if you think it's gonna take some time, then I'll have the jurors come at 9, but I wanna be mindful. I know, Mr. Brooks, we all had a long day. I'll do 8:45, but I'm not gonna do any earlier than that.
I
And
think
what will
that's
the
fair,
motion
Your
be?
Honor. It's a motion to conform the information to fit the evidence.
Oh, all right, I'll take
What
that
is
up.
that?
We'll have it in writing for Mr. Brooks in the morning, Your Honor.
Okay, that'll be great. All right. Anything else from you, sir?
No, I redid the, it's not the exact order that I'm gonna call the witnesses, but it's pretty much
Who you want, like each time block, morning or afternoon?
exactly.
You'll be ready to
It's
go
just
tomorrow?
not exact order like I'm gonna call this person,
I'm
this
not gonna hold you to
person.
that, as long
Yeah.
as it's by time blocks, if you wanna call it that, but be ready to
Well,
call
I did
witnesses.
it just so I can state for the record, so it'd be easy to follow. I did the names by threes. I'm guessing the first 3 would be the morning, the next 3 would be the evening, and then Friday, 3 morning, and then 3 evening. Is that fair?
I think so.
Yes, we may be able to move faster, but we will attempt to stay in contact with witnesses if we can, bring somebody here sooner. If the court's got time, we'll do that, but that's very reasonable.
And then do you have any idea how long you anticipate your opening will be?
Opening statement?
Yes.
I don't think it's any way to gauge how long it will be.
Just be mindful, sir, it's not the time to make argument, opening statements, as I like to call them, and what the jury instruction references, it's the roadmap. So I will expect to hear a lot of the evidence will show, the testimony, things of that nature. If it turns into argument, that's what happens at the close of the case.
What do you mean by argument?
If you're trying to argue the evidence and what it means.
No, I'm not trying to argue.
But this will be what, basically to lay out what the defense, what I would expect is for you to lay out what the defense or defenses that you believe you'll be presenting evidence about will be, to kind of, again, give the jury a roadmap, an idea of what to expect as your witnesses come forward. And then at some point, I don't know whether you will make a decision to testify or not, but we do have to have a conversation on the record about that. So if you could just give me an idea, if you are going to testify yourself, if you think that would be at the beginning or at the end, so I can gauge when to have that conversation with you.
I don't know for sure yet at this point.
Fair enough. So at some point, I'll have that conversation with you, though. All right, we'll see everyone at 8:45 tomorrow. Thank you, everyone. They're in recess.
Oh, yeah, I'm sorry.